Test admission item number 1.
Well, item 1 actually, this matter actually the dispute demands are the resolution plan approval date, that is 1/6/2009. So both the heads, if you are to annex 1 series, that relates to prior to the acceptance, because the Bhushan Energy actually they undertook that corporate insolvency resolution process, and there actually, if you kindly appreciate, they raised the demand as per the public notice. Their demand was considered, and the money has been remitted in their favor, whatever due actually that was admissible to them. Now, the differential amount they are claiming for that period itself. Therefore, your lordship knows that Ghanshyam Mishra's case and the series of other cases, I've given the bunch of judgments with your lordship. Your lordship has also delivered 3-4 judgments here on the head. But that covers the entire thing, if your lordship looks at, because the Annexure 1 series itself
No, we're trying to see why this is before this bench. This should not be before this bench, I think. It has to be before some other bench. This is electricity dues. Electricity dues.
No, Manoj, this is really IBC issue, which your lordships have dealt with in several matters.
No. I may have dealt. This is not a part-third matter or a.
No, I'm not saying your lordship. It's a IBC.
Similar type of case
just
lordship has dealt with and passed
earlier in the earlier bench.
Yes,
But now that the roster has changed, I'm wondering whether
Yes.
I should still deal with this. That's all.
Lord, there's something for I'm in the other matters, so your lordship will just hear me after your lordship's here.
All right.
Both are same.
What is the position? IBC matters also for which? bench? What are you saying?
Lord, I'm appearing in item 2. Without opening the paper, let me just put the landscape. Lord, the IBCs had many Agni Parikshas and come out successfully, i.e., the whole intent and object of the IBC, my lord, was to have successful resolution. And when there's a successful regulation, brackets open, when the Agni Pariksha is over, the successful resolution applicant, my lord, gets the company on a clean slate because it's a going concern and to keep entrepreneurship. The provision of the IBC expressly says that when a resolution plan is approved, it is binding on all stakeholders. Number 3, from the SR Steel judgment of 3 honorable judges to Ghanshyam Mishra, also, my lord, of the Supreme Court, all of them have said all pre-CRP claims stand extinguished. 4th, my lord, as your lordship knows, the IBC uses the expression called operational creditors. So all government authorities, etc., fall under this genre, if I'm using the word, called operational creditors. And therefore, my lord, every claim made by an operational creditor dealt with under the plan and approved in terms of the Supreme Court judgment, my lord, there's a complete finality. Your lordships in Shree Metallics and Ferroalloys also applied the same judgment.
Correct.
But why now it's very important what I was. But if this kind of practice,
No. So I'm just wondering. I'm on that very first question. Merely because you've delivered judgments in all those matters, do these matters come before this bench?
Perhaps that is the reason for which.
No, so all other benches will not follow our orders. Only we should follow our orders.
No. I don't know how it is listed.
I want to know why it is placed and how it's placed. That's all. What was this? There's an early reference in that 13.3 notice to both of you.
yes, ma'am.
There's a notice to some Confederation of Captive Power Plants.
What happened was this: in 2017, this association had filed a writ petition. It's of 2017 vintage. That got withdrawn recently. This has nothing to do with the IBC issue. My lord, I'm making one appeal. It's for your lordship's entire prerogative to decide. But my lord, this has complete business uncertainty because projects which are running well, if the past of some other person is to catch up, it destroys and is anathema to the IBC, which is why, my lords, it has been consistently settled. It cannot be unsettled. Today we face a potential, my lord.
No,
today is like a D-Day. So I'm only appealing to my lords in line with a series of
letter
orders.
doesn't spell out a consequence of non-deposit.
Your lordship knows the consequence of non-deposit is either recovery through law and order or the connection goes, all dealt with, covered under multiple cases and 6 orders passed by this court in various benches. I'm only making one appeal. Your lordship may consider today only saying no coercive steps and a stay. Have it before any appropriate bench on any day, as my lord deems fit. But my lord, this kind of law cannot be unsettled consistently by authorities.
No, so in one case it's 136 crores, the other case it's 194 crores.
Yes.
Yes. So my lord, these are nice mythical figures.
And
It looks
let
good.
me remind your lordship,
Just let me
in
just
those
complete.
cases where your lordship has
Can I just
granted
complete,
stay,
my lord? My
they
lord,
were
can I just
directed to deposit 50%.
My lord, can I just complete if my learned friend doesn't? My lord, it's like giving shock treatment on a regular basis. After the Supreme Court has consistently laid down the law, my lord, it is today, 28th March, D-Day has been given. So
No, I know, but none of both these letters don't say like the usual thing. If you don't pay by 5 p.m.
now, my lord,
Power cut.
my lord, with great respect and humility, it's an inbuilt consequence your lordship knows. So one says a D-Day, and my lord, I'm saying with all sense of responsibility, statute, judgment, principle, intent, object, consistently followed by this court and other courts. After that, my lord, and I also say on 5th of April, I myself appear, Supreme Court has issued contempt notice in a matter, exactly same situation, because you cannot have it. Ghanshyam Mishra declares the law. It's not just a case. It declares the law. My lord, in the teeth of this, to have this consistently happening is absolutely disruptive and against principles of legal certainty, gross violation of a judgment of the court. And your lordships have also, in the case of this very petitioner, he's also gone through trial by fire for multiple departments. So I'm appealing to my lords, my lord, your lordship may, in the light of those judgments, protect us and then hear us on any convenient day after.
Sorry?
My lord, so far as the merit of the case, we have to file a counter affidavit because I have to get instruction. For the first time, it is listed. So far as the interim prayer is concerned, not to take any coercive action, I pray your lordship that there are huge demand of the state government.
No, demand being huge is one thing, sir. How do you justify it in light of Ghanshyam Mishra as a question?
That I will take instruction and file. But so far as the
No, if you say we will stay our hands till you take instructions, that's fine. If you say no, Ghanshyam Mishra does not apply here.
The shortest possible day, your lordship can feast.
No, then you make a statement that you won't take coercive action.
In that event, your lordship can direct them to deposit certain amount because in all other cases, your lordship is passing order 50% deposit, 30% deposit. In such a huge amount, they will get an interim order without any deposit.
There are issues where calculation is in dispute, not liability. Here, liability itself is disputed.
Right.
No. Here, liability is in dispute according to them. But I think that the counter affidavit will be filed. That will also be in a manner which why the authority has charged this amount will justify it.
No. For interim relief, then you'll have to file something immediately.
Yes, we'll
filing counter in the main matter is one thing. Filing the interim application is another.
In both the matters, we'll file. Within 10 days, we'll file.
Then if you file, then till then stay your hands. Till then stay your hands. You see, just the names will differ. Mr. S.P. Mishra, senior advocate, Mr. Gopal Jain, senior advocate. Point out that the impugned demand raised by the electrical inspector Anubul by the impugned letters dated 8th December 2022 and 13th March 2023 of purported outstanding electricity dues for the financial year 2021-22 ending on 31st March 2022 are unsustainable in law in view of the clear legal position explained by the Supreme Court in where's that citation? Ghanshyam Mishra versus
Annexure 1 series in the first one.
versus Edelweiss Asset Reconstruction Company Limited. So let's have a regular citation of 2021 SEC Online, SC 313, and which has been followed by this court in several decisions, including Messrs. Shree Metallics versus State of Orissa. Bracket order dated 21st June 2021 in writ petition civil 8259 of 2019. And the judgment dated 10th December 2021 in writ petition civil 20286 of 2020 bracket Ferro Alloys Corporation Limited versus State of Orissa. Paragraph, it seemed that the demand raised is a very substantial sum of approximately, in the first matter, that is 9313, see, rupees 137 crores. The other, rupees 194 crores. Paragraph.
And another demand is also there in respect of the differential amount. That is also around 10 crores. In both cases.
Yeah, it's okay.
That relates to the same previous period.
Maybe.
There's an additional demand of a differential sum, again relating to period prior to 31st March 2022.
Yes.
Stop. In short, the submission is that once a resolution plan has been approved in proceedings initiated under the Insolvency and Bankruptcy Code, bracket IBC, which has been approved by the National Company Law Tribunal and further in appeal by the National Company Law Appellate Tribunal, all liabilities for a prior period would stand extinguished and would be governed only by the resolution plan. Paragraph. You say notice, he accepts notice and states that he would like to file a reply not only to the main petition but also to the application for interim relief. Full stop. He undertakes to do it within 10 days from today.
Only 15 days.
Within 15 days from today. The list on 17th April. Till then, no coercive steps shall be taken against the petitioners pursuant to the impugned demands.
Deeply grateful. But can be one day later, just after. A few days later.
18th April. All right.
Which day?
18th April.
Which day?
It's Tuesday.
Tuesday.
18th.
Can it be like Thursday or Friday? Just in
Sorry?
that week, not 17th, 18th, I have some difficulty. Thursday that week or Friday. Whatever is convenient to the court, just 2 days later.
All right, 20th. 20th.
So deeply grateful. Extremely grateful.
Item number 3.
Could we have the order Dasti? Order Dasti. Yeah. So deeply grateful.
My lord, this is a PIA regarding construction of multi-purpose flood shelter in village Biroli under Bhandari Pokari block. The mischief was played by the BDO, my lord. The site was selection in the UGM school of Biroli. It is situated in the ward number 20, which is completely inhabited by the scheduled caste persons, my lord. In the UGM school, that construction was sanctioned and the site was selected and it was approved. Without constructing the same, my lord, within the school premises, because it can be used for the classroom and also for the flood shelter during the flood, high flood. The BDO shifted that without approval of the higher authority to another place, my lord. In ward number 18, this village consists of 5 wards. Now that was challenged before your law. That has been challenged before losses, my lord. They say in previous writ petition, earlier one writ petition was filed by the Sarpanch, and there this honor court has directed that the collector shall take a decision in the matter, and collector has taken a decision at page 43, my lord. 43 second paragraph. In view of the facts and circumstances narrated above, it may not be rational on my part to pass any adverse order against ongoing construction of flood shelter at this belated stage. The BDO of Bhadrak district are seriously warned not to commit such type of mistake in future. In the result, this case is disposed of and direction of the Honorable High Court is accordingly complied with. My lord, I disputed this fact. You will also direct the State Council to take the instruction. What is the stage of construction, my lord?
My lord, so far as this order is concerned, which my learned friend has placed, he has not placed the subsequent event. This order of the collector was again challenged by the Sarpanch in the Honorable High Court before the Honorable Single Bench, and that was dismissed.
For
the order of the collector was
non-prosecution.
Maybe non-prosecution, but it was never restored. So that order was confirmed, wherein the collector held that this new place is the suitable
My
place.
lord, I am not challenging the order of the collector.
What has happened today?
Your Sarpanch, you are a ward member, his Sarpanch has challenged. Again,
Sarpanch
second
is another
round of litigation.
No, this has been pending for the last 6 years.
6 years, man.
What has happened in the 6
What
years?
is the
Current
stage?
status, that is also just in the morning I was going through the
How did you
file.
find out? You
Yes,
say the
ma'am.
repetition
Let
has
them
been
find
pending.
out, my lord, what
This
is the
repetition questioning the shifting of the construction of a multi-purpose food shelter,
flood shelter, my lord.
flat shelter to Biroli village.
Biroli.
Ha.
Biroli. BIROLI. Biroli.
Has been pending for over 6 years now. There has been no interim order restraining the construction of the flood shelter. Counsel for the London AGA states that he will seek instructions on the current status.
From the BDO of Bhandari Pokhari.
Not from, my lord, from collector, my lord.
No, BDO. Not
BDO is
collector.
the-
BDO is the authority.
Please,
He is on the spot. He will file the
BDO has
Okay, we'll
done
see
all
who
the
will file the
mistake, my
matter.
lord.
That video is no more in the seat.
I don't know.
Now,
I
First
don't
May.
know. Videos are continuing for 5
First
to 6 years. My lord,
1st May.
last.
Item
In the
number
month
4,
of April, you also. Yes, it. Month of April, my lord.
past May, sir.
past May.
Item number 4,
My lord, that old pension, I've given the one.
Sure.
25th April. All right.
item number 5,
Vouchers regulation, I've given. 49.
item number 6,
Your Lordship, I'm impugning order dated 27/7/22 by WPC number 18313, passed by Honorable Single Judge of this Honorable Court, wherein my application, writ application for a proceeding to initiate a proceeding under Section 83 of the Registration Act has been dismissed. It is a lease penance sale case. Suit is instituted before the Civil Judge Senior Division Bhubaneswar, and status quo order has been in force. That is why Annexure P1 I have filed the status quo order.
How is this writ appeal maintainable?
My lord, what is the allegation that during the operation of an status quo order, the person concerned has executed the sale?
So that,
So it is a violation of the civil court's order.
Order 39(2)(a), I think.
Yes, order 39, rule 2A.
Yeah, so
That is the provision.
correct.
And apart from that, there are a lot of decisions. Honorable Supreme Court decision is also there. If such a sale deed will come, sale deed will not be invalid. The
Correct.
person will be penalized
Correct.
who has violated the court's order. So how the writ court can entertain such a prayer?
But during pendency of the writ appeal, they have dismissed the suit now. During
nothing, even this is infractuous, that's.
Then you won the, if
They
the
have-
suit is
they-
dismissed.
Yeah, then all
because
the interim orders.
they imposed Lord Civil Judge imposed cost of ₹7,000, and during pendency of the case.
Oh.
Thereafter, I have filed the challenge that cost order here.
All right. This writ
Due to
appeal is not-
non-payment of cost, they have dismissed the suit.
All right. This writ appeal is not maintainable, sir.
So I am seeking because I have no other option, Your Lordship. I cannot initiate my own private complaint under Section 83 of Registration Act, Your Lordship. It is only a writ application and it is only through IGR of Orissa it can be executed.
Nothing. You can file a suit. You can file a suit for declaring the seal deed to be void.
And now already suit has been dismissed.
Your suit has not been dismissed, sir. Their suit has been dismissed. You have not filed anything.
Allow me time. I will file that dismissal order and
It appears that during the pendency of the present writ appeal, the suit from which the order impugned the writ petition was passed by the civil court has itself been dismissed. Full stop. The prayer in the writ petition was for a direction to the Inspector General of Registration, Odisha, to initiate criminal proceedings under Section 83 of the Indian Registration Act against the defendant in the suit on the ground that a status quo order passed in the suit was violated and sale deeds were registered. Full stop. Apart from the fact that the as noted by the single judge, it appears that during the subsistence of the status quo order, the defendants executed 11 sale deeds. But upon an application made by the plaintiff appellant, the registration of the sale deeds was blocked by an order dated 11th April 2022. Full stop. The learned single judge has observed that while the plaintiff public appellant is entitled, if so advised, to take recourse to law for initiation of proceedings under Section 83 of the Act, filing a writ petition for that purpose was not the appropriate remedy. Directly. With the suit itself having now been dismissed, the court fails to see how any cause of action for registration of any criminal case against the defendant survives. Stop. The court sees no error having been committed by the single judge in the appealed order. The writ appeal is accordingly dismissed.
Item number 7.
On the last occasion, we had submitted that this is covered by Narottam Ratha's judgment.
Yes,
State wanted to take instructions.
Yes, my lord. My lord, may kindly permit me to speak.
Let me just, before that, let me just show, my lords, what has happened. If my lord would see the list of dates, page number D, 1974 lease was granted. Now, important dates here would be 1998. Suo motu revision case number 873 of 1998 was initiated by the ADM against the vendor of the appellant, namely so-and-so. 11/8/1998, ADM Bhubaneswar passed an order and cancelled the settlement lease granted in favor of the original lessee. Thereafter, my lord may kindly see, challenging that writ petition was filed. 29/3, writ petition was disposed of, directing for fresh consideration. Next two dates, my lords, are very important. ADM passed an order in pursuance to the order passed in WPC so-and-so and held that the present appellant is an eligible and lawful lessee under WL so-and-so and lease is valid and directed to record the name in favor of the appellant. Then on 1910-2006, pursuant to the order of the ADM, Tahsildar issued Form K and the name was recorded. Thereafter, my lords, now they have again recalled this is completely without jurisdiction. If my lord would see, those orders are also on record. If my lord would see page 47, the orders were very much a part of the writ petition also. It's not that these were not the part of the writ petition, but the Honorable Single Judge, my lord, simply glosses over that and the order has been passed. This, my lords, cannot be sustained. And these are all small individuals whose entire lifetime's earnings are involved, my lords. And why I am, my lords, troubling...
Or it can go back to the single judge.
Yes, that is what I am submitting, that your lordship may see the Narottama Ratha case was dated 2nd January 2023. And this order was passed on 11th January. But what your lordship will see that this judgment was not produced before the Honorable Single Judge by the petitioner. So let him produce. If he is convinced, the Honorable Single Judge is convinced that it is covered by, because without referring that, without placing that judgment, this order was passed. So at the appellate stage, without affording the party opportunity of placing the same judgment before the Honorable Single Judge, it is, I think, it is a fit case for remitting the case back to the single judge to examine whether Narottama Ratha case is applicable to the petitioner or not.
My lords, what he says, I'll just, my lord, may kindly see page number B, similar cases which Narottama Ratha took note. These are all orders of this honorable court by single benches, division benches. Now, when these matters are now going before coordinated benches also, they are saying that no, Narottama Ratha is not applicable. Now that the assignments have changed, before the coordinate bench also, they are saying that Narottama Ratha is not applicable. And I must apprise your lordship what has happened after Narottama Ratha. They have formed a committee of 3 members to look into those cases. If they are covered, then they will grant. So ultimately, it has to go before that 3-member committee which they have constituted. So let this be, ultimately that 3-member committee will examine this. So let this be covered by Narottama Ratha. The 3-member committee will analyze whether this is there or not. And this is a case.
I have no idea what my learned senior advocate is saying. But what I submit that, since you are relying upon Narottama Ratha case, which was not placed before the Honorable Single Judge while passing the impugned order, so you must place it before the Honorable Single Judge. Then if the Honorable Single Judge will say, no, it is not applicable, then in another opportunity is having, you can come in appeal.
That's my lord.
Because
that's what our problem
should not, my responsible submission is that this Honorable Court should not interfere with the impugned judgment on the basis of a fact which was not placed before the Honorable Single Judge.
Those documents were certified copies.
If you agree it's covered, then no need to send it back.
No,
unless you say it's not covered.
Let's let him see page 47. Under page 50.
It seems to be a classic case of the ASO doing it suo moto without any reference to anyone.
Then it would have been...
That's a situation, Narottama Ratha.
Then it would have been placed before the Honorable Division Bench. It is arising...
What is your stand? I'm saying, why should it go back if you say, if you agree it is covered, there's no need for it to be sent back.
That is
committee will look into it. You have a committee in place now. In any case, the committee will look into it.
Out of the records.
No.
But committee, I don't know. He must be knowing, but I don't know whether any committee or they are examining. These are not within my knowledge. Anyway, if my learned senior advocate is saying this, let him place before this single bench.
It's a waste of time, sir. It's a waste of time.
But I cannot concede.
This is,
my lord, I
wouldn't have insisted had that ADM order not been there. That ADM order was very much a part of the writ petition. And if my lords would see page 50, my lord may see what the ADM records. Since my learned friend is objecting so much, my lord may see page 50.
I'm not objecting.
Page 51, my lords, what the ADM records, my lord may see the penultimate paragraph. In view of the facts indicated in the foregoing paras, there are justified reasons to conclude that the lessee Srimati so-and-so, wife so-and-so, was eligible to get the land on lease during 1974. Hence, lease sanctioned by Tahsildar in so-and-so case for review is dropped as purchased. Even the appellant's name is recorded. Thereafter, my lords.
Give us the judgment in Narottama Ratha.
My lords.
You have taken that to the Supreme Court, I believe.
My lord.
Narottama Ratha?
Yes.
It's been taken to the Supreme Court.
According to my instruction, not yet.
All right.
Our instruction is clear, my lords. After this, they have formed a committee to look into, which is fair enough. Let them look into this. There were a number of cases. This is squarely covered, my lords.
All right. Not reported. Oh,
And
it's
this is
reported.
pure harassment. These people will have to run from pillar to post for recording their
So
lines
the present
recorded.
appeal is directed against an order dated 11 January 2023 passed by the single judge, disposing of the appellant's writ petition civil 3497 of 2014, declining to interfere with an order dated what's the date of the ASO's order?
ASO's order, my lords, is 2014. The writ petition, it was so I'll give.
Annexure 11.
Annexure
perhaps.
11. Annexure 11 in the writ petition.
Eleven 12/2013.
My lords, 11-12. I'm great.
Order dated. No, I don't know. There are too many dates.
The date, my lords,
There's a 30th April on the right side.
my lords.
Signed 30th April, it says. ASO. So which order of the ASO should be set aside if you don't have a date?
Lords, order was under annexure 13 to the writ petition. That running page would be
Yeah, the writ petition also here.
running page 62,
That's right. See, there are 2 or 3 dates there.
my lords.
On the right hand corner, you find 30th April. On the left side corner, you find 11th December.
My lords. That is the record, that's what it shows.
Is it 30th April?
My lords. My lord, may kindly see the order. It is not clear, my lords, from the date. So even the signature date is not there.
No, it says signed, and below that it says 30th
My
April.
lords, my lord may consider it as 13th April.
All right, 30th April 2013, passed by the Assistant Settlement Officer, declining the objection case number, rejecting the objection case number 12868/2013/2000, filed by the present appellant, and directing to record hull plot number 3464 pertaining to hull khata number 2154 in Abad Jogya Anabadi khata of the government. Paragraph. The background facts are that these were sanctioned in WL case number 1734 of 1974, way back on 11/10/1974, in favor of Srimati Padi Beva of village Katagadia. In WL case number 1824 of 75, you put. The said Srimati Beva transferred AC 0.400 decimal of land Sarad 3 Kisam with a road to the appellant on 16th February 1983. Full stop. On the basis of the above transfer, the appellant's name was entered in the record of rights in 1992. Paragraph. Suo motu revision case number 873 of 1998 was initiated by the Additional District Magistrate Bhubaneswar bracket ADM against Srimati Padi Beva. And on 11th August 1998, the ADM cancelled the lease in her favor. Full stop. Thereupon, she filed writ petition civil 2952 2005 in this court, which was disposed of on 29th March 2005, directing the ADM to hear Srimati Beva again and pass a fresh order. Paragraph. Pursuant to the above order, an order was passed on 19th August 2005 by the ADM, holding that the appellant's vendor, right?
My lords.
The appellant's vendor, Srimati Beva, was an eligible and lawful lessee in WL number 1824 of 1974. Full stop. On that basis, on 19th October 2006, the Tahsildar Bhubaneswar issued Form K, recording the name of the appellant as tenant in respect of the land in question. Paragraph. During her hull settlement operation under the Orissa, what is this consolidation settlement?
Hull settlement is under the Survey and Settlement.
Survey and Settlement Act, Orissa Survey and Settlement Act. A recording was made on 22nd December 2006 by the ASO Bhubaneswar. Issuing Yadast and draft ROR in favor of the present appellant. Paragraph. As there was a discrepancy in the extent of the area purchased by the appellant, and that shown in the ROR, the appellant filed objection case number 1812868/2013/2000 before the ASO Bhubaneswar for correction of the ROR. Full stop. By the order dated 30th April 2013, the ASO rejected the said objection and directed the recording of the aforementioned plot in the single quotes Abada Jogya Anabadi unquote Khata of the government. Correct. The above order was challenged before the learned single judge by the appellant by filing writ petition civil 3497 of 2014, which was taken up for hearing on 11 January 2023. Paragraph. In the meanwhile, on 4th January 2023, a division bench of the 2nd January 2023, a division bench of this court in writ petition civil 1608 of 2014, bracket Narottam Ratha versus State of Orissa, bracket 2023 SEC Online, ORI 153, on the basis of a long line of cases settling the legal position, held that the ASOs exercising such suo motu powers under the OSS Act, overriding orders of the ADM passed under the OGLS Act, were acting without jurisdiction. Full stop. The following directions were issued in the judgment, reproduced para 22 paragraph. As far as the present case is concerned, the ADM has already passed an order in favor of the present vendor of the present appellant under the OGLS Act way back on 11th August 1998.
Even the appellant's name is also recorded, saying that the purchase is also recognized.
On 19th August 2005. Full stop. That order of the ADM attained finality. Full stop. It could not be upset subsequently by the ASO exercising suo motu powers, or by simply declaring that the land belonging to the government. So this was not within the jurisdiction of the ASO to undertake, as is explained by this court in Narottam Ratha v. State of Orissa. So paragraph accordingly, while setting aside the impugned orders of the ASO dated 30th April 2014 and of the learned single judge disposing of writ petition civil 3497 of 2014, the following directions are issued. 1. The impugned order of the ASO rejecting the objection of the appellant regarding the correct extent of land to be shown in the ROR in favor of the appellant is hereby set aside. 2. The order of the learned single judge affirming the said order is also hereby set aside. 3. The government will now accept the plea of the petitioner regarding the discrepancy in the entry in the ROR and make the necessary corrections within a period of 8 weeks from today. The writ appeal is disposed of in the above terms.
We are grateful.
It is
Item 8.
structures, delimitation matter in election, urban land.
Yeah, none is appearing anyway. You say none appears, dismissed.
Item number 9.
In this case, I have already filed the second copy of the writ petition, my lord, in court today, my lord. My lord, the grievance of the petitioner is that the opposition of 5 with the private portion of the petitioner village as encroached upon the gochal land of the petitioner village by making a boundary wall, my lord.
All right, the petitioner's representations, bracket, Annex 8, will be examined by the Tahsildar Basta, and after notice to the petitioner and opposite party number 5 and giving them a hearing, a reasoned order shall be passed not later than 1st June and communicated to the parties within a week thereafter. The court clarifies it expressed no opinion in the matter.
Item number 10.
My lord, kindly this matter come to next week, my lord. Mr. N. there has some personal difficulty, my lord. And then in the meanwhile, we will remove all defects which is pointed by the SR, my lord.
Parking space regulation.
My lord. Clause 9, 10 and 11 of parking space regulation with challenge, my lord.
Defects be removed. Let's say list on. We say at the request of counsel, the petitioner list on
As your lordship think fit, fix any date.
18th April, defects be cured in the meeting.
Oblige, my lord.
Item number 11.
None appears dismissed.
Item 12.
One week time.
Before your lordship, item 11, my lord. Item 11, I am from BC Miller. So 1 week time may be granted for a removal.
It's a 2019 matter, sir.
My lord.
Already a very old matter.
1 week time.
No, sir. It's a very old matter. Tell us what it is about.
The next one.
The single judge order has been challenged. The honorable single judge passed the order that since there one read appeal, it has been stated that there will no case will be filed. Provided that the selection process was started and the new selection process started for Sikha Sayak Miller. And for that Miller, the Sikha Sayak was the persons they applied, but the petitioners, they are the overage Miller. And for that Miller, they filed the representation before the secondary Miller. For that,
now it must be even more concession. Now even more impossible, sir. You all must have grown even older now. All due to passage of time, all this has been rendered infructuous, sir. You said due to passage of time.
Since that the case is pending, Miller, and it could not be taken up, Miller.
The issues raised in the present petition, as arising from the impugned order of the learned single judge, has been rendered infructuous. Stop. Leaving the questions of law raised open for decision in some other case. The writ appeal is disposed of.
The liberty will be given in future.
There's no need for that, sir. Right.
Item number 12.
My lord, before your also taking up this matter, my lord, there is a writ appeal, that is writ appeal number 1022 of 2022, my lord. That is, my lord, has been disposed of on the very first day following the judgment of Patita Bhavan Dattadas. So I have filed an order, my lord. Your lordship has remitted the matter back to because it is a case relating to gardener who have been appointed after following the due procedure. But without detailed discussion, that has been done. So I pray, my lord, let the matter be remitted back as per your lordship's order passed in the case. I have already filed an order and also my power in the case.
Which matter is this? Where you are
My lord, that is writ appeal number 1022. State of Orissa versus Arun Kumar Nath.
No, it's a sub item.
Yes, my lord.
Ah. We'll see what happens in the main matter, sir. Then we'll do all this.
All right. All right.
Sir.
Well, the compilation was added over last time.
Lordship, please this.
Ah.
A memo was, my learned friend gave a memo.
You want to address on that because he says there are other cases where you already implemented the orders.
No. What was now filed is that there are 69,000 vacancies.
Correct.
If my lords kindly turns to page 4 minutes.
Right.
That is the list.
Correct.
And that list says there are several departments. Your lordship may see 1, 2, 3, 4, 5.
Yes.
And on the right hand side, we got various groups A, B, C, D, etc., sanction strength.
Right.
So these all will be filled up. All of this will be filled up by a deselection process, and it is open for them to participate in that. Not a problem. Your lordship may grant them that liberty.
All right.
Both on the question of relaxation of age, as well as marks for the period 1 mark, like under the old rules. But instead of going into this, presently also there are 692 posts, for which the examination has not been held because your lordships are single judge said this will not be filled up pending the present return.
So, no, but what happens if the rules themselves that permit this?
Yes.
Those have themselves been repealed, right?
That would be repealed.
Well, another aspect, my lord, that rule, my lord, has got no application. That was our case for the honorable single judge, my lord. And they have not, only one thing.
Why are you interrupting, sir? This position was very clear last hearing also. According to you, those rules do not apply.
Yes, sir.
According to them, it applies. We'll try and understand their case. We will deal with your case that these rules don't apply. But his case is the rules apply. We're asking him if the rule itself has been repealed. What will apply?
I'm sorry. Your lordships have seen the Delhi judgment of Justice Lalit, where he gave this weightage and said that they can't be left to nothing. So the same principle, my lord, your lordship may record my concession that the benefits granted under the repealed rule will be made applicable to them because the rules have been repealed while these petitions are pending. So that your lordship may say, my lords. So all that we are saying is 696 posts have been now are there. You participate in those examinations, take Section 8 benefits, and if you are good, you will get selected. But they can participate in this, they can participate in that, they can participate in both.
All right. Yes. Now you can.
Before the honorable single judge, they have never taken that plea. That rule has got no application. Kindly pause for a minute. They have rightly not taken that plea because that plea, having been taken in Jatin Das case, and having been repealed by the tribunal, by this honorable court and the honorable Supreme Court, they have rightly not taken. That is why, my lord, I have also filed the SLP copy before the honorable single judge that was also dealt with. My lord, kindly come to, on the last occasion, my lord, your lordship wanted me to clarify about the test. About the test. If your lordship look at page 87, I'll just.
87 is the first paper book.
87, you also can take Milord flag Y.
No, this is the first one. Patita Pavan.
But that flag Y, Milord, my compilation, my objection and.
No, in which writ appeal, sir?
This is the writ appeal, Milord. 777. Well, you also may take up that flag Y.
Yes.
Kindly come to page 30 of that compilation.
1 minute.
Page 30, Milord, para 13.
Page
30, Milord, running page 30 of that flag Y, Milord. Para 13. In the meantime,
1 minute, once. Where's this flag Y? Page 13 or para 13?
Para 13. Page 30, para 30.
Yes, in the meantime.
In the meantime,
which is this para 13 is what?
Para 13 of the writ application.
Of the writ petition?
Yes. In the meantime, though GA department has made Orissa Group C, Group D post contractual appointments, yet the said rule has got no application to the cases covered under GA department resolution letter 79/2013. Well, kindly come to their reply, my lord. Your lordship will get at page 90 of the counter filed before the honorable single judge. Page 90. Running page 90.
Yes.
The averments made in paragraph 12 and 13 need no reply. Then, my lord, kindly come to page, kindly come to the selection test. If you also look at, I have taken, my lord, paragraph 5, page 24 of the writ application. My specific limit. Paragraph 5, page 24. Against the aforesaid 600 posts created under Annexure 1, opposite part number 2 issued advertisement in the Oriya, Delhi, Samaj and Dharitri and through notice board in District Office Cuttack, and also requested District Employment Exchange Cuttack to supply names of the candidates having graduation, post-graduation with DCA, PGDCA qualification for the purpose of being shortlisted for being appointed as operator assistant in various tahsils of the Cuttack. Names of the next page, names of the petitions along with 150 other candidates are shortlisted, and thereafter they are asked to appear in the written test, computer test, which was organized to be held on 31/1/2008 in the conference of the collectorate Cuttack. I have given annexure 2. Kindly see their reply. Their reply your lordship will get at page 186. Para 10 of their counter affidavit.
Yes.
That these deponents stoutly denied the averments made in paragraph 5 of the writ application, and the petitioner put to strict proof of this. On the basis of annexure 2, they have remember denied this. I have given details. And can we come to the next page, para 11. And you also have seen annexure 1, that 24/11/2006, where the post was created. It was left to the collector to cause appointment. If you also look at para 11, page 87, what was their counter? That with regard to averment made in paragraph 6 of the writ application, it is submitted that since the post created an engagement was made thereunder for a specific purpose, the government did not find it necessary to prescribe any standard recruitment procedure for engagement of DEO. So the collector concerns have adopted methods as suitable to them for selection of DO, simply to manage the updation of land passbooks for a period of 6 months. It was also not necessary to follow any rigorous recruitment procedure for a work required to be completed within 6 months, but since work could not be completed during the specific period, their services have been extended 6 months basis. Well, your lordship see that Annexure 21 I have filed before the Honorable Single Judge, because the Honorable Single Judge wanted you file all the extension orders. If your lordship look at page 124. 124 of the same Y, madam, flag Y. Initially, it was for 6 months. Thereafter, my lord, on an annual basis, again they have given 6 month basis. My lord, kindly see page 124. First extension was 13/3/2008. And my lord, kindly see the next page 125. The next extension was 12/2/2009. My lord, kindly see the subject. I am directed to say that government, after careful consideration, subject engagement of DEO come assistant in Tahsil level on contract basis for preparation and distribution of land passbook and for assistance of citizens facilitation centers. This was taken note of, my lord, in that page 49, where they have said the entire business of Tahsil office are being managed by them. And my lord, for a minute, yesterday I have asked them to, what is the date, what is the duty that has been discharged by you? I have asked them particularly, my lord. They have seen the government letter. My lord, kindly see. For a minute, my lord, kindly see this. From 2009, they have been discharging all the duties of so-and-so. My lord, kindly see, this is a letter dated 14/12/2018. In view of the above, the following works assignments are to be entrusted to the DEO engaged in Tahsil office and need to be followed scrupulously. Day-to-day updation of various e-governance applications in Tahsil like LRS-MS, RCCMS, CCMS, CMS, to facilitate record keeper for entry of required inputs for correction of ROR and dispatch thereof, to handle e-district level matters for quick issue of miscellaneous certificates, preparation of MIS, MPR as required and necessitated, to handle e-dispatch work, preparation of salary bill of employees of Tahsil under HRMS and IMFS platform. The above works are only indicative but not exhaustive. So they have been discharging duty, my lord, for last more than 16 years. And kindly see, my lord, the stand they have taken that they have never prescribed a procedure. And my lord, in all other cases, my lord, all other districts, my lord, like Cuttack, my lord, advertisement were issued. District Information Center, my lord, they participated. Computer test was taken. And initial, my lord, matriculation was the qualification required. But they have taken, my lord, graduation with PGDCA.
No, this computer test, I don't think it's an admitted position. You keep saying you underwent some test, they are denying it.
Well, paragraph 11, they have specifically stated they have never prescribed any procedure.
No. So
and my lord, this particular aspect regarding, my lord, 2013 rule application, my lord, that was the stand they have taken before the tribunal. I'll just read, my lord, what was the stand and how that was denied. My lord, kindly come to the stand of the government, my lord, in Jatin Das case. My lord, kindly come to page 209. Of that flag, why, my lord? May I please?
209.
Yes, sir. Page 209, para 4.
Para 4, huh?
Yes, sir. Because that was the judgment, my lord. Kindly remember, based on this judgment, my lord, number of judgments have been delivered by the Honorable Single Judge, by the Division Bench, even by the Supreme Court. And even your lordships followed, my lord, 4 cases. This was also followed. And that last judgment of the Supreme Court was 10/3/2023. I'll show to your lordship what your lordship said. Paragraph 4. The state respondents have filed their counter in OA number so and so and adopted the said preliminary counter in respect of all the aforesaid OAs. According to state respondent, all the applicants based on selection by a committee on the chairmanship or additional commission of commercial taxes initially engaged as IT personnel, namely data entry operators and junior programmers, through outsourced employee, namely IDCOL Software Limited and Odisha Small Industries Corporation Limited on contractual basis under the city organization. Most of them are continuing as such till date on annual renewal basis, and their selection by the aforesaid committee does not confer the status of government employee on the applicants. They have to be engaged in DEO programmers. According to state respondents, finance department has sanctioned engagement of 177 number of IT personnel comprising so and so, including data entry operators. 9 programmers were engaged under the commercial tax through outsourced agency, namely IDCOL Software Limited and OSS Limited. Then the finance department, by its office dated office order number so and so, directed the commercial tax organization to engage 147 DEOs, including the applicants on contractual basis instead of outsourcing basis, by following appropriate procedure. However, state respondents have admitted that no rule or executive instruction is framed for engagement of IT personnel in city organization. However, without an open and transparent recruitment procedure and without following the principle of Overview Act, all outsourced DEOs, including the applicants, were straight away engaged as DEO on contractual basis under commercial tax organization. It is the case of the state respondent that applicants having never been recruited as contractual IT personnel, DEO, junior programmer through open, transparent procedure following principle of Overview Act, they are not entitled to benefits under J Department Resolution so and so. And J Department Resolution, according to the respondent, Orissa Group C, Group D Post Contractual Appointment Rule 2013 is applicable to the case of the applicants, and the applicants have to compete with fresh candidates in any government recruitment process for Group C, Group D Post. And in that event, they would be entitled to operate age relaxation up to 45 years, and they will get 1% mark for each completed year of continuous service, subject to maximum 15% of extra mark. However, the factual aspect as highlighted, the applicants are similarly situated contractual data entry operators and junior programmers in other various departments, including finance department officers in the state, have been regularized in the regular scale of pay with grade pay on completion of 6 years of service as per J Department Resolution Letter 79/2013, as indicated in Annexure 7 series, have not been denied by the state respondent in the aforesaid preliminary counter. Here also, they have never denied. I have taken specific plea and I have given the documents to show that each department, other departments have regularized my lord based on 17/9/2013.
So here they repeatedly denied that you are covered by that. I've myself read in this very counter affidavit, they say you're not covered by 17/9/2013.
But they have said that. I not deny that. But the tribunal said it is not applicable to them.
That's different, sir.
My lord, because they have
now
said
saying that they never denied that this applies to you. In fact, they have consistently denied that 17/9/2013 applies to you.
My lord, can you see the reasoning assigned by the tribunal?
Yes.
The reasoning assigned by the tribunal. My lord.
Yes.
If you lordship, page 214.
Yes.
Last 4 lines, my lord.
Yes.
The manner in which the authorities have considered the cases of others while regularizing Group C contractually, we are of the opinion that cases of the present applicants are to be guided and regulated in terms of Resolution dated 17/9/2013, read with Resolution dated 16/1/2014 instead of Orissa Group C, Group D Post Contractual Appointment Rules 2013 came into force with effect from 12/11/2003, with a further clarification that Contractual Regulation Rule 2013 and Resolution dated 17/9/2013 read with 16/4/2014 that are completely different from each other and had its simultaneous existence. And in this case, my lord, they are not a single line. They have said that the 2013 rule has application before the honorable single yes. That is why, my lord, I refer to that because they have taken a new
here,
plea.
not there, sir. You came forward with a case.
Well,
you are covered by 17/9/2013.
Yes, ma'am.
You have to make good that case.
That is correct, my lord. But that
so forget
2013,
about
what they are saying, my lord,
defense.
2013 rule has application
your-
1%, 1%. That has been repealed, my lord. And 2013, my lord, you also said that test, my lord. I'll read, my lord. The judgment of the Honorable Single Judgment. Honorable Single Judge has dealt with each and every aspect, man, whatever they have taken. And so far as this test is concerned, my lord, your lordship's interpretation may be correct. I don't dispute that, my lord, because that the corresponding post-regular recruitment, what I do not find, my lord, what is the rule that was for grade 1 or consolidation grade 1? It was in a consultation manual, my lord. Only through, my lord, the project head.
Fact remains, neither
Well-
did you take that test or any other test.
Test, my lord, I have conducted. I have
That is
completed.
disputed, sir. That is disputed.
My lord, kindly see what the law says.
If you underwent some test, you should produce a document to show you underwent a test. Where is that document? If you underwent a test,
My lord,
then there must be some document to show that.
my lord, document, my lord.
So I'm just saying, so we are going
No,
down.
I have given my annexure 2 only one document. If you also give me, my lord, I'll apply for on the RTI.
Not like that, sir. These cases have been going on for years now.
Well-
And suddenly, because I asked a question, say, now I'll ask for RTI.
No, I have given annexure 2, my lord. They have never denied that. That some sort of procedure the collector has followed.
Anyway,
Well,
all right.
then, my lord, and that fact, my lord, they have not denied that.
So
Well-
you're not interested, if I take it, you're not interested in participating in this test or recruitment.
My lord,
You say, don't force me to go into this. He says either for 692 vacancies or now that you've submitted another document which says thousands of vacancies. The
Well,
AG says, if you are interested, we can give you the same facility that was there under the 2013 rules by relaxing, giving you 1% weightage for your marks, and age also will be relaxed. But if you say, no, I'm not interested in all that.
no,
because-
I'm not saying that, my lord. I'll just place, my lord, what the law is subject to your lordship's appreciation.
I'm
my lord.
just saying, because
My lord, there are two aspects. I understand, my lord. There are two aspects. One is, my lord, 17/9/2013. The other is, my lord, Umadevi. That take completing more than 16 years of service, my lord, by now. And that was also dealt with. And the Delhi judgment, my lord, has been referred to by the Honorable Single Judge.
See, whether they want to come up now with another policy for all of you, that's up to them. Nobody can stop a government if it frames a policy.
Well-
But can we issue a mandamus is the question.
No, Manavas, my lord, if you also look at the Gujarat judgment, the last judgment, there, my lord, they have said if there is a scheme, you have to follow that scheme. And the scheme is, my lord, 17/9/2013.
That's right, if there is a scheme. So we have to agree with you that there is a scheme covering this.
My lord,
That scheme, according to you, 79/2013.
well, at this junction, my lord, kindly come to that Umadevi issue, my lord, has been taken note of. If you also look at page that Amandra Kumar Mahapatra's judgment, para 4 of the Honorable Court's single bench order, my lord.
Yes.
Para 14, page 3074.
Yes.
They have followed, my lord, Umadevi, ML Kesari, everything they have followed, my lord.
Right.
Page 77, my lord. The relevant portion, my lord, 77. Para 43 of that judgment. My lord, please that.
Yes.
As to what would constitute an irregular appointment is no longer res integra. The decision in Moadevi, ML Kesari, has examined that question and explained the principle regarding regularization as University of Moadevi case supra. The decision in that case summed up the following three essential for regularization. One, the employee worked for 10 years more. Two, they have so worked in a duly sanctioned post without the benefit or protection of the interim order of any court or tribunal. They should have possessed the minimum qualifications stipulated for the appointment. Subject to these three requirements being satisfied, even if the appointment process did not involve open competitive examination, the appointment would be treated as irregular and not illegal, and thereby qualifying for regularization. Kindly see para 7, this regard is opposite and may be extracted as this.
Say, qualifying for regularization if there is a scheme for regularization.
But if you also look at the procedure, whatever procedure, my lord, be it not in accordance with law or not in accordance with the recruitment procedure which was there for grade 1 consolidation, grade 1. They have, the collector has prescribed, made a selection based on the procedure according to him, which is valid. And
That's the whole problem.
My lord, only
That's
one
the-
thing.
That's the weakest link, sir.
My lord, they have allowed them while granting extension and expanding the nature of work, my lord. They never objected to that the collector's procedure is not correct. They
That
themselves
question didn't
voluntarily
arise.
accepted this.
The question didn't arise, sir. When they keep
But-
extending your services, they're not going by 79, 2013.
No, but they have never questioned, my lord, the procedure that was followed by the collector. My question is this, my lord. And the Supreme Court says, my lord, employee concern
Why
should
would,
have.
why would they question the procedure followed by the collector? That is anyway not an established procedure. And it is not peculiar to these posts.
Well,
It is some procedure that he has to follow, that he is following.
my lord, there was an advertisement. And District Informatics Center, my lord, which deal with the computerization, my lord, they participated. ADM was the chairman of that committee. 150 persons participated. Out of this, my lord, these persons were appointed. And with reference to 11 persons, my lord.
Yes.
And the Supreme Court says if the employees concerned should have worked for 10 years or more in duly sanctioned post without benefit of protection. In other words, the state government or its instrumentalities should have employed the employee and continued him in service voluntarily and continuously for more than 10 years. Following this principle, my lord, the Honorable Single Judge passed the order. And my lord, all these judgments which have been cited, that has been taken note of by the Honorable Single Judge. Even, my lord, they have never taken that 2013 rule, and now that it has been repealed, my lord, can they enlarge, my lord, the scope of the writ appeal? Because your lordships were issuing notice, my lord, notice on that pretext that the rule 2013 has got application. Though that issue, my lord, had put at rest.
No, he is still willing to say that notwithstanding the 2013 rule is no longer there, they're still willing to give you the benefit of that rule.
No, I'm
Not as a rule, but
I'm
the
obliged for that. I'm obliged for that. On the face of my lord, Anup Senapati, they are taking that plea that after this repeal provision of granting order 1994, all the first appeals, my lord, have been dismissed. It is good for him, my lord. I'm grateful to him that he has made that suggestion. I don't dispute that, my lord. But kindly seeing the scenario of the facts of the present case, my lord, and on what context, my lord, they have been allowed to continue for more than 60 years. And at this juncture, my lord, if there is subjected to a selection, my lord, kindly remember, selection with the freshers, despite, my lord, some preferential treatment. I don't dispute that, my lord. You also consider this, my lord. And your lordship's judgment, my lord. Your lordship's judgment kindly see that if your lordship look at, I have submitted that citation. Your lordship will get a digital page 631. Six 31 first judgment, the batch of applications, batch of writ appeals. Kindly come to the operative portion, at page 3. It was, my lord, in that council, my lord, that ETT department, under the ETT department. Each of these appeals responsible for contractual working for over 10 years. It is also stated in the counter after file the petition paragraph 13 of the present appearance that there were in fact 5 vacancies sanctioned post watchman. The only distinction sought to be made is that for the benefit of the decision of so and so, their appointment had to be merely irregular, not illegal. The fact remains that the respondents have been working continuously as watchmen. It is not the case of the appellant that they are not qualified to be employed as watchmen. Given the fact that the respondents have worked as watchmen on contract basis for over 10 years, it is obvious that the appellants require their services. In these circumstances, the court is not inclined to interfere with the impugned order of the single judge, requiring appellants to consider the case of the respondent for regulation.
That watchman, yeah. This is for watchmen, sir.
No, watchmen, it is not only watchmen. There are other cases, there is junior assistant and data entry operators. Only one mirror is watchman. And mirror, can you see? I have given mirror your lordship's 25/8/2022 order. WA 363 of 2021. There merit the data entry operators working continuously almost 24 years. And following that manner, your lordships allowed this and dismissed the appeal. And merit the next page is the Honorable Supreme Court order. Would not find any merit, any ground to interfere the order passed by the Honorable Division Bench. And my lord, all those cases, my lord, now they have complied, they have implemented. They have allowed them, last page of that compilation, my lord. Order dated 28/2022, they have complied. So Jatin Kumar Das, my lord, 137 DEOs have been regularized. 17 junior programmers were regularized. And all other cases, my lord, I have given the compilation in this, my compilation flag Y, my lord.
Flag Y, is it?
Yes, my lord.
Put a flag Y. Flag Y, page?
My lord, flag Y, 26 is page 166, my lord. This is Vishwamitra Paridan and another versus state and others. This is my Gopandu Academic Administration under J Department. But this judgment of the Honorable Single Judge was affirmed by the Honorable Division Bench and my lord, upheld by the Honorable Supreme Court. 3 cases, my lord, I have given 26 series 166 to 172 and the orders passed by the Honorable Supreme Court 173, 174. All those 3 cases, my lord. And they have been, my lord, now they have implemented them, but prospectively.
Which departments are these?
This is, my lord, under J Department. State of Orissa, my lord, is the appellant. J Department. Go upon the academic institution, academic of administration, my lord. Then, my lord, kindly come to but the concern, those 3 cases, my lord, I have annexed, my lord, page 233, the division bench of this honorable court. All the 3 cases, Vishwamitra Parida, Susan Sethi and others.
It's the same, it's repeating.
My lord, that is up to the division bench or judgments, my lord. I have cited the division bench judgments. And my lord, so far as this case is concerned, my lord, this is a case your lordship remanded to the Honorable Single Judge for reconsideration. Following, my lord, the principles to be followed, they will file counter, I will file rejoinder, thereafter matter will be had. 5 cases, my lord, when the matter was taken up, 5 cases were before Honorable Justice S.K. Mishra, my lord then was, and my lord Justice S. Rath. And my lord Justice Rathu was also a party to your lordship, in that remand matters, my lord. Those matters, my lord, the Honorable Justice Mishra, my lord, has passed that order. Kindly see, my lord, what was the order passed. And this is a coordinating bench. If you also look at the order of the Honorable Single Judge, that is, your lordship's order, my lord, I have referred to in Annexure 23. That is 160, my lord, page 160. My lord and my Justice Rathu, my lord, this was WA 298 of 2021. Thereafter, my lord, this judgment has 777 writ appeal has come. My lord, kindly see what the order passed by the Honorable Justice Mishra, my lord. Annexure 22, page 152. Six writ appeals, my lord. Where, because by that time, my lord, when your lordship's taken up, by that time judgment was reserved on 26/3. My lord, this was the past. My lord, kindly see the honorable judge, honorable division bench, my lord. consider the judgment of the honorable single judge, and may Lord kindly come to relevant portion, page 158. The honorable division bench has quoted the entire order.
No, but again, this is again representation. This is the
the other portion of the judge, the honorable single judge, that our case is directly covered by Uma Devi. That finding was never appealed. My lord has said only that regularization part, if you also 158 minutes.
Yes.
In view of the matter, we hereby allow these appeals in part and set aside the following portion of the order and direction of the single judge and regularize their services and grant consequential service benefits as due and admissible. They have remitted the matter back to the government to consider those two aspects. But the finding matter recorded by the honorable division single judge.
So once it is set aside, then what? How does it help you that?
No, it was set aside in part matter, not in full.
No, but this portion where the single judge asks you should be regularized has been set aside.
That is correct.
Once that is set aside, the fact that Uma Devi applies will not hold good, because this direction of the single judge asking you to be regularized is a direct consequence of applying Uma Devi. If this part has been set aside by the division bench, then you can't say, no, Uma Devi, I am still entitled to regularization.
No, that finding of the, my submission, my endeavor, my lord, to bring to your lordship notice, that finding of the honorable single bench was not touched.
It touched, meaning that whole consequential direction is set aside.
The direction, my lord, to consider representation in terms of the law laid down in Supra, they have said.
All right.
Well, and with this, my lord, I leave it to your lordship. They have rendered more than 16 years of service by now.
We'll just ask there.
Well,
yes. So the last submission, which is the one, I mean, he's harping on.
Lordship.
In a large number of cases, some of which you took to the Supreme Court, you lost. And those cases you have implemented, you have regularized the services. So why be selective? This is the question.
Let's take Jatin Das, which is...
Not only Jatin Das. Today is referred to a whole set of other orders, including orders of the bench of which I was member.
Yes, sir.
Where we've, the watchmen, the three sets of cases.
The
watchmen, junior assistants, and then DEOs.
Yes.
In that institute. And then Justice Ratha himself has given some orders which were taken in appeal and SLP dismissed.
All SLPs delayed and dismissed on delay and laches.
No. In that Justice Hemant Kumar Gupta's bench, Hemant Gupta's bench, it's not delay or laches. Just see that. It's not delay. That's 6:30.
My lord, I must tell you, lordship, because I was also there, my lord, when the Supreme Court has taken up that last case. There, my lord, against that particular DEO, my lord, Solicitor General appeared. Thrice, my lord, he has taken time. The division bench was not inclined to entertain. And they have said, my lord, if you are not if you have not got the judgment from Justice Muralidhar, then you have no case. And that was the exact version. Well, I was there, but if you lordship, it is.
Anyway, that doesn't.
Your last line, I have also had so many occasions to hear that.
Because I was there.
My lord, take page 207.
Yes.
Of likewise. My lord, have it, minutes. My lord, sir, page 207.
Yes.
Kindly see, Millers. There is a paragraph just after the middle. Thereafter, those government agencies, my lordship, sir. Government agencies issued advertisement in local dailies like the Samaj Samvad, pursuant to plaintiffs filed their applications, subjected to screening test from so and so, the screening committee under the chairmanship of the Additional Commissioner Commercial Taxes. Thereafter, the committee prepared a merit list. Based on the merit list, so there was a whole gamut of selection procedure which went with.
That is Jatin Das. No, that is Jatin Das.
I'll just, and Jatin Das and all these cases, they relate to secretariat matters, where there is a cadre, where is the service rule for appointments.
No, this is commercial tax, commissioner commercial tax. It's a district cadre.
Either I didn't disturb you once. So everything is done by the finance department. So therefore, they have, as your lordships have a DO rules, the government has a DO rules. So government departments have nothing to do with collectorates. Would your lordships kindly see, my lords? Your lordship, that day I posed a question to me, what happened to these posts, these 600 posts? Would your lordships kindly see, my lords? Page 21 of my compilation.
Yes.
Engagement of data entry operators. This is the subject in different tahsils of the state on contractual basis. Now, kindly note, these are not departments, these are tahsils of the state on contractual basis for preparation and distribution of so and so. In inviting reference to the subject cited above, I am directed to say that after careful consideration, government have been pleased to allow the extension of engagement of 600 data entry operators who have been engaged and are working in different tahsils of the state on contractual basis on the same terms and conditions intimated earlier for a further period of 6 months from 1/9/2019 or till completion of the process of recruitment and appointment of 692 posts of junior clerks created for the tahsils and subdivisions, whichever is earlier. So therefore, now we have created the post, you compete there, participate, you go in. So once that selection process is over, this will come to an end. Now, would your lordships kindly...
1 minute. These 692.
Yes, my lords.
If you come to page 17.
My lords.
This is creation.
Yes, my lords.
This is separate creation, sir.
Creation
of junior clerk in lieu of abolition of corresponding vacant posts in survey and settlement organization.
Correct.
No. The genesis of these people's cases.
Yes, my lords.
Was what you pointed out in page 1.
Yes, my lords. Let me come to page 1. 24/11/2006. Let me read this.
My question to you was these 600 posts. What happened to this 600?
Look, these 600 posts.
I don't think they were abolished at all.
Let me tell you, lordships, what happened. As your lordships have seen, these are temporary posts.
No. In fact, that was my question to you.
I'll answer that straight away. And I'll tell you, lordships, why they were temporary posts. Kindly see, my lord, from the very first letter, I am directed to convey the sanction and creation of 600 posts for data entry operator, come assistants to be engaged in the different districts to render assistance in preparation and distribution of so and so for a period of 6 months.
No, they're to be engaged for 6 months is no doubt.
For a period of 6 months.
Correct.
And let me read further. My lord, at the rate of so and so, your lordship may then see, my lords, kindly see Roman 3 of paragraph 2.
Yes.
The engagement orders will be issued by the respective collectors, specifying the date of engagement clearly.
Correct.
For a period of 6 months.
Yes.
The disengagement is automatic.
Correct.
On expiry of the term, on termination order needs to be issued. No termination needs to be issued.
No. So the engagement will come to an end.
So, my lord, therefore, the submission to your lordship is this. That today, this 600 posts
cannot have been abolished. I'll tell you why.
Yes, my lord.
Because this same thing you've been extended till date.
Yeah, I did extend till date. So when did I stop? So when did I stop, my lord? I stopped on 26/9/2019. That is the cause of action for them to come to the High Court. On 26/9/2019, page 21, I said, look, now I have advertised X number of posts.
No, but even there you say it will continue till I fill up.
Till I fill up those posts.
But which means these 600 didn't come to an end even on that date.
My lord, once I complete my appointment procedure for
now
that.
Come to page 17, sir.
Yes, my lord.
Come to page 17.
Yes, my lord.
If what you say is true,
yes,
this letter creating 692
correct
should say we are abolishing the 600 posts of data entry operators which we created on 2006.
My lord, if your lordship sees page 18, page 19, my lord.
Yes.
Kindly see page 19, my lord.
Yes.
Now we are creating 692 posts
by
junior
abolishing something else.
Yes, we are abolishing something else because while they were appointed, these were contractual appointments for a temporary period.
No, in fact, now come to that document.
Yes, my lord.
Now you come to that flag Y.
Yes, my lord.
Which is that document, sir, where it says consolidation, group 1 consolidation.
That is my lord, page 49.
Of flag Y.
Flag Y.
Yes.
See, these things we have to reconcile, Mr. Parija. Otherwise, it's a big problem. Even for you.
Yes. Your lordships, I have seen page 49. 49, kindly see, 49 is the minutes of meeting by the chief secretary level.
Correct.
My lord, this is, it says at the outset, so and so, stated that 600 DO assistant posts were created by abolishing equal number of consultant grade posts.
In 2006. So we're talking of this very document at page 1, sir.
Correct. No,
So
no,
this,
yes,
so
yes.
we know this was created by abolishing something.
Correct.
We can't equate this to that page 17.
Now, my lord, would your lordship see one more page? Kindly turn to page 69.
So one way of looking
yes,
so that it favors them is that till date, these 600 posts exist.
My lord, and that 692, what I say is
692 is separate, sir.
Correct,
because
correct.
that survey settlement you abolished and you created 692 and you created junior clerks.
Correct.
You're on DEOs now.
Yes.
For DEOs, you created specific posts of DEOs.
Yes, my lord.
Whatever, whether it's by orders of the court or pendency of the matters, they continue till date.
They continue till date, but I'm not giving them a farewell. What I am saying is
No, we are only now, therefore,
yes,
only on the third limb
yes, my lord.
of that 17/9/2013.
Correct.
Do they have they come in through a regular process of
Yes.
selection? That is the only thing.
My lord, the answer is no. Because of Annexure 2. Before I take your lordships to Annexure 2, kindly see page 69. My lord.
No,
My
but
lord, lordship, just
page
see
69.
This is another minutes of meeting held by the chief secretary.
69 of the same.
Yes, same. Likewise.
Yes.
A meeting was held on 16th of March 2020 at 12:30 p.m. under the chairmanship of Chief Secretary in his conference hall to decide the extent of the special provisions, relaxations, eligibility criteria of so and so, so and so. The additional Chief Secretary Revenue and DM appraised the members about the issue of giving special provision, relaxation of eligibility criteria for DOs working in different tahsils. With concurrence of Finance Department, 600 data entry posts were created for engagement of so and so on contractual basis for preparation of land passbook at tahsil level for a period of 6 months with a revenue letter number so and so. At present, 572 DOs are working in different positions in different districts, out of which 429 posts are engaged by collectors on contractual basis, rest 81 by outsourcing. A proposal for regulation has been moved to Finance Department concurrence so and so was regretted with the observation that no recruitment rule or ORB has been followed. The minimum qualification for the post of DA was matriculate, whereas the minimum qualification for post C at district level is intermediate. The last extension of the engagement letters with data entry operator was made for 6 months with effect from 1/9/2019 to 29/2/2020. After detailed discussion on the issue and after acknowledging the fact that they cannot be regularized, it was decided
There's something missing.
that these DO, if your lordship sees page 50 of the writ petition, that document is there.
One minute.
My lordship, page 50.
One minute. Of the writ petition.
Yes, my lord.
Yes.
My lordship, have it, my lord?
Yes.
After detailed discussion on the issue and after acknowledgement of the fact that they cannot be regularized, it was decided. My lord, why? Because we said that they have not come through a selection process. It was decided that these DOs can avail the special provisions as envisaged under Rule 8 of the Group C, Group D post Contractual Appointment Rules 2013 in the process of recruitment to the 692 junior clerks created in lieu of abolition of equal number of vacant posts in service settlement organization. The Revenue Department will take necessary action. So this is exactly what I'm suggesting to you.
No. Let's go back to this para 3.
Yes, let me read para 3. A proposal for regularization of the DOs have been moved to Finance Department for concurrence in 2018, which was regretted with the observation that no recruitment rule nor ORB has been followed.
No, stop here for a minute.
Yes, sir.
See, it is not that no selection took place.
Yes.
See, this is the problem.
Yes, sir.
You simply say no recruitment rule has been followed. See, this not following a recruitment rule is not their fault.
Correct.
If you go by that 79/2013,
it talks of a recruitment rule.
It talks of a recruitment procedure. Let's go back to 79.
Yes. My lords have it, minutes. It is at page 4 of the compilation.
Page 4.
Yes, minutes.
Right.
Towards the middle minutes.
Correct.
Following the recruitment procedure prescribed for the corresponding regular post. And let us see.
You have not prescribed any recruitment procedure.
There are two subsisting procedures available for DOs. One in your lordship's court and one in the secretariat. Those I have appended. So they have a recruitment procedure.
Where is that?
But if your lordship sees my compilation, lordship may kindly turn to page 41.
Page 41.
My lords have page 41 of the compilation.
Right.
In exercise of powers conferred under the proviso to so and so, the governor of Orissa is pleased to make the following regulating method for recruitment and condition of service of Orissa Secretariat Data Entry Operator Service.
Yeah, so this is a prospective thing of 2008.
Yes. So therefore,
so the point is this, sir.
Yes.
You did not formulate this procedure when you took them. So you can't accuse them, listen, you never came through a recruitment procedure.
But the whole idea is that your lordship knows in Odisha, we have two kinds of posts, temporary post and permanent post.
Correct.
The service code, your lordships have seen.
Correct.
Now, today I am making a temporary post.
Correct.
I'm
not a temporary post, temporary engagement.
Temporary engagement. Your lordship may put it temporary engagement. I'm grateful. So all that the temporary engagement said is, let us see what it said. Will kindly come to page 1 again, if your lordship don't mind. Milords.
Right.
If your lordship sees page 1, it refers to a temporary post.
No.
It refers to a fixed period. It was 6 months. It refers to a temporary post at fixed term, fixed purpose, and fixed remuneration.
No, it doesn't talk temporary post at all, sir.
Miller, let me read this. I am directed to convey the sanction and creation of 600 posts of data entry operator, cum assistants were engaged in different districts to render assistance for preparation and distribution of land pass books for a period of 6 months at the rate of 4,000 per month.
So this for a period has to be read with who are to be engaged for a period of
6 months.
Not that the post is created for a period of 6 months.
Miller, let me read further. While conveying sanction order to the respective collectors, the following aspects may be kept in view. The recommended qualification would be matriculate with knowledge of computer operation. The temporary collection staff who are engaged earlier for collection work may be given preference.
Right.
So therefore, they are the first category.
Correct.
If required, number of data entry operators cum assistants are not available in the district, and after exhausting the above conditions, and wherever service providers were available, the collectors may take their assistance to fill up the residual vacancies.
Correct.
So therefore, first give temporary collection staff, then service providers, otherwise you take them. If the service providers are not available in the district, collectors are free to engage them. The engagement orders will be issued. So what will happen? Their engagement orders will be issued by respective collectors, specifying that the date of engagement clearly for a period of 6 months, disengagement is automatic on expiry of the term and no termination order needs to be issued again. So with 6 months, they have to go. This has been extended from time to time. Would your lordship see then next one? The copy of the sample format prescribed by the finance department for engagement of hand on contractual basis. So they are on contract. On contractual basis is appended. Now your lordship may see page 3.
Yes.
This is to intimate to you. This is what they are relying on. This is to intimate to you that DICS as the nodal agency of the district to support preparation, implementation of information management plans by different like departments and other organizations in the district has decided to have a panel of computer professionals to facilitate their engagement. Kindly look what this letter is for. To have a panel of computer professionals so as to facilitate their engagement as and when required in the district as service provider. For this purpose, a computer test is going to be organized on 31st of January 2008. So for what, my lord? For finding out a district service provider. Your name has been shortlisted in the list supplied by the district employment exchange. You are therefore required
This
to
is
come.
open market.
Yes.
This is the third category.
Correct,
of open
correct.
Market.
Now, my lord, see, my lord. My lord, this gentleman is relying on this letter only.
Correct.
My lord, he, Patitapavan Das,
Yeah.
relies on this letter alone.
Correct.
Now, kindly see, my lord, how everything has been dealt with at page 25 of the compilation.
All right.
My lord, sir, page 25. The Honorable High Court, while hearing writ appeal number so-and-so dated so-and-so, sought for the following instructions. Accordingly, as per para 4A of the GA Department resolution, number so-and-so, the High Power Committee consisting of the following members was held on virtual mode through MS Team to examine the matter of regulation of DOs in different tahsils of the state for preparation and distribution of land pass. So A, B, C, D, they are all the people who are in that meeting. As per para 4C of the aforesaid resolution, the committee must ensure that the concerned appointments fulfill the following mandatory eligibility conditionalities as elucidated in para 1. Contractual appointments engagement must have been made against contractual posts created with the concurrence of the finance department on abolition of corresponding regular posts of the contractual post created with the concurrence without abolition of so-and-so, strengthening the existing offices. Such contractual appointment must have been made following a recruitment procedure prescribed for the corresponding regular post. Principle of reservation of the post must have been followed in such cases, etc. The committee examined the matter in reference to the GA resolution number 16 January 2014 and observed as follows. With the concurrence of finance department, 600 data entry operator posts were created for engagement of DOs on contractual basis for preparation of land passbook at tahsil level for a period of 6 months by revenue letter dated so and so. The qualification and manner of engagement of the prescribed aforesaid letter was as follows. A, the recommended qualification for filling of these posts would be matriculate with knowledge of computer operation. Temporary collection staff earlier would be given preference. If collection moratoriums are not available, district collectors would take necessary assistance from service providers wherever available. If service providers are not available, in the district would make engagement from the open market. The fourth category. Such engagement was specifically for a period of 6 months. The disengagement was automatic on the expiry of the term and no termination order was required to be issued. The tenure of the contractual post of data entry operator was last extended on 6 months for 6 months on 1/3/21 to 31/8/21 by the government and the revenue department dated 18th of March 2021. The DOs were engaged temporarily for a specific purpose. The recruitment procedure for engagement of these DOs was not prescribed since the engagements were for 6 months only. No uniform procedure has been followed for their engagement.
This is the difficult part, sir. So
Yes,
this is, see, one is till now, once you say the last extension was till 2021.
Lordship pleases.
There's an acknowledgement that for 15 years, these people have been continuing.
Correct. Correct.
And if they were so bad, I mean, they didn't know their job, there's no question of continuing them. You yourself found them to be...
Lord, 17(9). On which
I'm saying where this thing that there was no recruitment procedure all pales into insignificance if you're continuing a man as DO for 15 years. At the end of 15 years, will you tell me that, sir, you didn't follow a procedure in recruiting you?
Lord, 17(9) says, one of the guideline is that they must have come through a recruitment procedure.
That's right. That is repeated in 2014 as well.
Correct.
But you did not prescribe a procedure. So what the collectors did is they simply had a computer test. Now, if there was no test at all, there is still one thing. Some test was held. See, once you're taking from the market, it's not as if first come, first served, everybody who applied got taken as a DO. Certainly not. I'm sure many would have applied, out of which whoever qualified in the computer test would have been given the letter.
Well, let us look at what is the post we are looking at. We are looking at a data entry operator.
Correct.
Now we are looking at what kind of examination happened.
Correct.
That's the next step.
We don't know. That an examination happened is important, sir. What kind we can't now go into?
I'll just allow me 20 seconds. What we are now looking at is that 79 says that look, some prescribed procedure has to be followed.
No, you did not prescribe. I'm just saying it's not their fault.
I'm coming there. I'm coming there. So now we see that whether in the state there are any prescribed procedure for such a post.
No, in 2008 you prescribed the procedure. You took them in 2006.
In 2008 one procedure is there.
Who stopped you, sir, when you extended his service in 2008?
Yes, madam.
You could have easily said only those who satisfy this test will be extended. You could have easily, nobody prevented you. The point is you took the lazy route. Obviously, when that last minute, tomorrow 6 months is going to come to an end, a note will be placed. Sir, we need their services. Please extend. Say yes.
Your Lordship knows, Milord, how that happened. Let me just complete it. The DOs were engaged temporarily for a specific purpose.
Correct.
The recruitment procedure for engagement of DOs was not prescribed since the engagements were on 6 months only. No uniform procedure has been followed in their engagement. Now, Milord, next one is very important. There is no sanctioned post for consideration of the present contractual DOs for regularization.
This is not correct, sir. This is not correct at all. Which is why I've been harping on this.
No, this is correct.
692 you created by abolishing survey settlement posts.
Correct.
600 you created by abolishing some consolidation group 1 posts.
Yes, madam.
These 600 posts were never abolished after that. These 600 posts have continued, which is why these people are continuing.
No, these 600 posts were created for a particular purpose.
It's still continuing that purpose.
No, Milord, once these people come in, the 692 come in.
They are junior clerks, sir. They are junior clerks. They are not DEOs.
Milord, they will do the same thing.
We don't know. Anyway, you seem to have a need for these. The junior clerks, whenever they come, they will come. You seem to have the need for DEOs.
No, Milord, may I
they are
submit?
here in your offices. They are
Milord,
continuously working.
Milord, now, Milord, what they are contending, what the learned single judge has held is, Milord, if you just kindly have a look at the judgment at page 57.
Yes.
My lords may kindly be pleased to come to page 60. Milord, identical facts. My lords have it.
Yes.
Paragraph 6 at page 60.
Yes.
At the outset, it is required to be noted that the respondent herein, original writ petitioners, were as such appointed in a temporary project, which was created for the purpose of rehabilitation pursuant to earthquake for post-earthquake redevelopment program. All of them were initially appointed for a period of 11 months on a fixed salary, which came to be continued from time to time, till the requirement in the particular project implementation unit. However, the said unit was required to be closed, which as such, the temporary unit, instead of putting an end to the service of the respondent, the state government thought it fit to transfer and place them with the Indian Red Cross. At this stage, the respondents approached the High Court and challenged their placement with the Indian Red Cross. Would you lordship now?
Where are you reading, sir? 1 minute.
I was reading paragraph 6 minutes.
Of the impugned judgment?
No. I was reading paragraph 6 at page 60 of my compilation. I'm so sorry, minutes.
Right.
If your lordship sees, my lord, this is State of Gujarat versus R.G. Pathan. Kindly see paragraph 6. What were the facts?
Right.
At the outset, it is required, my lords, to be noted that the respondent herein, original writ petitioners, were as such appointed in a temporary project, which was created only for the purpose of rehabilitation pursuant to the earthquake for post-earthquake redevelopment program. All of them were initially appointed for a period of 11 months on a fixed salary, which came to be continued from time to time till requirement in a particular project/unit of the project implementation unit. So they were temporarily appointed, extended from time to time. However, the said unit was required to be closed, which as such was a temporary unit. Instead of putting an end to the service of the respondent, state government thought it fit to transfer them. You lordship leave that. Kindly now turn to paragraph 10. My lords have it, my lord? Paragraph 10.
Yes.
The division bench has also not appreciated the fact and or considered the fact that the respondents were initially appointed for a period of 11 months on a fixed salary, that too in a temporary unit, project implementation unit, which was created only for the purpose of rehabilitation pursuant to the earthquake for post-earthquake development program. Therefore, the unit in which the respondents were appointed was itself a temporary unit and not a regular establishment.
Next slide is important, sir.
Yes, my lord. But here it was for land passbook.
No. Just read that line.
Yes.
The posts on which
the respondents were appointed and working were not sanctioned posts in a regular establishment.
Correct. Correct.
So they were not regular posts.
No, here it is.
Yes.
See, this is why I'm saying. Here,
Yes. But may I just read the next?
them temporarily.
Yes.
You make sure that you're creating posts.
Yes, my lord.
You don't want to be told, listen, there are no posts against which you're engaging these people.
Correct.
So you are very conscious. In fact, you're doing it correctly, unlike these people who are doing it ad hoc.
Yes, my lord. I was doing it on a 6 monthly basis.
Continued till date.
I was on a 6 monthly basis. My lord, if this
till date, you've been careful not to abolish these 600 posts.
My lord, I am doing it till date because once I issued that advertisement for that 692 posts, that advertisement could not proceed further because the lordships have said that you wait till the writ appeal is disposed of by the learned single judge. Otherwise, my 692 was over.
Yeah, I'm not making the connection between this 600 and that 690.
Yes, yes. So now kindly see para 11. Therefore, when the respondents were appointed on a fixed term and on a fixed salary, just like us, in a temporary unit which was created for a particular project, no such direction could have been issued by the division bench of the High Court to absorb them in government service and to regularize their services. The High Court has observed that even while absorbing and regularizing the service of the respondent, the state government may create superannuary posts.
No, all that we could see. This is why the point.
Yes,
because there are no posts. You
correct.
Pass these directions.
So, my lord, what is bothering your lordship?
No, and here that worry is not there here.
Yes, my lord. The point is, my lord, the point what is bothering your lordship is that these 600 posts are still there.
Very much,
and they are not contingent upon those 692 being filled up.
Correct.
I will produce the government file, your lordship may close the hearing.
All right.
I'll produce the government file. My lord, if 600 posts are still continuing and still there, then that's not the question. If the 600 posts
you
have
show me an order abolishing 600 posts.
I will produce the file. I'll give
you
that.
Cannot, sir. I tell you, you produce the file. I have no issues. You or the best instead of producing the file, the written note, you annex orders to abolish.
I'll do that. I'll do that.
But
all right. You say orders reserved. Both parties are permitted to file additional written notes of submissions within
a week.
Within a week.
I'm grateful to you. My lord, I had the great privilege.
Oh, very nice. Debut made.
I know. I've been working late night trying to.
Only now you have to persuade Mr. Tripathi.
I know.
No carrying so many papers.
I'll be well. I'm in the training well.
Take the help of juniors.
My lord,
Hello. My lord, item that 1022, my lord.
All right. If you want to go back, you can go back.
No, my lord, here, my lord, if your lordship will, after I just was listening to your deliberations.
So we'll reserve orders in this also.
My lord, your lordship, I only submission, my lord. Your lordship may have a glance to annexure 1 of my writ petition, where the director has said that they completely followed the recruitment process, ORV Act, everything has been followed, and we have completed 13 years of continuous service. That is the annexure 1 of my writ petition. And we are gardeners, my lord. We have undergone training. We have attended the interview. We are selected duly, and 71 regular posts were abolished and posts were created for contractual posts with concurrence of the finance.
You file a note, sir. You file a note.
Yes, my lord. I.
But I'm filing a compilation where orders have been implemented. Orders of this,
but you have to give him a copy.
Yes, I'm giving a copy.
I have a small problem, lords. But so far as read appeal number 4.
1 minute.
Grateful, ma'am.
This which is the Acharya's matter is what?
1022.
No, this is a sub item or?
This is
so in all these matters, sir, you say orders reserved. Both parties are permitted to file their respective further notes of arguments.
Yes.
Within a week.
Obliged.
I have a small problem, lords. Read appeal number 402 of 2022, my lords. This can be disposed of now, my lords. From the read appeal, I'll bring to your lordship's notice only one document, my lords, at page number 44, my lords. Read appeal number 402 of 2022, my lords. Page 44. It's a case of regulation. Here the petition is only one driver. Read appeal number 402 of 2022.
44.
Page number 40. Will also got it, my lords?
Yes.
It's a letter. It's a letter written by the Director General to the Special Secretary Government, my lords, to regularize these people, my lords. There are total 16 numbers, my lords. Out of these 16, my lords, everybody has been regularized except for the petitioner, my lords, which is as page number 6, at paragraph number 6, Sukhdev Hansta, the opposite party before, my lords. Your lordship turns to the next page, my lord. At serial number 14, my lords, the Ganoranjan Pradhan, my lords, the single judge or director for regulation state had come before this court, and your lordship had dismissed this case, my lords. I'm giving the copy, my lords. I'm giving the copy of all the petitioners, single judge, single.
You give them copies, sir.
I have already given on 3. I have given them, and they have taken 3 chance to take instruction, my lords.
We don't pass an order separately here today. We'll pass an order in the.
Yes, your lordship's order is also there. If your lordship permits me, I can also. Yes,
yeah, give it.
Your lordship, yes. Page 59 is the input order.
Huh.
There, your lordship, while along that read petition, honorable single judge has relied that 1951 of 2020, that your lordship hearing that matter, that is the data entry operator's case.
No, this is very interesting, my lords. Your lordship may kindly see.
Correct. This is that Patita Pavan.
Yes, that he has relied upon that Patita Pavan case. If your lordship will decide that particular, this will govern that case, my lord. In fact,
no. Anyway, see, your grievance was these orders were passed on the first day without going into individual facts.
My lord.
So he's saying, I'm placing all my individual facts. I'm giving you copies. If you have anything to say, you say it here in the written note.
Yes, ma'am.
Everybody has been, my one last submission is that everybody has been regularized except for the petitioner.
All right. So we look into it. Same order.
Grateful minutes. Right.
So the outsourcing chaps are that today?
Tomorrow. It's tomorrow, minutes.
Okay. All right.
Supplementary list item number 13. 13, my lord.
Item number 13, minutes on behalf of Mrs. Mahapatra, my lord. She instructed that the copy of the read appeal has not been served. Let them serve a copy, my lord.
What matter is this?
This is, my lord. My lord, may kindly see page 75. This order my lord has seen 75. My lord. This order was passed. This petitioner was the opposite party in a OA case, my lord, which was still pending. Even now, as on date, also it is pending. But when that OA is pending, a writ petition was filed before this honorable court, saying that since the interim order has expired in that way, we should be granted promotion. And the honorable single judge granted such prayer. But
subject to the final relief is granted in the interim stage.
But question is, they were not entitled. That was the case before the tribunal. And if at all they wanted such a prayer, they could have moved in the tribunal itself. Because in the tribunal, they knew that they were not entitled. They could not have raised such a prayer.
Anyway, copy of the writ appeal be served on Ms. Mahapatra, counsel appearing for the response within 3 days. What has happened in the meanwhile? You've not implemented.
Not implemented.
All right. Have they filed a contempt? No.
My lord?
They have not filed a contempt either.
Contempt has been filed, my lord.
All right, but anyway, there's no stay granted by us. So what is happening in the contempt?
Only first contempt has been filed. So, my lord, I'll pray, my lord, page 77, this order may kindly be stayed.
No, but unless something's happening in the contempt, sir, we don't know if anything's happening.
My lord, may I give the CNTC number, my lord, which is pending?
No, unless there's an order in that, sir.
2325 of 21 and
List on 12th April. No, 11th April. 11th April. All right. Great.
Item 14.
In that item number 12, that Pattavavan case method, there are number of cases listed. 5 cases were of DEO method. Other cases to be detached method because they were other departments and not DEO method. But disposed of by the honorable single judge based on that principle. Because the documents are different. Only 5 cases, 5 DEO's cases are there. I'll just give memo method in.
Which matter are you talking of?
That item number 12.
So now you're telling after all orders have been reserved, you can't just wake up suddenly and tell us this. We've been hearing the matter for 2 days.
Well,
you're suddenly waking up and making these statements.
Item 14. Sir.
But item 14, outsourcing employees regularization matter.
Which are those matters which are not DEO?
This is matter.
You also did not know.
Yes, ma'am, I know that number of cases. Only 771 up to that first case that is relates to DO. And 3-4 matters only DO. The others are some drivers where some are junior clerks. Total, I will give that list, ma'am.
There are group B posts are there also.
Group B posts are there.
Then they're all first day matters.
Yes, ma'am.
Yes.
No.
Yes. No.
Leading cases were taken up. One case, leading case in all those cases.
No.
Counter regener, everything was filed and that was hard.
777 is counter regener with filing.
All other cases also.
No.
That other case where Mr. Acharya is appearing, it was first day.
In my
Yes,
case,
that is the
I'm
first
taking
day.
out my case.
I'll give the number who is the first day disposal. It will be better, man.
Then let's call out each matter now. Let's do it right now. Otherwise,
Well.
we'll be passing wrong orders.
Well,
Why did you not tell us this? 2 days the whole batch has been listed. You never told us anything.
I'm sorry.
What is this? We create a whole batch only to be told that only some matters are the same batch. It's a waste of time, sir.
Other cases, I'll file it note of submission.
No. If there's no counter rejoinder, why should we break our heads? So 777 is DEO. 188.
That is my driver of Puri municipality.
First day.
The read appeal copy was not served. This is a driver case.
First day, sir. Even according to counsel for let's take individual orders. Even according to counsel for the respondent, the present case concerns the plea of regularization of drivers, whereas the judgment dated 9 September 2021 in writ petition civil 19951 of 2020 bracket Patita Pavan Panda versus State of Orissa bracket concerned regularization of DEOs. Stop. The said order has simply been followed and the writ petition was disposed of on the very first day without any opportunity to the state government to file a reply to point out the distinction in any between the said decision and the case on hand. Paragraph. On that short ground, the impugned order is set aside and writ petition civil 22363 of 2021 is restored to the file of the learned single judge where it will be listed for hearing on 24th July. Replies by the state will be filed to the writ petition not later than 10th July and rejoinder thereto if any on or before 24th July. No further time will be granted to either party for that purpose. The court, the learned single judge will thereafter proceed with the matter and dispose it of as expeditiously as possible. This is 118.
W207 of 2022.
That is the first date.
Same order.
207 also driver.
Yes. Yes, my lord,
Driver. 223 is?
223.
223, my lord, has been posted to 13/4/2023.
What is this 13th April matter? How did it come here?
Secretariat driver appointment matter, my lord. They have been continuing for 28 years.
No, driver, no?
Driver.
This is also
First day. Driver only. So this is also driver. You just add a line here. Next date is cancelled. 225.
Item 225 of 2022.
225, my lord. This is also
This, my
not
lord, counter regent, everything is fine.
not a reason.
It is, my lord, home department. Assistant
Assistant software engineer.
in home election department, my lord. Counter regent, because in home department, this was taken to be the leading case. Counter regent, everything was fine. This will go, my lord, by Patwaba. Same ground.
That you'll also see that he is the post of assistant software to engage and assistant for smooth revision of electoral and preparation of.
See, again, so why I'm saying it won't follow simply. When we talk of DOs, we're going to talk of the creation of 600 posts.
I understand.
We can't. That was a specific.
Maybe take on some other day. Maybe take on some other day.
No, but there's no discussion of the different facts.
Completely different facts.
Those different facts have to be discussed. The single judge seems to think whatever is there in Patita Bhavan is here also. So what you say here in this 225, you say, although the court is informed that the pleadings were complete in the writ petition, it is seen that the impugned order has been passed without discussing the pleadings and noticing the different facts, noticing that the facts of the case on hand, which involved regularization of assistant software engineers. Assistant software engineers was very different from the case concerning regularization of DOs, which was the subject matter of writ petition civil 19951 of 2020 bracket Patita Bhavan Panda versus State of Orissa, which had been disposed of by the order dated 9 September 2021.
Agreed. Stop. And it was agreed by them that this is covered. That's why this is only disposed of. If you also look at the first paragraph itself, they have agreed that this is covered by that decision.
So although in para 3 of the impugned order, it is noted that, open quotation, it is agreed by learned counsel of the parties, ... unquote. From what is stated in the memorandum of appeal and in the counter affidavit itself, it is plain that the facts of the cases are different and it could not have gone on a concession by counsel for the appellate. Paragraph, for the aforementioned reasons, the impugned order is set aside. And then the same 24th July and the same schedule.
W300 of 2022.
This is that data entry operator.
This data entry operator. All right. Orders reserved. So this will be part of that.
W305 of 2022.
This is also data entry operator. 305.
W317 of 2022.
317 also data entry operator.
W318 2022.
This is the data interpreter.
W319 of 2022.
This is the data interpreter.
W343 of 2022.
319. Forever life. 343.
You call Mr. Acharya again. His case will send back. 692 posts, that one.
At 346 data entry operator.
We are at 343, sir.
343, that pass, but that might pass.
346 of 2022.
That is data entry operator.
402.
402, my lords, it's already covered by a lordship's order, my lords. It's already
Is the contractual.
it can be disposed of today, my lords.
The contractual driver.
Similar orders can be passed, my lords. At the page 1, you kindly forward this. Same order can be passed, my lords. At page number 1. Everybody has been regularized except for the petitioner. That was showing, my lords. Same order can be passed.
All right. Right. In view of the order passed, this first page order, in view of the order dated 30th June, the writ appeal is dismissed. All right.
Grateful, my lords.
I say that in that
Gyanaranjan Pradhan, we are following Gyanaranjan.
yes, ma'am. That this case may be covered by that judgment, but not by that
No. Just show him the order that we have passed.
I have seen that I have seen.
We have not mentioned Patitaban Pandit at all. Just
no, that in that
we have actually mentioned Gyanaranjan Pradhan.
Yes, my honorable single judge has said that he is covered by that.
You see our order, sir.
Yes, ma'am. That he is covered by my lord, sir.
We are passing this order only.
Yes, ma'am.
Yes.
In that appeal we have taken that out, he is not covered by that Patita Bhavan. Your lordship said that
this order already we have implemented. I'm sure.
Yes,
we're not now distinguishing between these cases.
Yes, ma'am. Yes, ma'am.
Yes.
Item WF 427 of 2022.
That is watchman.
Sorry?
Watchman. Not data entry operator.
So you just have to now substitute watchman and then put it for 24th July. Send it back. Yeah.
468 of 2022.
And the data entry operator.
W 478 of 2022.
478. The other 478. Sweeper, a part-time sweeper come night watchman.
So it goes back.
Well,
W 483 of 2022.
That is DO, madam.
83.
Tahsil.
483.
W 484 of 2022.
484.
484.
484 also data entry.
485.
That is DO, madam.
W 599 of 2022.
590. 590. 590. A contractual peon while.
Contractual peon. That goes back to 24th July. Now let's shift after some time. This contractual peon, put it for 1st May. Replies to be filed by 17th. Sorry, 1st August. 1st August. Replies to be filed by 17th July and rejoinder before 1st August. All right.
Writ appeal 695 of 2022.
The stenographers.
Stenographer, my lord, the counter rejoinder, everything was filed, but
they're not covered under this.
Disposed of on Patwa.
So 695, you follow the other order which was for assistant program officers.
Yes.
The same order.
WA 225 of 22.
Same as 225 of 22. All right.
Writ appeal 705 of 2022.
The same, my lord, Vigilance Department, Vigilance Department, my lord, 225 of 2.
Counter rejoinder is all filed?
Yes.
All right.
Because the Mamta Sahu case was taken to be the leading case in those batches.
All right.
706 2022.
706.
This is That 225 order, my lord.
All right. What is the post here?
This is, my lord, the data entry operator in vigilance organization.
It is data entry operator.
Yes.
Vigilance organization.
State vigilance organization. Posts were created, appointments were made, and they have been continuing.
So this is DO only, sir.
Yes.
This can't be 225 then.
Here, my lord, counter region was filed in the Mamta's house case. That 695 of 2022.
No, 695 is DO only.
Yes, my lord, DO in vigilance department.
That's all right. But if they are DOs, that's fine because posts were created.
Yes, yes.
No. This is vigilance organization. Your lordship is dealing with DOs of revenue collectorate. So this is the vigilance organization. This is separate.
All right. See, then put it as DOs of vigilance organization. That is 695, 705, 706. All right.
729.
729. So all this will go on again 1st May. And 24 July will be the date for. No, you simply say list on 1st May, not for counter rejoinder, saying that they did not take into account the separate facts.
Table 739 of 2022.
That is Tahsil.
No, this is DO.
DO Tahsil.
742.
739 DO.
29.
739.
729 is different. 729 is different.
No, that is a vigilance DO. My lord is putting to 1st May.
DO in way say attendant. My lord. 729.
No, what was pleadings complete in this?
729, no. The pleading complete, that not a DO attendant. 7.
Also put it to 1st of May, my lord.
All right. 729 simply say attendant. All right.
739.
739 well, DO.
740. 742.
42 my lord, DO.
926 of 2022.
926. DO.
All right.
927.
920.
DO, my lords. DO. Same.
928.
That is DO.
Same, my lords.
929.
Same, my lords.
DO, my lord.
930.
Same, my lords.
935.
Same, my lords. Same, my lords. DO.
All right.
936.
936. MIS.
936 is?
Separate.
No. Counter rejoinder complete or?
No.
No.
All right. So very first matter then.
Only
Only dates you have to change it. 1st May and then 24 July. All right.
937.
937, I'm praying for an adjournment, my lords. It's a case of driver, my lords. The opposite party have continued for more than 25 years, my lords. In the meantime, since last 1.5 years, they're not allowing to continue. So therefore, I'll take some instruction in this. I'm praying for a short adjournment, my lords.
937 or 1st day disposal.
Then it
1st day disposal, page 31.
No pleadings were complete.
No, 1st day, my lord. No pleadings.
All right. Then let it go back. Jagdish Rao.
In Jagdish Rao, my lords. Yes.
So very first matter, and then now give it for 8th May. 8th May. Counter to this file. Not 8th May, sorry. 8th August. 8th August. Replies to be filed by 24 July. Rejoinder for 8th August. Sorry.
952.
952 data entry.
1022.
1022.
Gardner.
Gardner. Say Gardner matter.
Gardner. So we'll have
Mr. Acharya.
Acharya that. So just tell him we're sending it back. It will be there on the not 7th August. Don't say it. 7th August. Mr. Acharya's matter also 7th August. No pleadings were complete.
First, page 54. Page 54, my impugn order. Plus first error. Plus you got it page 54.
Right. Thursday. All right.
W1085.
Data interpret.
1086.
1086. Data interpret.
1087.
This is also data entry operator.
1115.
1115. 1115, my lord, it's a commercial tax, my lord, organization based on Jatin Das, my lord.
No, but pleadings complete.
My pleadings complete in both the cases. 1115 and 1379.
As a system analyst.
But disposed of on Pattabhavan, my lord. So 1st of May, my lord, you also put it to for
1st of August, sir.
August.
Not May. 1st of August. All right. Send it back. But you have to say pleadings are complete, but no discussion. All right.
1379.
Perhaps that is the first day order.
That's right, but without discussing pleadings.
But that is the, even no pleading, no counter has been filed.
Yes. Counter agent, everything is fine.
Counter is filed.
Yes.
Yes. Order number 2 is that.
No, counter agent, before that it was.
Must be from the OAT.
No, but
not OA matter.
Counter matter, they have filed 19/7/2021. And we have filed rejoinder.
Yes, ma'am.
All right.
W1379 of 2022.
Same as that. No? 1379 is the same.
Yes.
Yes, ma'am.
779 is same. Yes.
W1573.
This is different, my lord. Casual labor.
Horticulture.
Casual labor under
Gardener, contractual gardener.
Well,
so I think same as first of gardener will be that same. All right.
Well, item 23 and 24. This is counter rejoinder, everything is fine. This was relating to vigilance department. That may go, my lord, along with that.
To be called out.
1 minute, we'll just wait.
Well,
now 12 is over.
12 is over. Item note 14.
Item 14, Lord, first day disposal. Here the outsourcing employees regularization matter and the learned single judge straight away directed to regularize the petitioner within 3 months. Well, Lordship kindly see page 38, the impugned order.
Delay control. Notice returnable. July. Stay till that.
Item 15.
May I please, your lordship? My lord, the honorable single judge filed the order. Your lordship may kindly come to page 20, page 21, paragraph 8. However, the consultation authority, without taking cognizance of the same, recorded the kisam of the land as Sarada Dopasali in final ROR published under section 22(2) of the OCH and PFL Act. It is not correct. Your lordship may kindly come to page 28. Annexure 6. The final ROR published under section 13(4) of the Orissa Consolidation of Holding Acts. So, lordship may kindly see the. May I permitted to read the section 13.
Consolidation.
13(4). 13(4), Your Lordship. Where in respect of any village, an order is published under section 1 of the section 5 and 1 minute. Thirteen four, Your Lordship. Where in respect of any village, an order is published under section 1 of the section 5 at any time after publication of the map and land register under section 1, the map and the record of rights prepared on the basis of such land register shall, for all intents and purpose, be deemed to have been prepared under the Odisha Survey Settlement Act 1958, provided that they are published in the same manner as required of subsection 2 of extract of the record of rights are supplied to landowners at the time of such publication. Here my case is the record of right was published under section 13(4) of the Survey and Settlement Act. Once the record of right is published under section 13(4), that record will be sent to the land Tahsildar. Here the case is the petitioner applied for conversion of the sued property area SC0 24 decimal. Your Lordship may kindly come to Annexure 2, page 13. Demand notice served by the land Tahsildar, Jajpur.
The single judge,
Milord?
the single judge observes that you have a remedy by way of a revision under section 37.
No, my lord, there is no remedy under section 37.
Why?
Because the record of rights published under section 13(4) of the Orissa Survey Settlement Act, the Tahsildar is the authority to convert the land and supplied the record of rights as Ghoravadi. In the meantime, the present petitioner has already deposited the demand amount as demanded by the land Tahsildar, Jajpur. Your Lordship may kindly come to the demand notice under Annexure 2, page 23.
No.
And
what did you challenge in the writ petition?
My lord?
You only wanted a direction to the Tahsildar to issue ROR.
Correct error. That is from Sarada Dufasil to Homestead Group.
No, so by some order, the Consolidation Authority recorded it as Sarada Jala.
Sarada Dufasil.
So that order you have to challenge, sir.
Yes, my lord.
That order is what you can challenge in 37.
That is the view of the Honorable Single Judge. That Tahsildar, you deposit the amount, but it is in the consultation operation. In the revisional authority, you have to file a case for correction of the.
Correct.
Sir, he is not remediless, and prejudice is going to be caused if he is, because 37(1) is clear. If any wrong recording by the consultation authority, it is the revision which is maintainable.
No, my lord, there is no scope for filing any revision in view of the record of rights published under section 13(4) of the Orissa Survey Settlement Act. The consultation has been closed. Your Lordship may kindly come to the notification made in under Annexure 5, page 27. Page 27. In exercise of power conferred under subsection 1 of section 5 of the Orissa Consolidation of Holding and Prevention of Pragmatism Act 1972, the state government do hereby cancel the order issued irrestorative revenue excise department notification in respect of the 3 villages of Jajpur district under subsection 1 of section 3 of said act, and in respect of areas as per the schedule enclosed here. This is number 2, serial number 2, Abdulpur. That Mauja has been denotified from consultation to settlement. Once it has been denotified from consultation to settlement, the consultation authority has seized the power. The settlement authority, so the record of right is handed over to the Tahsildar. Lord Tahsildar should have to convert the land as he has accepted the demand amount, and the same has been deposited before the Tahsildar.
Anyway, all right. You say notice, he accepts notice on behalf of the opposite respondents. The record of the writ petition B, that's already there? Yes. All right. List for hearing on 24th August. 24th August.
24th June.
24th August. Item 16.
Item 16, 17 and 18 had fast day disposal and similar to item 14. Oh, Lordship
Same
directed
as
on
14. All right.
Item number 19.
19, my lord, the promotion during proceeding yesterday, my lord, disposed of all those cases.
item 16.
27 June, is it? 27 June. Right.
Item 20.
My lord, 20, 21, both same as item 4, I have given the order.
All right.
25th April.
25th April. All right.
20 and 21. Item 22.
Same, man. 20, 21, 22.
Item 23.
23, 24 pleadings complete, but disposed of based on Patta Bhavan. So 1st of August, my lord, can be taken up.
What is this post?
This is, my lord, this stenographer, my lord, in the Vigilance Department.
All right. This is a post of stenographer in Vigilance Department. Despite pleadings being complete, there's no discussion. And the writ petition was disposed of on the very first day. Now remanded to 1st August for being proceeded with in accordance with law.
Item 24.
24, my lord, same as that 23.
Right.
Item number 25.
25 may can be taken up after lunch.
Pass over.
Copy.
25. 25 is same that.
It's not stated. Item 25 passed over. Item number 26.
26, my lord. Lordship has issued note. Take. Yes.
अरे जा
Fifth May.
Item number 27.
Same, my lord. Same to 26.
Item number 28.
28, my lord. Departmental proceeding promotion during pendency of department. Yesterday's matter. In the case, notice has not been issued.
All right. Notice returnable. Second of. Returnable 4 July.
Well,
Stay till then. No, 5th July. 5th July, stay till then. All right.
well.
Item 29.
29, my lord, Lordship has fixed it to 25th April. DLR matters.
All right. List on 25th April. Notice already issued.
No, first time.
All right. Notice returnable 25th April. Stay till then. Right.
Item number 30.
30, my lord, promotion during pendency of vigilance case. That's similar to 28. First, it is coming first.
Notice to 5th July. Okay.
Similar to item 28, promotion during pendency of vigilance case. Yes.
Today is 28.
Yesterday, your lordship had disposed of batch of cases, but in this case, notice has not been issued yet.
I see. Yeah, but it notices.
This is also first day disposal.
That's why. So let it go, sir.
Yes.
Because there will issue notice to the.
Yes, my lordship may issue notice so that he can, on appearance, it can be disposed of.
All right. It's a notice returnable. 5th July. Stay till then. All right.
Item number 31.
May I please, Lordship? Lordship, I am Rishi Mehta.
Yes, please.
Yes, my lord, the matter is listed with defect for filing the delay conduct petition. My lord, 2 days may given so that I will file the delay.
All right. List on 20th April. No defects we cured in the meanwhile.
Item number 32.
32, my lord, 25th April. It's a DLR matter, your lordship.
All right.
Item number 33.
33.
State appeal.
My lord, may pass over it 33.
Ad hoc promotion during pendency vigilance case.
Yes, my that.
Yesterday's.
Well,
So this is after notice or?
first time it is.
No. Here notice is gone.
33.
No notice yet.
No.
I think, what is the date?
5th July.
5th July, right.
Item 34.
34, my lord, that DLR regulation 25th April.
April.
And with notices to be issued, ma'am.
Actually, notice returnable 25th April. Right.
Item 35.
35, my lord, in the meantime, that order has been implemented. So,
Infructuous.
My lord, I have a small my lord. After my retirement, they send my CCR for my promotion. That
Separate cause of action, sir.
You
see, the counsel for the appellant states that the appeal has been rendered infructuous. It is disposed of as such.
Item 36.
36 is works as a regulation, my lord. Same as item 5, I have given the order.
Which date?
14/9.
14/9. All right.
Item 37.
37, my lord, regarding enhancement of that superannuation age, relying that Premlata Panda case, that Premlata Panda case has been implemented.
All right, infructuous, right?
Not infructuous, may
dismiss. The shows the order.
That has been relied upon, my lord. Page 13. Relying that Premlata Panda case, my lord, this court has allowed that.
But that Premlata Panda judgment is single judge or division bench?
Single judge, my lord.
So where is the other similar matters of the division bench?
I'll give that number, my lord. You'll ask me to take it.
All right, in view of the order dated dash in writ appeal dash, the present writ appeal is dismissed.
Item number 38.
38, my dealer matter 25th April.
All right.
Item 39.
A dealer matter 25th April.
Item number 40.
40 also dealer 25th April.
41.
41, my purchase employees 49.
Item 42.
42, my lord, regulation of contractual regulation of MIS computer programmers. So this has to be dealt separately, man. But the order was passed on the first day as Patita Pavan Datta case.
This you put it to 1st August, 24 July, set aside, sent back.
Yeah, yes.
Pleadings were not complete.
Not
complete. Contempt has been filed.
All right.
Item 43.
May I please, your lordship? The order of the honorable single judge is under challenge, your lordship. The fact
so many defects.
That defects are state copy has already been served, your lordship, and other is Bhakalatnama filed with the appeal memo, your lordship. Curable defects are there.
So then cure them. List on 1st May, defects be cured.
Obliged.
Item number 44.
DLR.
My lord, 44, DLR regulation 25-4.
25-4.
45.
45 not pressed, my lord.
Not pressed disposed.
Item 46.
46 is 25-4. DLR.
47 also same thing.
47 same.
Item 48.
None appeals dismissed.
Item number 49.
48, 40 dismissed.
49.
Item 49.
Yes, ma'am. May I please, Your Lordship? Your Lordship, may kindly verify the impugned order. My specific case is that without following any due processual law, the opposite are trying to evict me from the property, my lord. But the honorable single judge did not consider my case at all. Rather, constrained me to file undertaking before the authority to vacate the land within a stipulated period. I am a house timber due to Hirakud Dam project. My entire property has been submerged and I have been provided with rehabilitation as per Annexure 1. The record right was also issued in my favor.
You were to file an undertaking within 6 weeks of 2nd August.
Madam? Second order, madam, is that a modification because
you're not able to hear me, sir?
Madam.
Are you able to hear me?
Yes, yes.
The impugned order, can you tell me the date?
Impugned order is Annex page 16.
Give me the date, sir.
4/8/2022.
4/8?
Delay is my order.
4/8 or 2/8?
2/8, page 15.
Yes, 2/8. First order 2/8.
What is the time period and in terms of that order?
Yes.
Within what time did you have to file an undertaking?
Yes, one that is given. We record
6 weeks.
6 weeks, madam, within 6 weeks.
So 6 weeks is over, sir, from 2nd August?
In the meantime, it is over, madam.
What have you done in the meanwhile?
That one, I have not given the undertaking. I have challenged before because I have challenged this order.
You have yourself given yourself a stay.
No, that's not. That's not
Yes,
correct.
of course.
That's not correct. No?
It is correct. It is correct. You yourself gave yourself a stay. So you have continued merrily now for how many months, sir? How many months have you continued?
In the meantime, more than the agreed period.
Sorry?
More than the undertaking period that I am continuing.
More? That's an understatement, sir. How many months have you continued?
No, that is about 8. It's more than 6 months.
How are you continuing without an undertaking for 6 months?
It is a government land, admittedly.
Yes,
he has no vested right over that land. He is saying that I was land ours.
Which is why he simply filed his writ appeal.
Yes.
He never wanted this writ appeal to be listed. Unfortunately for him, we have instructed the registry to list it. Otherwise, it was unnecessary trouble for you, no, sir? This writ appeal being listed is an unnecessary trouble for you. You are hoping it will never get listed.
No, that's not.
Yes. You are staying quiet. You are telling your client, sir, writ appeal filed, don't do anything. Relax. We have filed writ appeal now, don't worry. Orissa High Court, once we file writ appeal, it won't come up for so many years.
No, presently, that is not the situation.
That's precisely the point. That is why we are getting cases like this. In other high courts, sir, somebody gives an undertaking like this to the single judge. Next day, they'll be rushing to the writ appeal. If their undertaking is wrongly given.
Yes,
you are now claiming it is wrongly given.
Yes, ma'am.
This is recorded by the single judge that you are giving an undertaking.
That is my specific. I am constrained to. That is my specific.
A solemn undertaking happened to have. He said the impugned order reads as under. Today, learned counsel of the appellant seeks to resolve from the above undertaking. So it is seen that the appellant has continued in the property for over 6 months after the above order, which was passed on 2nd August 2022, and did not even mention this writ appeal once for listing. Full stop. The writ appeal is clearly not bona fide and is not entertained. It is accordingly dismissed.
My lord, item 50, permission to withdraw.
Let's just withdraw.
I don't know, 51.
My lord, liberty may be granted for the if future causes.
All right. Counsel, the petitioner seeks leave to withdraw the present appeal with liberty to file a fresh appeal. But it's an appeal, sir. There's no need for permission. All right. Dismiss as withdraw.
Item number 51 and 52, my lord. I was the counsel for the writ application, my lord. Therefore, my lord, usual practice of this court is, my lord, in the writ appeal, new vakalat should not have been filed, my lord. So, my lord, if they have shown that as a defect, my lord.
Okay.
There is no new counsel.
Vakalat number is not. Acha. No fresh vakalat number needs to be filed.
In a writ appeal, my lord, usually.
Because he was the lawyer for the petitioner before the honorable single.
All right.
So that
So tell us what the matter is about. That's the only difference.
Here, my lord, I have challenged the order of the learned single judge. On the ground that, as per section 16 of the Odisha Cooperative Society Act, my lord, if an application will be filed before the apex body to include the as a member, if they have not replied anything within 60 days, then it is deemed to be a member of that apex body, my lord. But the honorable single judge, my lord, have held, since I have filed another application, that's why, my lord, dismiss my case. That is not another application, that is a reminder. That was a reminder giving to the apex body that we have filed our application since long.
No, but what happened to that dispute case 103?
That was withdrawn.
That has been withdrawn?
Yes, ma'am.
Why?
Because, my lord.
Because that is your remedy. That's the correct remedy, no?
Dispute case, my lord. Your lordship.
That's the correct remedy. Because any dispute of cooperative societies has to go to the registrar.
No. 68 is, my lord, so far as the management of the case.
Not only management, even members. Members versus management also
68,
goes there.
section 68, my lord. My lord, here is the case, my lord. It is purely question of law, my lord.
No.
And the honorable single judge, while dismissing my writ application, has not, my lord, held that since there is an alternative remedy.
No.
Since there is an alternative remedy, you have to go. Only thing, my lord, interpretation of section 16 of the Cooperative Societies Act, my lord.
What we can observe is, notwithstanding that you may have withdrawn, you can file a fresh petition.
Pardon, my lord?
You say you have now withdrawn that section 68 dispute. 103 of 22.
That is withdrawn. But the honorable single judge, while dealing with the matter.
Yeah, but we can help you to go back and revive that. That can be done. So that you are not remedying.
My lord, here also, my lord, my application, the day the Lawrence single judge had disposed of, on that way, by operation of law, I deemed to be a member. By operation of law, I deemed to be a member, my lord. Your lordship will kindly see the conclusion.
No. The only question is, where do you have a remedy? Correct? They are not making you a member, so you need a declaration from a court that you are a member. Correct?
Yes. Yes, ma'am.
The question is, you should not be remediless.
My lord.
You withdrew what you had filed in the registrar to go to the single judge.
My lord.
Single judge says you have a remedy before the registrar, some other application is pending, and therefore we will not decide it. If you say that was only a reminder,
my lord,
we permit you to go back to the registrar, notwithstanding withdrawal of that 103. Dispute 103 of 2022.
My lord, the honorable single judge has not dismissed my writ application on the ground of alternative remedy, my lord.
Yes. Just see that?
Yes, my lord. Your lordship will kindly turn to page 64.
Yes.
My lord, the sentence starts, thus the effect of deeming clause under section 16(2) of the Act is no more applicable to the instance case, as accepting the decision of the opposite party number 4, a fresh application has already been made by the petitioner to the member of the opposite party number 4. It appears that before expiry of the 90 days of making second application, that is so and so, the petitioner approached the opposite party by filing the dispute case so and so. Therefore, the present petition so and so is premature.
So that dispute case 103, which has been referred to, although you have withdrawn it, today we can permit you to revive it because you should not be remediless. It's not that neither will that go on nor the single judge will hear you. It should not be that you are without a remedy. So we can clarify that since the single judge has declined to entertain your petition, your dispute 103 of 2022 should revive before the registrar. That will solve the purpose.
It is a pure question of law, my lord.
It's all right.
Operation of law, my lord, deemed to be a member, my lord.
All right, all right. You say agreed by the opposite party number 4, Aska Cooperative Sugar Industries Limited, bracket, hereafter Central Society. Not responding to the application made by the petitioner for being a member. The petitioner filed writ petition civil 20061 of 2022, seeking a direction to the Central Society to accept the petitioner as a member. Full stop. According to the petitioner, with no decision having been taken by the Central Society on the petitioner's application submitted on 5th July 2019 for over 90 days, the petitioner should be deemed to be a member of the Central Society. Paragraph. The learned single judge noted that the petitioner had moved the Registrar of Cooperative Societies under Section 68 of the Cooperative Societies Act. This is the Odisha Cooperative Societies Act.
My lord.
With dispute case number 103 of 2022. Stop. However, the said case was withdrawn before the registrar with permission to approach the High Court. Full stop. Paragraph. Before the learned single judge, it was submitted that the petitioner had filed a second application on 3rd June 2022. Full stop. Taking note of this, the learned single judge declined to entertain the writ petition. Paragraph. Today, Ms. Mahapatra informs the court that the second application, in fact, was only a reminder and not a separate application. Full stop. Thus, it appears that the petitioner may have been rendered remediless with neither the single judge entertaining the writ petition nor the petitioner's application under Section 68 of the Act pending before the Registrar Cooperative Societies. Full stop. Paragraph. In the circumstances, this court clarifies that notwithstanding the impugned order of the learned single judge declining to entertain the writ petition, the petitioner cannot be rendered remediless, and therefore dispute case number 103 of 2022 filed by the petitioner before the Registrar Cooperative Societies under Section 68 of the Act shall stand revived, notwithstanding the earlier order dismissing it as withdrawn to enable the appellant to approach the High Court. Full stop. The dispute case number 103 of 2022 will now be listed before the Registrar Cooperative Societies on 1st May 2023 for further proceedings.
May I pray, my lord, a time bound to...
It will be open to the appellant to request the registrar to expedite the hearing of the said case. The writ appeal is disposed of in the above terms. Second matter?
Second matter, my lord, I have approached the Development Authority and a unauthorized case was instituted, my lord. Because no steps have been taken by the Development Authority, I have approached this Honorable Court for him issuance of mandamus to conclude or take steps for the conclusion of that UD case, my lord.
UAP case.
UAD case.
All right.
But
the short grievance, the present petition is that the officer on special duty under the Orissa Development Authorities Act is not proceeding with the appellant's UAP case number 57 of 2021, complaining of unauthorized construction by respondents 5 and 6. Full stop. The learned single judge you also filed a civil suit.
Well, that is a suit between the brother and sister for declaration the sale is void, my lord.
I see.
So far
The
as
single judge noted that there was a civil suit number 1477 of 2021
no nexus with unauthorized.
pending in the court of the Civil Judge Senior Division, Bhubaneswar. And therefore, the appellants should seek further remedies in the said suit. Paragraph. It is pointed out to this court that the said civil suit number 1477 of 2021 is between siblings concerning the respective shares of the suit property and has nothing to do with the issue of encroachment by third parties. Full stop. Since it is an entirely separate cause of action, it need not come in the way of the decision in UAP case number 57 of 2021. But the notice will have to go on this, no?
I pray, my lord, your lordship may kindly direct the opposite party number 4.
No, but notice will have to go to 5 and 6. You just say notice, he accepts notice for opposite parties 1 and 2. Notice will be issued to the remaining respondents through elected speed post returnable on the next date. Yes, sir. 9th May. You just say right in the beginning. Since counsel for the appellant is the same counsel who appeared in the writ petition for the petitioner, the wakalat already filed be taken on record and the defect be ignored. Right.
Item 53. Item number 53.
None appears dismissed.
53. Item number 54. 54 rehabilitation assistance scheme.
30th August.
30th August. Item number 55.
Visual lordship. The order of the Honorable Single Judge as Annexure 5 is under challenge as page 56 make a glance. On the date of admission, the writ has been dismissed on the holding that the original alloty has not been taken in steps. So the present writ petition at the instance of this third party purchaser is not maintainable. Lordship may kindly, I am there placing the order, page 56.
Yes. So the person you purchased from
2000
failed to give an undertaking that she does not have any other allowance.
Yes, that undertaking may then your lordship may kind of glance the report of the tax force, the relevant portion at page 49 may kind of glance. Last part, the observation of the task force. Because there is observation, they have to file an undertaking that no other house or building within the municipal area. Then your lordship, last part, page 9, under the above fact and circumstances, coming to the merit of this reference, it is held that being the original allotee, Srimati Bharati Mishra, from which I have purchased, was the multiple allotee reported by the task force in his report to serial number 60 in annexure IA. And in the meanwhile, she is not the picture in the basis of the transfer of the multiple assets to other by help of some officials. So the assets now exist in the name of both husband and wife, may not be treated as multiple assets with a family as per the eligibility criteria of the said brochure. So observation tax force that the allotment in my favor should not be treated as a multiple assets. Because your lordship make the criteria involved, the brochure involved, your lordship make a glance. The brochure has page 59. The 59, it is a village of Mauja Subudhipur.
Then your lordship page 64, the eligibility criteria.
All right, you just say notice. Mr. Mohanty accepts notice for respond number 1, notice to the remaining respondents. Registered speed post returnable on the next day. List on 16th May.
The status quo at least they are now.
I think so. Correct.
Item 56. Item 56. Some legible copies I have to file my lord. Only 2 weeks time may be granted to remove the defect.
List on 10th April. Sorry, list on 19th April. Defects be cured in the
Item number 57.
Item 57, my lord, some defects were pointed out. So the matter is the respondents 1, 2, 3 have
before I'm seeking your lordship's permission. Before my learned friend begins, but the second appeal on the basis of which this judgment has been passed, that against that second appeal they preferred SLP before the Honorable Supreme Court and it has been dismissed.
So what remains, sir?
My humble submission will be, my lord, that second appeal may not have any bearing on the
No, but
present.
the impugned order seems to think there is.
In the impugned order, my lord, the Honorable Single Judge has said so. But then my humble submission is, the suit has been, this is a separate suit filed by respondents, separate writ petition filed by respondents 1, 2, 3 for release of some postal deposits. Some deposits are in the name of the association, and for specified purposes, the deposits are there. Then the suit out of which the second appeal arose, which my land senior from my friend is relying on, is with regard to issuance of identity cards, Parichaya Patra, by a Katak association. It's not about the apex body.
No, they have succeeded in the suit.
Suit is relating to issuance of identity cards. This is a matter, directly they have come in a writ petition for permission to release the deposits in their favor.
Even identity cards, ultimately, who's entitled to it will be the same.
Just if you'll also give me 2 minutes, there is an apex body. There are different branches throughout the state. In the apex body, there was an election and there was a dispute came and 2 fractions, 2 groups quarreled as to who will be the president and secretary.
Correct.
One group has filed a suit. It is there, respondents have filed a suit before the sub-judge Puri. When the suit was pending, another suit was filed against a branch office at Cuttack. The branch office, what the grievance there is, when the election dispute is pending there.
Where is that decree in the second appeal? You have a copy? Then we'll know the scope of that suit.
Well, the Honorable Single Judge in the impugned judgment has also held.
No. Oh, the same single judge dealt with the second appeal also.
Yes. But you'll also kindly have a glance at page 20. 20 starts with paragraph 3. At page relevant portion is at page 21. Internal page 7 of the impugned order. The judgment, should I place it?
Yes.
The judgment and decree passable and first additional discharge was upheld, whereby the suit of the plaintiffs was decreed with a declaration that the defendant number 1 has no legal authority or right to sign or issue Parichaya Patra, identity card,
as president of the Sakha Sangha. Sakha, if your lords permit me, Sakha means a branch. Sakha Sangha, and he was restrained to interfere with the smooth management of the Sakha Sangha. The dispute is in the suit, which went up to second appeal and even up to the apex court, is whether a particular person can issue identity cards.
No, not just that, sir.
Yes.
Just see the findings, page 14 and 15, trial court findings.
Right. That your lordships are referring to that second appeal.
Judgment, second appeal judgment. You come to page 15 internally. Five, 6 and all is directly affecting you. Election of defendant number 1 is null and void. Defendant number 1 is not the real president.
That was decided in my absence.
That's different. So you filed the SLP dismissed. That's the end of the matter.
It's a very interesting suit, my lord, where both parties together are working even till today. But the dispute is with regard to the following the religious formalities. Administration, there is no dispute. They together are working even till today. In fact, an application under section 89 was filed. 89 CPC was filed to refer the matter for settlement, because likely to settle. Then Honorable Single Judge, during pendency of the second appeal, Honorable Single Judge said, now that the suit appeal has been heard and we are at the verge of delivering a judgment, at this stage such an application is not maintainable. No finding that there is no jointly working and other things.
But now this has been affirmed in the Supreme Court. Yes. Then we can't really go behind that.
Well, that is on record. I can't say. Can I say that anything else other than that? Except arguing that the scope of that suit, even upheld up to the Supreme Court, is different than the scope of the present suit. Here, your lords will kindly appreciate one thing. Several deposits were there. Deposits were meant for definite purposes. Each of the deposit is for a definite purpose. It was there. A body who is saying that they are elected to the apex body want to withdraw that money.
Who else can withdraw, sir? All these bodies,
they're not capable of.
Bearers are the ones who can operate the accounts.
They are not capable of being withdrawn. But my submission is, for a specified purpose, it is endowed, and therefore it has to be kept like that. If once they withdraw that money, and postal authority have said that unless you get
not withdraw so much as the operate the bank account. Basically, that's what it means. Only an elected body can operate a bank account of a Sangha.
The elected body can operate running accounts. Absolutely, there is no problem.
The prayer is only that. Come to page 16. Prayer is, why should they not be allowed to operate the postal savings bank's accounts?
Savings bank account, they can operate. That's all right,
That's the prayer. Page 16.
I have not got that copy. Anyway.
No, your own paper book. Forget I'm on your paper book.
Yes.
Page 16.
Page 16.
Impugned order. Prayers are set out.
Yes, madam. Shall not be, yes, madam. Allowed to operate postal savings bank account. Referred to in Annexure 4 and 9 series.
That's all. So naturally, if they are the elected body, they can operate. That has been affirmed now.
My humble submission is the suit which they have filed, because based on this finding, they have withdrawn the suit. They have taken the risk. I will not say anything there. But there is actually another suit which is pending in Puri, CS 339 of 2004, as to who will operate the postal accounts. When that issue is pending, in an ancillary suit, if somebody
petition file
identity card shortcut method, and somebody saying that he cannot issue identity card, that will be binding on us, and that suit will become infructuous. And the suit where the evidence will come and the nature of deposits will be decided.
Pending.
Yes, ma'am.
On the same issue.
339 of 2004.
Lord, that is not what my learned friend is submitting before your lordship. Lord, 3 suits were filed. Admittedly, 3 suits were filed. One at Puri, one at Cuttack, and one at Balasore.
So this is Cuttack.
This is Cuttack. What happened in the suit? What is the relief
once there was a case before me, said Lord Jagannath Mahaprabhu versus Lord Jagannath Mahaprabhu.
Yes, Lord.
Then I said there must be something wrong in the cost rating. They said, no. Lord Jagannath Mahaprabhu Puri versus Lord Jagannath Mahaprabhu Anugul. So apparently there's another temple there.
Yes.
So,
But I am
So there's no-
Lordship for your Lordship appreciation. Lord, nothing has to be decided. Why I am saying so, Lord? Lord, there is a split in 1989. One group claimed that the real office bearer of the Sangha, and they hold an election at Birtung. One group hold election at Balasore. And on that basis, Lord, both the groups claim that we are the real Nilachal Saraswat Sangha. There is some transaction and identity card issued. So therefore, ultimately the question remains, who is the real body? So therefore, in this suit, Lord, it was decided that the Balasore group, which has been elected, the governing body which was elected at Balasore, they are the real governing body, and this body has no authority to issue the identity card. So therefore, the question of election was decided. And when the suit was pending, Lord, and Balasore suit was decided first, thereafter the second appeal preferred before this honorable court, Lord. Second appeal dismissed, then went to the Supreme Court, Lord. Supreme Court, the SLP dismissed, Lord. So the argument was advanced in this suit, Lord.
So you're 2-0. You're one Baleshwar, you one Cuttack. The only Puri is left.
Argument was advanced before why they have withdrawn the Puri suit. essentially that since that is not a representative character suit, see the judgment which was passed in that suit, that is not binding up against us.
Not in rem.
Yes, Lord. So this suit was the order 1 rule 8 was complied. Thereafter, both the courts hold that the Balasore election is valid, and the office bearers who are elected at Balasore, they are the real office bearers. At that time, the writ petition was filed, Lord. And your Lordship can see.
No, now you'll agree that the Puri suit is infructuous.
Infructuous. We have withdrawn that suit.
When did you withdraw?
Lord, we have withdrawn just after the judgment was passed in the second.
See, you didn't inform Mr. Rao. He thinks it's still pending.
Lord, I am talking of another suit, Lord. They have filed. No. He is talking of TS 46 of 89. I am talking of TS 339 of 2004. That is pending. This suit is only meant for
filed by him.
No, this is by me. This is a suit 2004. That's pending.
That you pursue.
For what it's what I'm saying is this is a suit which is directly connected to this present writ petition because
And your Lordship kindly see.
because there the issue is to be decided who will be entitled to withdraw the money.
Lord, when the registered body is the party in this suit, Lord, whatever decision has been taken, that is binding against all the members.
Correct.
That is a judgment in rem so far as these members are concerned.
Correct.
My suit on the same subject matter is pending, as your lordships have rightly used the word. For a shortcut method, they have come here.
I am placing before your Lordship, since 2 senior advocates were appeared at this stage of admission of the SLP, the Honorable Supreme Court heard this matter 20 minutes, Lord, at the stage of admission of the SLP.
That itself is an indication that there is a point in it.
And thereafter, the appeal was dismissed.
All right. There's nothing.
Your Lordship may give some observation with regard to my pendency of the suit. Otherwise, if this is...
that will be decided on its merits.
Your Lordship may say that otherwise, because the writ petition is dismissed, then they will go there and say that the suit will have to be dismissed. I will say so.
Anyway, he will say that.
He will say it, but if your Lordship give an observation, ultimately, if I permitted to use a correct word, the battle will not end, my lord. A war may end by this. So the battle should end ultimately. So even at this stage, your lordships can invoke section 89 and call both the parties and decide the matter. And no issue. At least there is no dispute that they are together working. Because section 89 says where there is a possibility. It's not that there should be a compromise.
But so far as that question is concerned, that order was challenged before the Honorable Supreme Court. That's the order passed by this Honorable Court in section 89. That has also been dismissed.
All right.
In Supreme Court dismissal, I can't comment upon it, but your Lordship knows it. You're coming from that place.
This is a dispute between two factions of the Neelachala Saraswata Sangha.
Yes, Saraswata
Sangha. a religious institution espousing the ideology of Sri Sri Thakur. Stop. Apparently, the Sangha has its branches in several places in Odisha. Stop. As far as the dispute between the two factions, for convenience will be referred to as the appellant faction and the respondent faction. The respondent faction appeared to have succeeded in disputes raised within the jurisdiction of the courts, of the civil courts at Baleshwar and Cuttack, the results of which, with the dismissal of specially petitions by the appellant faction, have affirmed that the respondent faction is the duly elected body of the Sangha. Paragraph. The present dispute concerns the right to operate the postal savings banks accounts and banks accounts of the Sangha. Stop. Even while the civil suit OS number 46 of 1989 filed by the respondent Sangha, faction was pending in the court of the additional civil judge, Senior Division Puri, the respondent faction also filed OJC number 834 of 2000 in this 8314 of 2000 in this court. Paragraph. Meanwhile, the dispute that arose within the jurisdiction of the district judge Cuttack ended in favor of the respondent faction by the judgment delivered by this court on 20th September 2022 in RSA 254 of 2004. Stop. Inter alia, the findings of the trial court in the said dispute that the respondent faction were the duly elected body of the Sangha was accepted. Full stop. On the basis of the said judgment in RSA number 254 of 2004, the learned single judge has, in the impugned judgment, while allowing OJC number 8314 of 2000, permitted the respondent faction to operate the postal savings accounts and the accounts of the Sangha. Full stop. The appellant faction, agreed by that order, is before this court. Full stop. In the meanwhile, the Supreme Court has, on 13th March 2023, dismissed SLP civil diary numbers 37582 of 2022, thereby affirming the judgment dated 20 September 2022 in RSA number 254 of 2004. So thereby, for the second time, the respondent faction has been recognized as the duly elected body of the Sangha. Paragraph. Mr. Nirod Sahul, learned counsel appearing for the respondent faction, further informs the court that the respondent faction has withdrawn OS number 46 of 1989, which was pending in the court of the additional civil judge, Senior Division Puri. A copy of the order dated 22nd February 2023, passed by that court, accepting the withdrawal of the suit, has been placed on record. Paragraph. With the respondent faction now being recognized twice over as the duly elected body of the Sangha, the impugned judgment of the learned single judge allowing OJC number 8314 of 2000 cannot be faulted. Paragraph. Mr. Rao, and counsel appearing for the appellants, states that the appellant faction has filed yet another suit being
CS 339 of 2004.
CS 339 of 2004 in the court of the civil judge Senior Division
at Puri.
At Puri. And that the subject matter of the said suit is the same, namely, which faction is entitled to operate the accounts of the Sangha. Paragraph. since the said suit is pending, it will obviously be decided on its merits by the court concerned. Full stop. With the above observations, the present appeal is dismissed.
Item 58.
My lord, in this case, inadvertently the appellant filed this case instead of a review petition, my lord. So
you want to withdraw it?
My lord, with liberty to file a review petition.
All right. Counsel for the appellant seeks leave to withdraw the presented appeal with liberty to file a review petition before the single judge. Before the review petition disposed of as withdrawn with liberty is paid for. Right.
59. Item 59.
None appears dismissed.
Madam, 59, the Lordship has fixed it to similar matters to 4th April.
4th April.
Madam.
Okay. This is after notice.
Madam, no. In that case, the Lordship has directed that respondents to file their document relating to that graduate school certificate. That is WA number 1296 of 2022.
All right. Notice returnable 4th April list along with WA number
1296 of 2022.
All right. 1296 of 22.
Item number 60.
My lord. May I please, madam? In this case, my lord, the petitioner, the appellant challenged the order under Annexure 1, my lord, passed by this honorable court. My lord, in this case, my lord, the respondent unauthorized absent for 6 years, my lord. Thereafter, my lord, we removed from him from service, my lord. He has challenged that order before the learned single judge, and that has been quashed by the learned single judge, my lord. My lord, only we invoked in Rule 72, 1 and 2. My lord, your lordship may see internal page 10 that has been quoted by the honorable single judge, my lord.
Nothing. He's neither reinstated nor given back wages, sir. Nothing. No relief. Only he's get his pension. That's all.
My lord, only pension, my lord, calculating from 2002, my lord.
Correct. Why not?
My lord, because, my lord, he has overstayed with remain.
No, the process is not followed, sir.
Process, my lord, the honorable single judge held that the process has not been followed, my lord.
Correct.
But we have relied the two judgment of honorable apex court, my lord. Syndicate Bank versus General Secretary, Syndicate Bank Staff Association, and another reported in AR 2000 Supreme Court 2198, my lord. And another case is Ali.
No. What is that case about?
He remains absent for more than 5 years.
But you have to hold an inquiry. That is about what punishment can be granted. That's it. It does not excuse you from following the procedure. Admittedly, the respondent was removed from service without actually holding a disciplinary proceedings in terms of the provisions of the Orissa Civil Service. What does CCA stand for? CCA, right? Classification, Conduct and Appeal Rules. Which was mandatory in terms of Rule 72(2) thereof. During the pendency of the writ petition, the respondent attained the age of superannuation. Full stop. The charge that he was unauthorizedly absent from 16th March 2002, unauthorized absent for 5 years, was actually not established in an inquiry. Full stop. In the circumstances, the learned single judge has held that his termination with effect from
27/6/2008.
no. Acha. 7th June 2008 was bad in law. Full stop. Paragraph. Taking note of the fact that the appellant the respondent did not render any service after 16th March 2002, the learned single judge has declined to grant any financial benefit from that date till the date of superannuation. Also, the question of reinstatement also did not arise. Full stop. The only limited relief was that the respondent should be paid his pension and other retirement benefits. Paragraph. Learned counsel for the appellant sought to rely on the judgments in Devki Nandan Prasad. Sorry. Syndicate Bank versus General Secretary. Syndicate Bank Staff Association, AIR 2000 SC 2198. And Aligarh Muslim University versus Mansoor Ali Khan, AIR 2000 SC 2783. To urge that the punishment of removal from service was justified on account of the unauthorized absence of the respondent for over 5 years. Paragraph. The above submission overlooks the fact that the mandatory inquiry that was to be held prior to such removal was not fulfilled in the present case. In that view of the matter, the decision of the Supreme Court in Devki Nandan Prasad versus State of Bihar, AIR 1971 SC 1409, and of this court in Kishori Das versus State of Orissa 2008 105 CLT 309 would apply. Paragraph. The court is unable to find any error having been committed by the learned single judge in passing the infant order. The appeal is accordingly dismissed.
Item 61.
My lord, state is the appellant. The Honorable Single Judge has granted ex gratia of rupees 4 lakhs on the ground that there is a mishap death due to heavy rainfall and wind. And that was negatived by by the certificate granted by the authority that there was no rainfall on that day. And 4 lakhs rupees has been granted, and that is under. That information collected from Odisha rainfall monitoring system that there was no rainfall in Daspala area or Nayagad district on that particular date. Hence, occurrence of whirlwind in Daspala area on that day is not a fact. That is the finding of the Tahsildar. He was working in a foreign liquor shop, and due to sudden accident, the asbestos fall down on his death and he died. That is 4 lakhs rupees.
What is your ex gratia amount usually?
4 lakhs rupees, awarded 4 lakhs.
No. What is your state policy on ex gratia?
That if there is any yes, your lordship may see paragraph
The compensation payable is 4 lakhs, sir.
4 lakhs.
Ah.
Recently, your lordship has dismissed one. And
The
interest part may kindly be waived.
All right. No, but why in his absence? For that, we'll have to issue notice to him. 5% interest is nothing, sir. You see, the
Recently,
present
your
appeal is
lordship has
directed
dismissed
against
similar case passed by the same honorable single judge. That ex gratia.
the impugned order of the learned single judge allows the writ petition filed by the respondent, whose son died as a result of whose son, who was working in an off shop, died as a result of the roof of the shop falling on his head and causing a fatal injury. Full stop. Paragraph. The issue was whether the roof fell as a result of a cyclonic storm on the relevant date. Full stop. Although the police report indicated that it was so, an inquiry conducted by the Tahsildar pursuant to an order passed by this court in writ petition civil 2903 of 2020 appeared to suggest that the death was accidental and not on account of a natural catastrophe or disaster. Paragraph. The learned single judge, on analyzing the report of the Tahsildar as well as the earlier FIR, came to the conclusion that the cause for the asbestos sheet to fall on the victim's head was indeed a cyclonic storm. Paragraph. The ex gratia amount in terms of the government's own circulars in such an instance would be rupees 4 lakhs, which is what has been ordered to be paid by the learned single judge, together with simple interest at 5% per annum from only the date of the writ petition, that is 19th March 2021. Paragraph. Having heard Mr. Mohanty, learned AGA, and having perused the documents and record, the court is not inclined to interfere with the impugned order. Full stop. The view taken by the learned single judge is a plausible one in the facts of the case. Full stop. Even the interest amount has been restricted to a period of less than 2 years and a nominal rate of 5% simple interest. Full stop. Keeping in view all the above factors, the court is not inclined to interfere. Full stop. Okay. It is clarified, however, that the impugned order of the learned single judge has been passed in the peculiar facts of the case and would not constitute a precedent. The writ appeal is dismissed with the above observations.
Item 62.
May I please, Your Worship? Today I have filed petition for condonation of delay, that is IA number minor 1628 by 23.
COVID period.
My lord, 22 days delay.
Or delays condoned.
My lord.
Taken on board, delay condoned.
Similar matters, sir.
Similar matter as pending before this honorable court for adjudication.
6 similar matters are there.
There is judgment.
Okay. List along with writ appeal number 1256 of 2022.
Other matters are there. I am giving that number.
On which date?
That has been urgent. No date has been fixed.
Oh.
I am giving that 6 numbers.
Last date was 1912, my lord. But not listed, my lord.
Lordship, I remember that case, that selection of in respect of Jagatsinghpur district. Honorable single judge has found that selection is irregular and accordingly quashed that. And Your Lordship, on that occasion, Your Lordship directed to prepare a select list, keep it in seal cover.
Correct. 5th July.
My lord.
5th July. Right. Along with all of this.
Item 63.
May I please, Your Lordship? My lord, I am busy, my lord.
Yes.
Order of the London single judge, page 43, my lord. Page 43. The petitioner filed this writ petition seeking direction to the opposite parties to accept the joining report of the petitioner and to allow him to continue as a constable at Bounce Police Station both, having heard the London counsel for the party.
No reasons. No reasons given.
Yes, my lord, my lord. But only limited by the acceptance of my joining report, my lord.
This can go back, sir. No reasons given. Just a one line dismissal. You say notice, he accepts notice. The impugned order reads as under. Reproduce the whole order. It is very plain that the impugned order is an non-reasoned one. And therefore, on that sharp ground, it cannot be sustained in law. It is accordingly hereby set aside. WPC OA number 1469 of 2019 is restored to the file of the learned single judge for being listed there on July 12th, 2023. Reply to the were pleadings complete?
No, my lord. No, my lord. Control not filed till near my lord.
All right. The respondent state will file its reply to the said writ petition. Paravest reply to the said writ petition not later than 3rd July, and rejoinder thereto any by the present appellant would be filed on or before 12th July. No further time will be granted to either party for that purpose. The learned single judge is requested to proceed with the writ petition on merits and dispose it of as expeditiously as possible. The writ appeal is disposed of in the above terms. Right.
Item 64.
Where are you appearing from, sir? Bhubaneswar. Achha. All right. All right.
Item 64.
64.
Yes.
Lord, that matter, Lord, ad hoc promotion during the pendency of the vigilance proceeding.
Right.
And your lordship disposed of the all the matters yesterday.
Yes.
That is item 63, my lord.
Right. This is what? This goes with the 27 June, I think. List on 27 June. This is after notice, correct?
Here, my lord, no notice has been issued.
No notice has been issued. Oh, sorry. You say notice returnable 6th July. Stay till then. All right.
Item 65.
65, 66, same, my lord, but notice has not been issued.
So same, 6th July.
65 and 66. Item 67. 67, my lord, is regarding that grant of TBA. What has happened with that?
1 minute, you are not the appellant, sir. 68 is somebody.
67.
67. Oh, sorry. 67. All right.
The only dispute, my lord, he has been upgraded with a financial upgradation. So that has not been taken into account. So that date of initial appointment has been taken into account for the purpose of granting TBA. So that our notification is that if one is upgraded to a higher scale, so that from that date 15 years will be calculated. May I draw my lord's notice that we have annexed that notification at page 51.
This is a new batch which will start, is it, with today? A whole batch will start now. All right. It's a notice returnable. July. 12th July. Stay till then.
68.
May I please, I have filed a petition for disciplinary certificate, my lord. I have filed a petition for disciplinary certificate because the judgment has order has been passed by the Lord single judge. Batch of cases get tagged together without notice to us, the order has been passed. So I have not collected the certificate copy. In other cases, certificate has been filed. So therefore, I have filed a petition for disciplinary certificate copy.
All right, that's dispensed with. No notice was issued to you when the impugned order was passed.
My lord.
All right, notice returnable. 11 July. No, sorry, 12th July only. 12th.
68 copy, maybe, sir.
Serve a copy. Notice, no, he accepts notice on behalf of. What about the original writ petitioner? They have not made a party. The original writ petitioner was who?
We are appellant tribunal. I am the petitioner and the tribunal. Straight up after the review petition, in the review they have passed another order. That is not a challenge. And in the review, no notice to us. Review held by state, my lord.
You withdrew it in the Supreme Court with liberty to file a review.
No, in this, no, not in this case, my lord.
Some other case.
Some other case. That represent again the lordship dismissed by division bench. And confirmed on appeals court. Despite that, without notice to the revision allowed. My lord, single judge.
But it says for the parties are present.
Present in, there is a batch of cases. 2 to 3 cases on notices. All the cases tagged to the order passed. And I am the petitioner, my husband expired. My husband is the petitioner. No notice to me, they have
All right. He accepts notice for the response. All right.
My lord.
Same date.
My lord. All right, my lord.
Item number 69.
Item 69, there are a number of defects, my lord. I will rectify them. What has happened, there is a batch of cases. I am giving the list, my lord. About 50 matters are there. The point involved is same. There is a regulation of the appellant Board of Secondary Education, which says that a person, the retirement age of the person is 60 years, but the board will pay the pension up to the age of 58 years. That was the regulation, taking the consent. That was, everybody was working and that was being followed. Suddenly what has happened? Some of the employees challenged the, in a writ petition, 2-3 persons have filed writ petitions to quash that regulation. That regulation was not quashed by this Honorable Court. On the other hand, this Honorable Court has said, you go and approach the authorities, they will consider. But as the laxity will have, they have not considered it within time. Therefore, some contempt petitions were filed. Under pressure, they had to pay money for those 2-3 persons.
That became the precedent.
That became a precedent, and becoming accepting that negative equality, so many writ petitions have come. And those writ petitions, nearly 50 writ petitions came after some people have retired after 20 years, some people 15 years,
So
like
parity,
and they have all come. And these
they're all 80 years old now.
Then what has happened?
I'm sure this Arun Kumar Dev must be 80 years old.
It might be.
Why invite him to the High Court? It's not a very nice place, sir. At this age, why should we invite him here?
No. What I'm trying to submit is, your lordships may list those matters, all the matters which I'm giving. I will serve copies on the council appearing in the writ petitions.
That council, that they start chasing all these 80-year-olds and say, now give me fees.
Well, the problem is not that. Your lordships will kindly see, so far the present writ petition is concerned.
You deposit costs of litigation.
That your lordships will say that, my lord, what I'm saying is, in the present writ appeal which has come before your lordships, the virus of article, that regulation was challenged. Once the virus has been challenged, the Honorable Single Judge could not have taken it up. It should be a matter for the division bench. That is one point. The second point is the earlier batch of cases which came before this Honorable Court that went to Supreme Court. Honorable Supreme Court kept the law open, and direct payment was already made, so that was not recovered.
But why are you denying when they're working for you till they're 60 years?
Well, there are 3 submissions, mine. Number 1 is that these people are fence sitters. They have...
No. I'm on the main issue. You say...
Yes. I'll get the point. Well, my submission will be like this. Board of Secondary Education was having the retirement age of 60 years. They were not having pension.
The certified copy is not there. Copy of the judgment itself is not there. You filed writ appeal without copy of judgment.
I will file them. I'll file it.
How did you draft it?
Well, there are batch of writ petitions in singular.
Some other batch you filed that copy.
Yes.
In a single... How many more are that like this? Wow. No peace of mind for these all these respondents.
Well, what has happened? There was no pension rule so far as the appellant association.
Anyway, you file that certified copy.
Yes, ma'am.
But what about all these? These are all in defect, is it?
Some defects are there. I will remove all those defects. You will also fix up a date. So that it can be once for all decided, my lord. There need not, as your lordship has said,
Nothing happens once for all.
Nobody
As
needs
long
to
as
be
nothing is once for all.
nobody. What I'm saying is nobody need to be in tension. My submissions will be number one, delay. Number two, monetary benefit, at least 3 years benefit they can take. The third point will be that knowing fully well, they have come and accepted on their consent only the pension scheme was introduced. Because then the state government was having the retirement age of 58 years. We were having 60 years. Therefore, it is said, you work for 60 years. Since pension scheme is accepted, pension will be calculated at 58 years. Now, in the changed circumstance, state has also made it 60 years.
Correct.
So therefore, this was also withdrawn. But it is during that period.
So you're offering us a temptation that so much we can dispose of on fund. All right. You say list on. Pick up the leanest of the days. 24th July, along with all the 47 matters, defects and all the matters be cured by then. All right.
24th July.
Item 70.
70 is also same.
Item number 70.
Same. So you put both the numbers together. You see list on.
Item 71.
May I please? The order of the Honorable Single Judge. And we were the teachers under the municipality high schools. The schools and our services were transferred to education department by notification of the government in 28/2/2004. Services were regularized since 2004.
What about this Harapriya Patra?
Harapriya Patra relates to regularization where I have no dispute, my lord. Rather, my case is covered by a division bench decision of this court in Shankar Sanapal. I had given that reference to the court master.
All right. Counsel for the appellant submits that the appellant's case is not covered by the decision in Harapriya Patra versus State of Orissa, bracket, WP Civil, OAC number 2709 of 2016, dated 25th August 2022. But by the decision of the division bench of this court in
2017 supplementary 1 OLR 951.
What's the cause title?
Cause title State of Odisha and others versus Shankar Sanapal and others.
Shankar Sanapal and others. Say notice, he accepts notice for opposite parties of the respondents. School and mass education?
Yes.
Or this 2nd August.
72.
72, your lordship has issued notice.
Already.
I'm for respondent number 1, Miller.
You are in person?
In person. I pay for some time to reply me.
Well, there's no reply, it's a writ appeal. What's the matter about?
Kindly tag up one contempt number 6131. 2 contempt there, 1 pending, 1 disposed of. Contempt 6131 may club up.
Your lordship, my lord's order 19/1/2023.
Two contempts is there. 1 contempt pending, 1 disposed of. I prefer 1 contempt 6131 of 2020 may club up.
Why we filed this writ appeal? You only to take a decision on his
That scheme is not continuing. That is the whole problem. I have gone through. So I have every sympathy for that man, but scheme is not continuing.
No, but only to take a decision on his claim, that's all.
Your Lordship, paragraph 8.
Read it.
Yes, madam. That in view of the sum made by Mr. The court find that against 2 persons recommended by letter, the person that said though has engaged a legal assistant lawyer in Bancho Panchayat, but the said person has already tendered his resignation and it has been accepted. Therefore, in view of such factors, the disposed of with the directive to take appropriate action with regard to engagement of the petitioner against the post.
That's all. With regard to the engagement. That's all.
That
the said opposite party shall take a decision.
So that's
you take a decision. That's all. The impugned order only requires the appellant open quotation take a decision of the petitioner's claim within a period of 1 month from the date of receipt of this order. Unquote. The impugned order does not direct the appellant to take a decision one way or the other. In that view of the matter, the court sees no reason why it should entertain the present writ appeal, which is accordingly dismissed.
73.
73, my lord. This is the impugned order at page 17. That he was dismissed, removed from service in a duly constituted departmental proceeding. But were dismissed, removed from service in the year 1997. It referred appeal that was rejected in 2001. So he approached the tribunal after 10 years in 2010, my lord. And the Honorable Single Judge has he remained absent during the course of inquiry. And the Honorable Single Judge has quashed that punishment and directed him to grant all the benefits.
He was suffering from a psychiatric problem.
That ground he has not taken before the inquiry officer, nothing. He remained absent, and it's a higher service department, is the emergency department. And not for that day, previous, it is recorded as a habitual absent, unauthorized absent. And you will see paragraph 9 of that, paragraph page 25.
All right, notice returnable. 2nd August, stay of the impugned order till then.
74.
DC.
Yes.
It has been pointed out that delay content petition has not been filed. Today I'm filing before the Honorable Court. A delay of 65 days. I'm filing today in the court.
I see. We have the copy. Actually, it does not come on record, sir.
Today I'm filing before the court.
All right. Counsel for the appellant states that he has today filed an application for condition of delay. It be brought on record.
It's already.
The impugned order says
Yes, the impugned order is a Norotoma case. The impugned order says the writ is due to belatedness. The writ was filed in a belated stage.
Yes.
Inherent delay, 9 years delay. That is what the Honorable Single.
Thing is, 2018, I got a certified copy of the order of not an age. In 2022, I filed the writ. That only because of that 4 years, the writ has been dismissed. In 2018, I got the certified copy of not an age. Thereafter, I gathered some documents. In 2020 and 21,
no, but still 4 years had to be explained, sir.
So 2020 and 21, these 2 years of the judicial body was not functioning as it was due to COVID-19.
No. 18, you got the certified copy.
I'm disputing 18.
No.
18, 19, time was consumed gathering the documents.
No. Sorry, sorry.
The rate receipt, the ASO order, the sendings, the RWAR, many things were there.
I know, sir, but everything in good time. Everything in good time. You say the impugned order has rejected, by the impugned order, the learned single judge has rejected the writ petition filed in September 2022, questioning an order passed by the assistant settlement officer way back in 2013. Full stop. Paragraph. In trying to explain the delay, the appellant sought to suggest that he had obtained a certified copy of the order under challenge only in September 2018. Full stop. That still did not explain the delay of 4 years in approaching the High Court. It is then suggested that due to the COVID pandemic, that period should be excluded for the purposes of computing limitation. Full stop. Even if that is excluded, there is still a delay of well over 15 months, which again remains unexplained. Paragraph. The net result is there is no satisfactory explanation for the delay in laches in preferring the writ petition. Consequently, the court finds no reason to interfere with the impugned order of the non-single judge. Writ appeal is dismissed.
75.
May I please, Your Lordship?
Yes.
Here I will humbly pray, Your Lordship may kindly consider the delay for the reason, my Lord, so far as the main writ appeal is concerned, it involves a question of law which has been decided by the Honorable Single Judge as to whether a government pleader can be allowed in terms of Rule 14D of the Orissa Law Officers Rule 1971 to conduct cases where he has no role to play on behalf of the government. Now, it has been interpreted to say that he can only be permitted to conduct a single case out of the cases he had requested to be allowed, which is outside the district, not the cases which are within the district. May Your Lordship will kindly see this appellant with Your Lordship. May my Lord, with Your Lordship's kind permission, place the fact of the case for Your Lordship's kind.
Why is this so important? Why is this one case that you want to defend?
No, my Lord, what has happened, I had given it, may I just, with Your Lordship's kind permission, place few lines for Your Lordship's consideration. He was initially engaged as a government pleader. My Lord, so far the law officers rule is concerned, it makes a distinction between the public prosecutor and a government pleader. Government pleader deals with the civil cases, whereas the public prosecutor deals with the criminal cases. Now, my Lord, limitation is provided for in Rule 14 with regard to conducting cases. It says, with the permission of the collector, the concerned counsel who has received briefs prior to his engagement as a government pleader or public prosecutor
can continue those cases.
My Lord, much obliged, my Lord. Now, here is the case where initially he was engaged in 2016. He sought for permission to conduct cases which he had received prior to 2016. That was allowed in terms of 14D of the Rule 71. Now, subsequently, he resigned. He was again engaged as a government pleader who deals with the civil cases on behalf of the government and defense. Now, he furnished a fresh list of cases which he was engaged in the meanwhile. It was more than 1 year. He was not the government pleader. To be permitted to conduct those cases which are essentially criminal cases and other cases which are no way affecting his performance as a government pleader.
No, but he will be arguing against the government in the criminal cases.
Those cases are permitted to. I beg to demonstrate that from the rule itself, Your Lordship will see. May I just, with Your Lordship's kind permission, place Rule 14 itself. And my Lord, one thing I beg to emphasize upon is that he was allowed to. My Lord, in the previous case, I am not taking it as a precedent to say that he should be allowed always, but it is provided in the rule. And rule makes a distinction with regard to a public prosecutor and a government pleader. Here, my Lord, so far as this petition of Your Lordship is concerned, he is a government pleader. May I just, with Your Lordship's permission, place Rule 14, my Lord?
Yeah, it's quoted, para 10.
May I just place it, my Lord?
Yes, yes.
Limitation. Any law officer shall not hold any brief against government or advise or appear or act in any case against the government or give advice to private parties in cases in which he is likely to be called upon to advise the government or any government officers. Act or appear on behalf of a plaintiff in any suit in which the plaintiff has applied for permission, that is as an indigent person. Undertake defense of any person or appear against the government in any criminal proceeding. I have to emphasize upon this. But this is, they have made two distinctions. A and B pertains to those civil kind of matters, and C is relating to criminal matters, my lord.
Correct.
Then D is important. Appear defense in cases in which he might have accepted briefs prior to his appointment unless permission is obtained from the collector. Now, my lord, your lordship has seen ABC, AB relates to civil matters and C relates to criminal matters. Now, your lordship will see from the definition in section 3, A and B makes a distinction between a public prosecutor and a government pleader. So my respectful submission is, so far as clause C of Rule 14 is concerned, it pertains to a public prosecutor who cannot conduct criminal cases because he will be appearing against the government. So far as A and B are concerned, that pertains to a government pleader. And being conscious of that, they have allowed not one case or two cases. Your lordship may kindly see the earlier order they have allowed me. That is at page 15, your lordship. Page 15. May I just with your lordship's kind permission, beg your lordship's kind attention to page 15.
Yes.
Therein, your lordship will see, in pursuance of Rule 14D, law officer Sri Devadatta Mishra so-and-so is allowed to conduct cases, defend cases, for which he had accepted briefs prior to his engagement as per the list appended in Annexure A. Your lordship will see next page, page 16. These are all criminal cases. Because the authorities, while allowing, were conscious of the fact that he is a government leader, so he has to defend the government in civil cases. Now, again, he was re-engaged, and after he was re-engaged by virtue of the notification under Annexure 5, page 19, he again applies under Annexure. My lord,
what are you are still continuing?
I'm still continuing. Now, my lord,
these cases must all be over now.
No, these cases are there, my lord, because these cases doesn't end that soon. My lord, your lordship, my lord, is aware of every proceedings throughout the state of Odisha, my lord. Here, what happens, my lord, the only thing I beg to my concern is, now the Honorable Single Judge says that you can conduct a case, criminal case outside the district, not within the district. My respectful submission is a reading of the definition vis-a-vis the Rule 13 and 14 doesn't make out such a distinction. But the authorities will allow or not is a discretion of the authority. But kindly see the order. What has happened? The order is vitiated for the reasons. Your lordship has been pleased to peruse Rule 14. It says the collector is to permit. Here, what has happened? The government has advised the collector not to permit. So therefore, the order is vitiated in that sense, because your lordship will kindly turn to page 28. He says, the collector says, may I just place it, page 28, madam, how the collector refuses it. And he has not assigned any reason also as to why it is being rejected, except saying, may I just place it, my lord.
All right. This is like acting under dictation, you say, because of the government order.
That is at page 27. The Deputy Secretary of Government says that you don't allow him. And he is not a...
Now, should they all appear or they'll be all interested parties?
No, they can appear.
No, they'll all be interested, no? They may agree with you.
But ultimately, your lordship is there to decide the fate. So even assuming they agree, that will not hold good unless your lordship accepts my submission that my submission is acceptable. Otherwise, my lord, even if they concede, it will not hold good. Ultimately, your lordship's decision will bind all. And that will be...
All right, notice. He accepts notice on behalf of... So it's like a catch-22. On behalf of the respondents. Was a counter filed in the writ petition?
No. My lord, the writ petition, a counter was filed. My lord.
All right. The record of the writ petition is already there, no? All right. List on... Third July.
Will your lordship place it before vacation? Grateful, my lord.
All right.
Item 76. 76, my lord, 30th August, rehabilitation. Item 77, Sarta Parida, 8th May.
8th May.
78, Sarta Parida, 8th May.
All right.
For admission, item 79.
Why is this coming before us? It's not partnered.
No, your lordship specifically assigned to this court. And last occasion, your lordship directed only regard to permanent alimony.
What happened to mediation?
As per the previous settlement, though I have already paid the permanent alimony, however, in view of...
No, your lordship last occasion clarified. That is for a That is for one time this lump sum he has paid as per his own agreement.
What happened in mediation?
That will be referred to the mediation center for conciliation between two parties because the permanent.
No, you're willing to go for mediation or not?
Mediation center, what you also may kindly say the mediation center of Honorable High Court for conciliation with the two parties to arrive at a conclusion.
All right, both parties agree.
Also, I have given the calculation of the permanent alienation.
Mediation.
That is no basis.
Both parties agree to go in for mediation at the mediation center of the High Court. They will appear there at 3:30 p.m. on 11th April. 11th April. The mediation report will be placed on record by the next day. List on 17th May. Then try and settle it, sir. Better try and settle it. With both your efforts, you can arrive at a settlement.
Because he has remarried and the appellant has a son, 8 years.
All right. So I'm saying try and settle it.
He has avoided to pay that 5 lakh for
Anyway, now
more
that
than
you've got
1 year.
that you anyway have got now. All right.
Item number 80.
Your Lordship, by order dated
Item number 80.
2022.
Your Lordship may see the nature of the writ. This is an application to declare the Rule 4 of the Orissa Freedom of Religious Rules 1990 is invalid as it obstructs in exercise of practicing religions of one choice as enshrined under Article 20. So the virus of this rule is under challenge. It's not a PIL.
It's not a PIL.
It's not a PIL.
Made an application, then you say that
if
there is no such first class magistrate.
If the virus of then law department is to be implicated as a party. That is my first contention. Second contention is that whether this case can be listed here, that your Lordship is to be, because it's that is. And law without implementing law department, how the sub-collector will reply to all these
All right. At the oral request of the counsel, the petitioner, the law department of the government of Odisha is implemented as opposite party number 6. The consolidated cost title will be filed within a week. Notice is accepted on behalf of the law department also by Mr. D.K. Mantri, AGA, who prays for and is granted 8 weeks time to file a reply, rejoined up for the next day. Based on 22nd August. All right.
Item number 81.
Pursuant to Lordship's order, the state has filed an affidavit, but the state's affidavit, Lordship kindly see. State's affidavit, that matters regarding health hazards of this coal-fired thermal power plants.
Correct.
So that has come from the Honorable Supreme Court. And I am appearing for NIOH. Actually, on our report, the Honorable Supreme Court had referred to different state high courts to decide on the matter.
Correct.
So I think the report which the state government has said that the reports have not been properly taken care of. Very interestingly, you'll also kindly see our affidavit, the Honorable Supreme Court's order. The health hazard has not been addressed by the by the state government. In the affidavit, I did not find. You'll also kindly see the page 19 of the order of the Honorable Supreme Court. They have stated that what steps have been taken, that I do not know, because I have sent the affidavit to the NIOH. They will examine and file an affidavit. But page 19 of the Supreme Court judgment by the Lordship kindly see.
You have referred it to the NIOH.
I have affidavit sent this affidavit to NIOH. So if Lordship will permit, I will file an affidavit based on that.
All right. Counsel, Mr. Manoj Mishra and senior counsel appearing for the. You are appearing for, sir?
NIOH opposite part number 5.
Opposite part number 5, NIOH states that the affidavit of the state government has been referred to the NIOH for its response and will be filed for the next date. Based on Fourth May, sir.
4th May. Deep privilege.
82.
May I please your lordship?
Yes, sir.
Mirror. Order of the learned single judge is under challenge, holding that the respondent number 1 wrongly deprived to continue in the post and passed Annexure 15A and directed is entitled to all the
benefits.
Miller, facts are like this, Miller.
Mm.
I am appearing for the OSFC.
Mm.
Miller, the OSFC during 80s, 90s
Mm.
sees a number of units which requires Miller watch and ward persons. So locally they have to recruit and engage them. After the units are released, they used to be disengaged. So number of cases are filed in the High Court. Miller, earlier when the matter was pending, that is OJC number 888383389. Honorable Court directed, asked the OSFC to frame a scheme so that these people, those who are disengaged, engaged, they will be accommodated. Miller, the scheme was not worked out. Thereafter, this Honorable Court appointed a commission, Justice V. Gopal Swamy Commission, to inquire into what is the requirement and what is the financial condition, how many people require to manage the existing units. Miller, the Honorable Commission reported that there is 241 persons may be required to manage the things. Then Miller, your lordship also directed the OSFC to form a committee and examine and submit a report. So accordingly, Miller, the board formed a committee. Managing director was the head of the committee, and they have suggested certain things. And after that, the board, OSFC board, Miller, asked the managing director to place it before the court for consideration. After Miller consideration, everything, this Honorable Court directed, Miller, that is, I have given that order is annexed along with my note. Your lordship got that note, wherein first Miller, the court directed to engage 100 persons by giving a particular time. And the rest 50% in the month of November. Like that, two cut-off dates were fixed. When the matter stands thus, that because the information is not available with the board, OSFC, number of units throughout the states, engagements are made, there are no data, Miller, so they have decided to issue a notice under Samaj, daily Samaj, asking the persons to submit their documents and particulars. And thereafter, Miller, 301 applications received. Out of that, Miller, the list was prepared 126 persons. And 126 persons that was published and objections were called for. And after receiving objection, Miller, they have decided to issue appointment letters. First, 100, that is in the September, because while giving appointments, Miller, the present respondent has appeared before the branch manager, Raurkela, with a letter, appointment letter, and submitted a joining report. Miller, that was sent according to Miller SFC regulation. A code number will be issued and fidelity and declaration of secrecy. After that declaration is given and the code number will be given, he will be treated as employee of the OSFC. This respond number 1 appeared with an appointment letter before the branch manager Raurkela, and after receiving all the particulars that was sent to the PHO, that is Public and Human Resources, Personnel and Human Resources Department for verification. They found his name is not in the list of that 126 persons, and this letter was not issued by the head office. And after inquiry, everything, the head office, the persons who are in charge has informed that this appointment letter was not issued. This is a fake one. And further, the appointment letter which the present respondent appeared before the branch manager and submitted, that was not sent to the branch manager, no memo number, no noting is there. Then an explanation was called. Under what circumstances you have accepted that, and without the reference, then the communication was made, telephonic discussion, ultimately found that appointment letter was not issued to him, that is issued to one Katak Diesel. That was also there, Miller. In this background, Miller, now petitioner has filed this writ application to quash Annexure 15A. 15, Miller, the letter asking the branch manager to explain under what circumstances you have accepted the joining report. And the second letter, Miller, not to act upon the appointment letter, which is not issued, that is a fake one. You submit a report to the police and not allow him to continue. That is challenged in the writ application. Miller, your lordship has now that note I have submitted, I have annexed 2 orders of the Honorable High Court. The first order, Miller, I have annexed, that is OJC 529 of 90. 529 of 90, Miller, that is filed by the petitioner. By that time, Miller, when this writ application was taken up, already there was a suggestion for the scheme to be framed and the commission was appointed. And this letter is not the party in that OJC, Miller, 3833 of 89. Is not, petitioner is not the party. He is filed an independent writ application 529 of 90, wherein this Honorable Court disposed of with saying, Miller, I am placing that note, Miller, page 3, page 2, your lordship kindly see. I have also that entire copy I have given. Dispose of the Honorable Court with an observation, similar matter arising out of OGC number 3833 of 89, together with batch of cases. A committee has been constituted which is consisting about the alleged retrenchment and scope of regularization, and the ultimate result in the aforesaid cases will have an impact upon the grievance of the petitioner. Therefore, it will be open to the petitioner to ventilate his grievance further after finalization of the report by the committee. A copy of the order of the Honorable Court in the above case enclosed. So, Miller, here only it is mentioned. It is very important, Miller, in view of the subsequent submissions made. These 2 orders are very important. He is not the party in OJC 3833, Miller, and he is a party. Here, only observation is commission was appointed. In case a report is come, that may have some impact, and he can represent and ask for the relief. Now he represented all along. Now two submissions made. One, on the basis of the direction of this honorable court, a commission was appointed. Commission report was given, and the OFC was asked to give the observations.
See, in the last 9 years, what has happened? The impugned order is 2014.
Yes, Mr.
What has happened in the last 9 years? You've not taken him.
No, he has appeared with a forged letter. No appointment was appointed.
No, sir, I am on the impugned order.
Yes.
The impugned order was passed in the year 2014.
Yes.
It is 9 years now.
Yes.
What has happened in these 9 years?
9 years, Millard. We have
No stay, nothing.
Your Lordship,
No
kindly
stay.
see the appellate.
But only contempt petition postponed.
Yes.
So for 9 years, no change in the status quo.
Not listed. Matter was not listed.
No, so
7
he has
years.
not. No, so he's not back in service.
No, he was not appointed.
Right.
There is no appointment letter.
Okay.
It is a forged one.
No. So he never worked for you.
No, he never worked for even a single day.
Achha.
That I will Millard the land single days.
No. He was already 46 in 2014.
Yes.
So now he's what? What is his age now? 55.
Yes, sir. 55.
55.
What does he do, sir?
Here, Millard.
What is he doing?
My lord, my information is he's driving an auto.
Oh. What was this post?
Delhi rate basis.
Millard.
Security assistant.
My lord,
Security assistant.
Security assistant.
Security assistant.
Here, Millard, before that, Millard, I am giving only two submissions, Millard. It will satisfy your Lordship.
No,
that he has worked.
No, in the 55th year, will he want to become security assistant?
Yes, my lord, I have seen he is quite fit. I've seen him. At this age, if I am fit, my lord, why will not that?
How can you compare that, sir?
No, I am 79, my lord.
I know.
Fit.
Everybody can't be Mr. Ratha.
He is 55, my lord. I know that he is fit. I have seen him. He is standing behind, my lord.
My land friend 79 is very young. We are 76. We are now become old before him. Energetic.
But you cannot age with somebody's fit.
Yes.
His capability of
that's what I said.
Condition.
That's what I said, Millard.
And moreover, before my honorable friend starts, just a minute. They have not obtained any stay. They prayed this honorable court that will obtain a stay. They went to the honorable court. Honorable court did not grant stay, and thereafter they kept quiet.
No, Millard. Your Lordship, kindly see the record. It was moved, and this honorable court said.
No. I'm just saying, keep aside all this letter. You say the letter is a forged one or something.
Forged one.
Anyway, is there any other objection to taking him? Do you have any objection to him?
Before that, Millard,
either he's not qualified or he's not found fit, anything like that.
Millard, may I submit, Millard? Out of that 126, subsequently we found 15 persons were also given forged. And we have terminated them. They have filed writ application. This honorable court has held that after giving opportunity, they found all the forged letters and they have dismissed that writ application dismissed. That copy of the order also with me. 10 persons out of that list.
No,
he is the one of
on
the
this on this forged thing. Just come to this impugned order, where the judge has quoted extensively from one letter.
Yes.
Just see that.
That is, Millard.
Page 14, internal page 14 of the impugned order.
Yes, Millard. I have answered that. My
Annexure 17.
Yes, I have seen. That is annexure page 14. Yes. Your Lordship, kindly see that order that is annexed. As annexure, Millard, there, in the same letter, there is a noting that the branch manager has explained seriatim what are the facts happened. When he was asked to explain under what circumstances you accepted that appointment letter, which is not in any memo, nor it is referred to you under what said, that is the while explaining last two paramillard page 51 of the writ application. He himself mentioned he was not attended, he was not allotted any duty, nor he has given salary, and nor he is having a code number, he was not taken oath. Other things also mentioned. That is, that portion is omitted from that order. Your Lordship, kindly see page 51 of the writ application.
Because his name was included in the list.
Yes. He has not worked even a single day.
No. If he was not being considered, how is his name included in the list? His name is included in the list of selected persons.
Milord, if he has been selected he is not in the list of 126.
No, serial number 86.
Milord,
come to para 13. Just the previous paragraph.
Yes, Milord.
This,
Milord, it is a confusion created on misconception. Single judge, Milord, has taken into note that this is the misconception, Milord. They think he is the petitioner in OJC 3833. He is not the petitioner there.
Oh.
On that basis, the claim was made. The single judge, Milord, taking into note, even there is no appointment letter because his name was in list 70s.
No, but how did his name come into the list?
That, Milord, that earlier list before 90, before the appointment of the commission and the scheme, that, Milord, they called when this honorable court wanted to have a scheme and regularize. We have called different branches, the particulars. There, these 100 people names were there. His name was 74 and 86. 86.
Initially,
That is
74.
86. That list, Milord, after that list, commission was appointed, notice in Samaj was given, and he himself also applied, along with the certificates and other things. His name was not found place. Thereafter, he approached the chief minister and secretary, everybody saying that, though I am, my name is there, that 7486, which is not concerned with the present after the commission report. And he was the petitioner in OJC 3833. So in spite of direction, he was not given. And after that, he has taken a second stand that on being directed by the state government secretary, he was given appointment letter. And third stand, Milord, this appointment letter, you say on the basis of that list, he was given the list, appointment letter. So misleading the facts. And he has worked only 1 year, 3 months, Milord. That is 27 to 88 to 27, 389. That is the entire service he rendered with the corporation, on the basis of which, after your Lordship direction, Samaj publication, he was given the particulars as per the seniority, Milord, your Lordship, while passing the order, the seniority, the date of appointment will be taken on the date when the writ application is filed. That is 23/5/89. And seniority will be counted from 1/1/90. So he has worked only 1 year, 3 months. And these things, Milord, the entire commission, during 90s, 80s, I was the counsel and handling all the regulations, these writ applications. Mr. Manoj Vashra was appearing for this thing. And this set a trust by this court by appointing a commission, giving a procedure, call for the application. After receiving the applications, and he was found not coming within the scope, and his name was not there. My Lord, Honorable Single Judge, your Lordship, kindly see page 16, page 7 and 16. My Lord, page 9 of the Single Judge judgment, para 7.
Yes.
Your Lordship got it?
Yes.
This is the submission of the petitioner, respondent number 1 advocates.
Yes.
Mr. N.C. Panigrahi, Land Senior Counsel, appearing for the petitioner, strenuously argued that a right accrued to the petitioner by virtue of consideration made by this court in the earlier writ application OJC number 3833 of 89. That's why I pointed out to your lordship, his earlier writ application is different. There is no, he is not the party in OJC number 3383.
Oh, I see.
He is not party in the OJC. So by misrepresenting, and he also mentioned paragraph 4 of the writ application, he joined 1980 and he was returned in 89 after 9 years. That is a wrong statement. The Honorable Single Judge has taken into note of that 9 years. And these are the weight on the mind of the Single Judge, misleading statements. That the first misleading statement made by the petitioner is that he is the petitioner in OJC 3899. He is not the petitioner. He is the petitioner, Millard, in OJC that I have given. 529 of 90, and he referred about the commission. And in case any report comes that may have some impact, he can represent and claim for the benefit. That is the writ application. But 7, I have pointed out to your lordship, paragraph 7 is not the petitioner. And paragraph 16, your lordship, kindly see.
Yes.
Paragraph 15 and 16, clearly that is there. That again on the basis of that submission of respondent number 1 advocate, Honorable Court in paragraph 16, take a note of that and said, even in the absence of his name, that was given. So the other persons, Millard, they have suggested this writ application disposed of by this Honorable Court by the 15 persons of that list, where their names were there after commission notice. They found, after there is a clause in the appointment letter, if they found any misrepresentation, any false certificates, the appointment can be cancelled without any reference. Accordingly, their appointments, if he has approached, he would have faced that same thing. Millard, the judgment of division bench, taken note of everything and passed this order. Millard, I got a copy. This is the order out of 126, Millard. 10 persons filed after termination, after the certificates, forged certificates, others given, the termination, that is upheld by this Honorable Court. This is the judgment.
Yes, Mr. Rathur.
Yes, my lord. My lord, prior to this, the sole opposite party filed one writ application, OJC number 529 of 1990. This Honorable Court has passed an order. It is submitted by the learned advocate for both the sides that similar matter arising out of OJC number 3833 of 1989, which Mr. Rao was now telling. Together with a batch of cases, a committee has been constituted, which is considering about the alleged retrenchment and for scope of regularization. It is further submitted that the ultimate resulting to the aforesaid batch of cases will have an impact upon the grievance of the petitioner. To satisfy the grievance of the petitioner, it will be open for the petitioner to ventilate its grievance further after the finalization of report by the committee concerned. This was on 12th of January 1996. Thereafter, my lords, this 2002 writ application was filed. My lords can have a look to paragraph 7, which my learned friend was read half, 3, etc. For the strenuously urged that the right accrued, this is on page 9 of the judgment, my lord.
Yes.
To the petitioner by virtue of consideration made by this court in the earlier writ application, that is OJC 3383 of 89, referring to two lists produced by the London Council for the Corporation. He submitted that in the first list as per Annexure 1, this is the list given by the Corporation, my lord. The petitioner's name finds place at serial number 86. And in Annexure 1 by A, that is also Corporation letter, my lord, his name finds place at serial number 74. Since on the basis of the report of the subcommittee out of 241 employees recommended by the Justice B. Gopal Swamy retired committee, 150 numbers of Delhi rated employees had to be observed as per the recommendation of the subcommittee constituted with the board of directors. In both the cases, the case of petitioner can be taken into consideration as his name finds place against serial number 86.
This is the
and
problem,
70.
sir. The serial number 86 and 74 was before the commission was set up, not after.
My lord, this has been conquered. This has been conquered by this honorable court in different writ application this is the list
of different persons. See, this person, he did not make it to the list after the commission was set up.
My lord,
His name was included before the commission was set up.
My lord, this is after the committee.
No. In fact, that's the problem with this paragraph.
My lord,
the single judge has proceeded on the basis that
probably, my lord, I'm not clear. Number one, the Justice B. Gopal Swamy committee gave a report.
Correct.
Thereafter, they
set up a commission.
They wanted their own committee.
Whatever, they set up a commission.
And ultimately, the name of the petitioner.
No. After the commission, his name was not included. This is the mistake, he says. This is precisely the mistake.
Advertisement was given, applications called for, thereafter list was prepared under 26. His name was not there.
Can come to paragraph 12 of the
That
judgment.
is the crux of the
I'm
point.
running page 11. In the counter affidavit filed by the opposite party, they have not disputed with regard to inclusion of the name of the petitioner in the list. Rather, the subcommittee, which was constituted by the board of directors, stated that 150 employees were to be engaged to meet the situation immediately. Even if case of 150 candidates were to be considered, since the petitioner's name found place as
again a mistake, sir. He's in the list prior to the commission, not after. Commission, when it prepared the list, his name was not there.
My lord, with my...
That is Annexure 5. His name is not there.
My Annexure 5 of the...
Writ petition was... Anyway.
Mr.
Mr. Rathé, you file a written note of argument.
Yes,
right? Orders reserved.
Yes.
Both parties are permitted to file written notes of arguments within 1 week.
Yes, ma'am.
All right. Thank you.
Item number 83.
Infructuous disposed of.
Item number 84.
May I please your lordship, my lord. In this case, last occasion, my lordship directed the issue, file the requisites for opposite parties. I am also filed the requisites, but the opposite party didn't appear in this case.
24. 24, I am instructed to appear for the opposite party. I filed the Mokararkana by day after tomorrow. I should take it from here before after May.
Sarkar.
84.
What is your kind name, sir?
N. Sarkar.
Mr. N. Sarkar appears on behalf of the respondent and prays for some time to address arguments. List on 14th August.
Number 85.
I'm for the appellants, and no one has appeared on behalf of the opposite party.
Addressee expired.
My lord.
6, 8, and 9. 5 addressee left. Have you seen the remarks?
Yes, ma'am. I've seen.
So the notices to...
Take fresh steps.
No, R5 has been returned with the remarks addressee left, and notice to 6, 8, and 9 with the remark addressee expired. Appellant to take steps to ascertain the correct present address of R5 and furnish it in the registry within 4 weeks. Within the same period, to take steps to bring and record LRs of 6, 8, and 9. Fresh notice will issue to R5 the correct address returnable on the next date. This on 17th August.
Item 86. 86, promotion during pendency of vigilance case.
That matter, your lordship disposed of similar matters yesterday.
Is it after notice or before?
Notice has been issued on 20th March, but notice not issued.
Then the same 26th.
Item 87.
87, lordship turns to annexed to page 74, my lord. This is the until order. A departmental proceeding which has been-
Okay, in 86, 1 minute. In 86, you say notice returnable on 19 July. Stay in November. Right. 87.
Page 74 is the until order. Here, my departmental proceeding has been quashed. On the ground, he has joined in its service. So,
no fresh notice. This notice has not come back. You are appearing?
No.
Or fresh notice returnable. This Valentina Ray.
My lord.
Fresh notice returnable again 19 July.
Fresh notice.
Yeah. Stay to continue.
Item 88.
May I please, your lordship? The petitioner before your lordship is a election petitioner in a Gram Panchayat, arising out of a Gram Panchayat election. His application for amendment of the the election petition was allowed by the tribunal. That has been reversed by the learned single judge, which is being assailed before your lordship. Now, your lordship takes page...
Hear it on some other data. Hear it on some other day.
Spot date, my lords.
Interim order is continuing, sir.
I am suffering. My election petition has got stalled.
So what about this maintainability?
Maintainability, I'd satisfy your lordship. In fact, there is a division bench judgment of this honorable court besides two single bench judges.
Is there an interim order in this matter?
In this matter, madam? Yes, madam. There is a stay of further proceedings before the...
Where is that?
Order.
Because 1810, we simply say interim order to continue, but there was no interim order in the earlier date.
20th September, there is no.
20th September, there is no
20th
interim order.
September, first listed. Notice was issued on 20th September.
But no interim order was
interim
passed.
order. My record shows there is no interim.
Acha, we passed that interim order on 20th October.
October. Yes, yes.
In fact, if your lordship recalls, I had shown your lordships the judgment of Justice Chandrachud of Bombay High Court, then
Correct.
Advani Orlikon.
All right. See, list on 3rd May. 3rd May. Interim order to continue.
Item 89.
I may be pleased to your lordships. My lord, I am on BC, my lord.
Yes, please.
From the Augustine, my lord. And the,
Yes, please.
My lord, I have received the counter filed by the respondent number 1, 2, 3, but the affidavit filed by the respondent number 4, the copy has not served on me, my lord. And the counter filed by the state, my lord, the rejoinder is required. My lord, the case...
It's a copy of the affidavit filed by opposite party number 4.
Your lordship has directed to file the affidavit both the parties, to the petitioner and the respondent number 4. And he has not filed the affidavit. Matter relating to purchase of my paddy. I am a farmer. Lawrence single judge are directed to purchase my paddy since the purchase token were issued to me. And similar situated farmers like me, the appellant has purchased the paddy from them. Only I have been, my lord, deprived, and paddy is lying vacant with my, lying stock in my house, my lord. And that is damaged day by day, that is going to be damaged, my lord. My content proceeding has been stayed, my lord.
What is your...
My lord, fact is... I have glanced the order of Lawrence single judge, my lord, which has been challenged.
Without giving notice, my lord, without giving notice to the opposite appellant, my lord.
7/8/2022.
Without giving opportunity of hearing, my lord, that order was passed. And the fact of the case lies before your lordship, my lord. The present appellant is the secretary of the society.
Oh, I see.
He was entrusted to procure paddy, my lord.
All right.
That Miller was, my lord, the token is to, the farmer has to register his name and to obtain a token from the state, my lord, by linking that to the Aadhaar card, my lord. After obtaining the token, my lord, the secretary had to purchase paddy, procure paddy, my lord, and the money had to be paid by the government. The 513 numbers of farmers were registered, my lord. Out of that, only he could be able to procure paddy from 139 farmers because the millers, 2 millers were asked to lift the rice paddy, my lord. But they did not come, the miller did not came and did not raise the paddy, my lord, procured by the petitioner, my lord. That's why the token period was for 1 month, my lord. After lapse of 1 month, that was last, my lord, the token was elapsed, and miller did not raise the paddy. That's why it was impracticable for the petition appellant before your lordship to procure the paddy furthermore. That was informed the opposite respondent number 3, the CSO of the district, that this is the difficulties. You kindly direct the millers to raise the paddy because there is no space to procure the paddy. 139 numbers of farmers, they have already given their paddy, my lord, and they are not paid. That's why after receiving the complaint from the my lord,
Alright, you say counter affidavit filed by opposite
I
party
have already
for
filled the affidavit from whom they have purchased.
be served on counsel for the appellant. Rejoinder be filed to all the counter affidavits before the next date.
Only fix a short date.
Short date will be in April only, sir. 17th April. 17th April. All right.
Item number 90.
90, my lord. May I seek time to file objection to the counter he has filed, my lord?
The interim order is against me, my lords. That is with regard to.
Here also similar issues to item 88 has arisen. That is election.
Election of my lord, he was disqualified as per 25F of the Gram Panchayat Act, my lords. And my lords, that is only with regard, my lords.
Same issue.
No, issue is not same, my lords. That is rejection of 711 person was rejected.
Yes.
Rejected. And that single bench, my lords, confirmed the order, my lords, that is 7111. That is rightly, that has been dismissed. And they have filed a writ appeal, my lords. The only issue, my lords, with regard to my lords, that is disqualified.
There is a question, Acha, there's further proceedings have been deferred. All right.
And my lords, in the meantime, my lords, the evidence has been started and we have already given the evidence.
Here the issues here, election petition has been filed where only 2 dates were mentioned, nothing else. There is material particulars to be mentioned in an election petition calling in question of a democratically elected sarpanch. And now only 2 dates has been mentioned, and that is why
the rejoinder be filed for the next date. List on. When are we keeping the other matter? Keep it on a different date. 3rd May. 3rd May. We can keep this on 5th May. 5th May, sir.
interim order to
Yeah, interim order.
My lord, item 48. Sorry to say, my lord, I have not appeared in the time. Kindly formulate to withdraw, my lord.
Item 48 is dismissed as withdrawn. All right.
Pass to matter item 25.
Lord, 2 dates your lordship may kindly take note of that on 27/10/2014, this is a selection was made for the post of Shiksha Sahayak. And in the first notification was issued on 27/10/2014. And I did not apply that point of time because I was 36 years, 6 months and 14 months.
Some defect pointed out.
Mila?
What is it?
Some defect pointed out.
Defect number 9.
3rd May defect be cured in the meanwhile.
Which is copy has happened.
Copy
has not been solved.
Blood.
So copies.
Sorry,
CRLMC 5132 of 2015.
My lord, item 1 on behalf of Mr. H.N. Mahapatra. Only file is misplaced, my lord.
Dismiss non-prosecution.
Also item,
Liberty to
also item 12, my lord.
12, 1 and 12. Liberty to
Obliged.
revive it as and when the file is found.
Item number 2.
Item number 2 on behalf of Mr. B.K. Parida, no instructions.
No instruction dismissed.
Item number 3.
May it please your Lord's Parade. Dear Parade, I have challenged the order taking cognizance passed by the Land Magistrate in taking cognizance of the office matter order Annexure 4, page 62, ballot may kindly see.
Yes.
Ballot here, ballot will see that cognizance has been taken under section 7 and 8 of the Issue Act. My sole submission before my lord is it is not there which control order I have violated for which I will be held responsible for section 7. This point, my lord, I have categorically taken earlier, my lord, in a case reported in my lord, 1993, volume 6 OCR, page 726, where this honorable court was pleased to observe that the person concerned must be a licensee and there must be clear-cut observation that which control order he has violated. Here, my lord, this point I had raised while the case was, investigation was going on. And my lord, I had filed a criminal case number 3013 of 2013, wherein the honorable court was pleased to observe, my lord, in paragraph 10 of that order, the decision of this court in the case of Pradurna Kumar Behra, my lord, I had argued that case, which has been relied upon by the learned counsel for the petitioner, relates to passing of cognizance order. In that decision, apart from the issue that provision of the control order was not indicated, the court further held that the accused therein was neither a stockist nor a licensee. Therefore, he was not at all liable to be prosecuted. But present case is against prayer to quash the affair. So
Anyway, all this can be pointed out to the court, sir, at the appropriate stage.
My lord, it's a case where the Honorable Apex Court has also been pleased to observe.
Correct.
In the case, my lord, 1996, volume 5, SCC, page 1. My lord, unnecessary.
All this can be pointed out to the court, sir. All this can be pointed out.
My lord, that has been taken note of in cognizance, challenging cognizance.
Yes.
For that reason, my lord, I am raising it, my lord.
All right. You say permitting.
If my lord so desires, my lord, I can give a small note also on that.
Not necessary, sir. Permitting
My
the
lord,
petitioner to raise
at
all
the stage
things.
of, my lord, this is not a case where I will raise all the, because it's a point of law. It's not a fact, my lord. Point of law.
Point of law can also be raised, sir. Point of law can also be raised. Permitting the petitioner.
Stage of framing of charge, my lord?
At the appropriate stage. Yeah, at the appropriate stage.
My lord, may I observe that at the stage of framing of charge?
The appropriate stage, including the stage of charge.
My lord, may I pray, my lord, item number 42 and 52.
Awesome. Same.
Maybe taken up some other day.
Oh, I see. 1 minute. Let's finish this. The petition is disposed.
May I pray?
All right.
Because my lord,
the order, the interim order is vacated. The copy of the order be sent to the consent.
Item number 42 and 52 may have been taken up. So
we'll pass that order when we call it out, sir. Right.
Item number 4.
Permitted to raise all the points.
Yeah, permitting the petitioner to raise.
Item number 5.
Your Lordship, we have no instructions.
No instructions dismissed.
Both the cases. Item number 6.
None abuse dismissed.
Item number 7.
7, my lord, permitted to withdraw.
Dismissed.
Arising out of a complaint case, my lord.
All right.
Item number 8.
Pardon, my lord. Last occasion, your lordship, in tomorrow, item number 17, I pray your lordship to adjourn the matter wherein my senior is going to argue the matter. This is the company affairs, your lordship. My lordship was fixed a day.
It is posted to 28th of June. Your Lordship.
28th of June.
Yes, sir.
All right.
Yes.
List on 28th June. All right.
I'm for the opposite party number 1.
All right.
Okay.
My lord, entry order to be got.
Item 10.
18.
Item number 9.
Item 9, your lordships, no instructions.
No instructions dismissed.
Item number 10.
But I can raise those points at the time of hearing.
All right. Permitting the petitioner to raise. Right.
Item 11.
None abuse dismissed.
12 already taken up. Item 13.
Memo taken on record. No instruction dismissed.
Item number 14.
No instruction, my lord.
No instructions dismissed.
Item 15.
None abuse dismissed.
Item number 16.
None abuse dismissed.
Item number 17.
Same order.
Item 18.
May I please, your lordship?
Yes.
The complainant, your lordship, had booked a flat with us. Now the agreed price was 1,40,000.
He's not even served, sir. Permitting the petitioner to raise all pleas at the appropriate.
Your lordship may look at, we served him a notice.
Unclaimed, come back unclaimed, sir. It's all right. Unserved notice. You see, permitting
the person has died, my lord. I substituted, took out notice. I also.
It's not being served, sir. What's the point? We can't keep on waiting. 9 years over. No point. We can't pass an ex parte order. You see, permitting the petitioner to raise all pleas. There, nobody will appear. It will be easier for you to get it closed there.
My lord, I am before your lordship because reason being, I think I have got a point in hand which your lordship can appreciate.
Oh.
I served him a notice annexure 2.
It's all right. Permitting the petitioner to raise all pleas at the appropriate stage.
Item 19.
Right. Nana based.
Item 9. 19.
If it may please your lordship, item number 19. Lordship, an interim order was passed for no coercive action against the petitioner. As far as the notation is concerned, the AD has not been returned. The notice has not been.
What is the offense, sir?
So the matter arises out of a petty offense whereby the informants have, at the time of unloading the truck, the informants have dashed the truck into the godown of the petitioner.
Permitting the petitioner to raise all pleas at the appropriate stage. The petitioner is supposed to.
Lordship, there is a compromise in annexure 2. The matter has been compromised by the opposite parties. Has been amicably settled between the informants and the petitioner. Annexure 2, your lordship.
You point that out, sir. You point that out to the trial court. The trial court be informed of the compromise stated to have been arrived at between the parties.
At least a date may be given for fresh notice to be served up on the parties again.
No, not at this stage. Sorry. Yes.
Item number 20.
None appears. Oh, yes, none appears.
Item 21.
Same order.
Item number 22.
Same order.
Item number 23.
Same order.
Item 24.
Same order.
Item number 25.
25, no instruction.
No instructions dismissed.
Item number 26.
None appears dismissed.
Item number 27.
Cognizance taken on the first day NBW has issued. What my respective submission is that if this summon can result in production of the accused, there is no need to resort to BW and NBW. On the first day itself, NBW has been issued, my lord.
All right. You give a date for you to appear, sir. Counsel to the you say petitioner will appear before the concerned trial court on 24th April 2023. Thereafter, the petitioner can apply to the court for appropriate orders.
And NBW may not be executed in the meantime.
Till then, the NBW will not be executed. No. The petition is disposed.
Item number 28.
28 may I please? Last occasion, my notice has been issued to the opposite party number.
Absent. Returned with
the case arising out of one case.
Sorry?
The case there is a dispute between the accused number 1 and the opposite party number 2. There is a dispute at page number 24. I have mentioned total mentioned the Prashant Kumar Jana who is the complainant.
307, sir. Permitting the petitioner to raise all pleas in the appropriate state, the petition is disposed of.
Item 29.
My lordship.
As per instruction, my lord, file the press vocal, my lord. 1 week time, my lord.
No. What is the matter about? This is 29.
29.
What is the matter about, sir? What is the matter about?
Matter I have no.
No, you've not got time to read all that.
Cognizance has been taken on section 420.
Permitting the petitioner to raise all pleas at the appropriate state. Petition is supposed to have interim orders vacated. Right.
Item 30.
None appears dismissed.
Item 31.
None appears dismissed.
Item 32.
Same order.
Item number 33.
Same order.
Item number 34.
My lord, item number 34,
this is the matter for quashing of the proceeding, and I am just filing one judgment, recent judgment, my lord. My name does not figure in the FIR. The offense is relating to 143, and on the basis of the suspicion against the unknown accused persons, the same has been lost. As for the ratio laid down, in the case of the state of Haryana and others versus Bhajanlal and others, and other decisions, I am just citing, my lord. I am just giving the judgment. That is Binit Kumar and others versus state of Uttar Pradesh. There is a guidelines have been set by the Apex Court. When prima facie, my name is not FIR, doesn't figure in the FIR. No case is made out against me. No charge sheet has been submitted against me. And by virtue of the interim order, the matter has been stayed for the last 7 years. No, nothing is there. Because only thing is that I have a Xerox shop in the locality. The police was making a raid. And in pursuance to that, I filed bail application. And I was allowed anticipatory bail. Thereafter, filed this present petition for quashing of the proceedings in view of these decisions. My name doesn't figure in the FIR. There is nothing, my lord. Only only thing is that some persons are making some tickets. One person, as per the railway authorities' instructions, cannot make more than 6 tickets. One agent. I have a Xerox shop, so they were making rampant rate. For that reason, because of the apprehension, I filed it, my lord. There is not a single piece of document against me. Because of apprehension, I have filed, my lord. My name also does not figure in the FIR. There is nothing. So I am just, my lord, I may be permitted to hand over this judgment that contains all the previous judgments, the celebrated decision of Bhajanlal and others, and other recent decisions. And this is also a decision of the 2022, my lord.
No. On 16/9/2017,
my lord,
a lawyer appeared for you.
No, my lord. I have the interim order, my lord.
Sir, 16/9 to don't keep saying no to everything the judge says. Sometimes the judge can also say something correct. Come to page 15. Paper book, sir.
Page 15. My lord, this is for furnishing the bail bond, my lord.
Who has appeared for you? Somebody has appeared for you?
In the lower court, my lord.
Why did you appear?
My lord, because I filed an advance anticipatory bail application.
Why?
My lord, because of the apprehension I filed, because there.
What apprehension? Nobody's named. Why? What apprehension?
Apprehension is that, my lord. On the apprehension that
somebody is filing against unknown persons. Why? What are you apprehending?
My lord, I have a Xerox shop.
Relaxed. Somebody is filing against unknown persons.
My lord, I have a Xerox shop, my lord. The police made a raid in my shop and all the shops, my lord.
All right.
So
why did you file an anticipatory bail?
My lord, I was remaining less, my lord. Unless I get a bail order, they can.
How do you know? It's all unknown persons.
Yes, it is unknown persons.
Why did you go and file an anticipatory bail? Unknown persons. Why did you file?
Because they frequently the local railway police visited all the shops.
They like to visit, sir.
They
may come for even chatting with you.
A common man is not that strong, my lord.
No. This is not common man. See, common man will not know all this. You're uncommon man.
Common man is only given to the court, my lord.
You're uncommon man, you know the law. So you know who's being targeted.
My lord, because of
the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. All right.
Item 35.
May I pray one thing, my lord? May it be disposed of, my lord, instead of.
Yeah, disposed
yes,
of.
That is disposed of. Item number 35.
None of this.
Item number 36.
None of this.
Item number 37.
None of this dismissed.
Item number 38.
My lord, item 38, I prefer withdraw, my lord.
Dismissed as withdrawn.
Item number 39.
None of this dismissed.
Item number 40.
None of this dismissed.
41.
May I please, your lordship? My lord, page 21. There was a contract that he should have paid 3,62,000. Instead, he paid 2,50,000 for a generator set. Balance 1,12,000 he did not pay. We asked him, you pay the amount or take back the money, my lord. We in fact,
Your counterpart, opposite party number 2.
in fact, this matter was heard last date also. He was there, my lord, before my lord Justice.
But I am for the opposite party number 2, my lord.
Ah.
Yes.
Why are you chasing him for 20,000, sir?
Yes, but this was the proposal. You lordship may kindly see page 21. This was the proposal given by the opposite party number 2 on 23/9/11. And page 22, the payment. You lordship may kindly see. Advance rupees 2,50,000 and balance amount after successful commissioning of generator sets. This was the proposal. Along with this proposal, 2,50,000 check was given to them. They encashed that amount. Thereafter, they did not provide the generator set and demanded that rest amount to pay. Only thereafter we will provide the generator.
We never agreed to that. We said you pay the entire money, we'll dispatch you the generator.
Well, that is the dispute here.
We return him the money.
Our proposal received 2,50,000 and the balance our proposal.
So till date you don't have generator.
Yes, Miller.
Till date you have no generator.
No, he doesn't have.
No, thereafter.
And we returned him the money.
2,50,000.
We returned him the money. Your lordship may kindly look at the additional documents that I have filed.
The money has been returned.
No, till date the money is lying with them.
Please, let us be fair to the court at least. Let us be fair to the court at least. My lord may turn to my documents.
No, you returned it by check or draft?
Check, my lord.
Naturally.
He has never done, my lord. This amount, it was offered to him. He initially filed a complaint, my lord, complaint case before the consumer court. He failed there. Then he went to the civil court.
That was for compensation.
Allow me to say something.
That was for compensation, loss and damage.
All right, sir. 1 minute.
Then he goes to the civil court. Civil court he lost. Dismissed. Appeal is pending. Then, my lord, he comes up with the brilliant idea of filing this complaint, police complaint. And in fact, this matter, what is the criminality involved in it? And in fact, this matter was heard by Justice Satpathy and he directed.
This is purely civil dispute, sir. Purely a civil dispute.
Here, Millard, my humble submission, Millard,
I think best is you take even now that whatever money they're offering.
Millard, let them, beside this dispute, Millard.
No. Are you prepared to accept 2,50,000?
Yes, 2,50,000 with bank interest. I am not claiming more interest, Millard, because 18% interest was claimed. I am saying that let them pay the amount with bank interest because in the meantime, more,
to demonstrate your bona fide, you pay him 2,50,000 to begin with, and then we'll talk of interest.
Your lordship, I have to take instruction. In fact, this matter was heard by my lord, the other bench. Lordship said, what is the criminality involved in it? Then my lord directed me to file all the documents.
At least not neither generator nor 2,50,000 is fully empty-handed.
My lord, case after case, your lordship, one civil suit.
See, you're paying your lawyer, he's paying his lawyer. Only that is happening. Nothing else is happening.
Let somebody be benefited.
Only lawyers are benefited, sir.
Your lordship, give me some time, I'll take it.
In fact, after so many years, when the matter was
Counsel for opposite party number 2 states that till date, neither has the party received the generator nor the money. Mr. Sarangi, senior counsel for the petitioner, however, points out that the petitioners had returned the money by way of a check on
your lordship, I have given the date. Through registered post, it was sent to you. That is 14/9/2012.
On 14/9/2012. But the
check number,
not,
my lord.
Yeah, but the check is not encashed. Paragraph, be that as it may. He seeks time for instructions on whether even now the petitioner is willing to pay the said sum without prejudice to the rights and conditions of the parties. At his request list for the roster bench. On 10th May. Interim order to continue.
Item 42.
Mr.
Request of Mr. Dalal list on 4th July.
Grateful much. Item 43.
My lord, your lordship kindly see the order dated 22/7/2022. The government council was directed to take instruction as to whether there has been amicable settlement between the petitioner and the opposite party number 2.
Yes, sir.
My lord.
There's already an affidavit filed.
Yes.
Yes, my lord.
All right. You see, in terms of the affidavit filed, Annexure 3, and with the government not being able to dispute its genuineness, take the prayer clause and all proceedings consequent thereto hereby called. Right. Yes, yes.
Item 44.
My lord, date may be fixed.
Quashed, sir.
Item 44.
Just explain to him. He doesn't know he's succeeded in the case.
I'm for the opposite part.
May it please, Your Lordships. The moot point involved in this case, Your Lordships, is whether cognizance to an offence, whether it can be taken twice. Your Lordships had filed a date chart. It should be on Your Lordship's record.
No, we'll
The
place
fact
it
is
before-
like this.
No, it's okay. Placed before the roster bench on
Obliged, Lordships.
18th May.
Roster bench.
Item 45.
Interim order to continue.
Obliged, Lordships.
45.
None appears dismissed.
Item 46.
Same order.
I'm on dissimilars.
Yes.
The input order of cognizance at Annexure 1, taking cognizance of offences under section 341, 294, 354, 188, 506, 34 of IPC has been challenged. These are the petition, the OP number 2, they are brothers and sisters. There are civil dispute, there is a civil case. And earlier also had Annexure 2, one complaint case was filed, which ended in final report. And on the same set of allegations against this complaint case was filed, and the cognizance has been taken by the Annexure 1, which is the informed irregulars. The dispute is purely civil in nature, and in response to and there has been also a 107 proceeding against the OP, which they didn't appear, whereas the petitioner appeared. They didn't appear to the orders of the executive magistrate. Rather, they
It will get closed. The better thing is if it goes to the trial court, it will get closed in no time, sir.
Let's say this now.
It's better it's done that way. It's better it's done that way. You say permitting the petitioners to raise all pleas at the appropriate stage in the trial court. The petition is disposed.
Item 47.
Yes. Memo taken on record. Dismissed is not pressed.
Item 48.
Both matters.
48.
48. Sorry.
48, my lords. Two questions arise in this petition, my lords. My lords, notwithstanding the orders, specific orders of the Supreme Court, that all the matters relating to 44 companies, which includes this present company, is to be transferred to the CBI, and the CBI has already investigated and given a charge sheet, my lords, wherein the present petitioner's name does not find place, my lords. Can the state police still continue?
Why not?
My lords, there is a specific direction of the Supreme Court. That, my lords, there is a specific, your lordships may see the judgment. All cases, including those which wherein charge sheets have been filed, are to be transferred to the CBI.
ID, you are the concept.
Some cases are transferred to CBI and some are not.
No, my lords.
This case is not.
Your lordships may see the directions. I've given the judgment of the Supreme Court.
I think 44 cases have been transferred.
44 companies. Your lordships, I may
cases
point out
44 companies.
No, I may point out your lordships may take it up tomorrow also. If I think your lordships,
right.
Because this involves some hearing, my lords.
All right. List for the roster bench.
Your lordship may list it before roster.
Yeah. On 11th May. Right. Interim order to continue. Is there an interim order?
Yes, my lords.
All right. Interim order.
There is a connected.
Both the matters.
Right.
Item 49.
Deeply obliged.
My lord, item 49. The impugned judgment is Annexure 4 and the relevant portion is page 20, my lords. This application arises out of one 1cc case alleging the offence punishable under section 138, my lords. I filed at the middle of the trial, I filed an application. Let the check be sent to the expert's opinion in order to opine whether
counterpart who's appearing for the other side.
Because my lords, Madam S. Patnaik, my lords.
All right. Counsel for the opposite party number 2 is not present today. In the interest of justice, list before the roster bench on 10th May. Interim order to continue.
Item number 50.
None appears dismissed.
Item 51.
Not press dismissed.
Item
All
not,
these memos you can convert as a release. It's over.
item 52.
52, your lordship, may post it to the same day, 4th July, your lordship.
Or 4.
Lordship, item 42, there was an interim order, your lordship.
Or interim order to come.
Grateful.
Item 53.
May I please, your lordships? My lordship, the application has been filed challenging the order dated 9/2/2016 passed by the special judge CBI Bhubaneswar. My lords, we have prayed for the recall of witnesses PW3 and PW5. My lords, the recall of witness is important because, my lords, these are independent witnesses and they have been examined and before the examination and cross-examination of PW7, who is the IO. My lords, after the examination of the IO, there were some facts that have come to light. So, my lords,
Let's see the impugned order.
My lords, it's at page Annex 4, page 19.
Yes, the present petition is directed against an order dated. There's nothing, madam, because you look at the gap between the examination and cross-examination. PW3 was examined in chief on 30th June 2011, partly cross-examined on the day, then taken up the cross-examination after 3 years on 2/5/2014. Similarly, PW5 examined in February 2013, cross-examination deferred, taken up in November 2014. This is all completely delaying tactics. You say the present petition is directed against an order dated 19/2/2016 passed by the special judge CBI 2 Bhubaneswar, rejecting the plea of the petitioner for recall of PWs 3 and 5 for further cross-examination only because certain facts emerged during the certain issues emerged after the IO was examined. Paragraph. A perusal of the impugned order of the trial court reveals that, let's take from page 18 the factual scenario up to completed. Second paragraph. The facts are telltale. Full stop. The petitioner has obviously availed a full opportunity of cross-examination of PWs 3 and 5. And the request for the recall is clearly with the intent to further delay the trial. The court is therefore not inclined to interfere with the impugned order of the trial court. The interim order is vacated. The petition is dismissed.
Item 54.
None appears dismissed.
Item 55.
May I please, your lordship? Your lordship, earlier occasion directed both the parties appear before the mediation center and the present petitioner appeared and the complainant did not appear. Thereafter, again, the matter came before your lordships and report before your lordships kindly see.
Unsuccessful. Okay, the mediation report has been unsuccessful. List before the roster bench on 27 June.
Interim order continue.
Interim order to continue.
Item 56.
56, your lordship, on behalf of Mr. Lal, I'm praying for a short adjournment. He's on accommodation. He's unwell.
The counsel, the petitioner stated to be unwell. List before the roster bench on 22nd June.
Obliged, your lordship.
Item 57.
May I please, your lordship, my lord? My lord, with your lordship, my lord, I have two grounds, my lord. My lord, one is, my lord, the inception the complaint petitioner stumbles for, my lord, then sanction, my lord. Stumbles for, my lord, on the date of filing of complaint petition, the learned magistrate straightway forwarded the complaint to be registered for FIR, which runs contrary to the dictum of the Honorable Apex Court. Secondly, my lord, the very interestingly, my lord, this present opposite party who is the complainant, he was involved in the criminal case by the present petitioner, IIC of the police station. May I invite your lordship's kind attention to the page, my lord, Page 7 is the complaint petition. Complainant name is mentioned. Then may invite your lordship's kind attention to the page 14, my lord, where, my lord, he has been implicated in the case, my lord. Not page 14, 1-4, my lord. May I invite your lordship's kind attention to page 1-4, my lord.
Yes, yes.
My lord, the column 7 from bottom, my lord, your lordship may find the name of the present opposite party, Prashant Kumar Mishra. He is an accused. He is accused in the PS case number 137 of dated 24/6/15, my lord.
All right. What is this? Custodial violence?
Pardon, my lord?
What is the complaint?
Complaint is that the present opposite party went to the police station. There, my lord, the IIC and the constable manhandled. He was manhandled, but the allegation is, my lord, on the same day, he entered into the police station. He had a word up with the IIC and ransacked the police station, for which this PS case 137 was registered. And to wriggle out of that, regards of that case, my lord, that is the complaint, my lord.
Permitting the petitioner to raise all.
Then, my lord, sanction 197.
That also you can take there.
At the time of trial.
The petitioner to raise all pleas at the appropriate state.
At the time of trial.
All right. Intermodus.
Item 58.
May I please your lordship, my lords? Organization 498 and 506. Opposite party number 2 is the wife. Matter has been amicably settled and both are living separately, having been married life. And there is no chance of conviction, even if the trial is continued. And based on that, I am filing this judgment of this annual court.
You have to file the affidavit of that person, sir.
I have made the parties and the somebody I am not friend as appearing.
Address is absent. Who's appearing?
Mr. Chiraranjan Satpathy is appearing.
Where is he?
May keep it tomorrow.
Opposite party number 2 is not present. Mr.
Chiraranjan Satpathy.
Let's put down that. CR Satpathy is not appearing today. The registry will inform him to remain present on the next day. Telephonically inform him.
Yes, ma'am.
9th May for the roster bench.
Interim order
to continue.
Much obliged.
Item 59.
Please, your lordship. The present petition, it is a peculiar case. Present petition is challenging Annexure 1, the second complaint case, your lordship. In this case, your lordship, petition number 2, so opposite party number 2, has lodged this FIR against 176.
Where is that lawyer? Where is the lawyer for opposite party number 2? Mr. Ajay Dash.
They have not filed
Mr. Ajay Dash is not appearing today. Registry will inform him to remain present for the roster bench on the next day. List on 4th May.
Item 60.
There is interim order.
Interim order to continue.
Item number 60.
None appears dismissed.
Item 61.
Pardon your lordships, item 60 on behalf of Mr. B.B. Rautraj, lordships may kindly take up this matter any day next week. He is ill, your lordships. He insisted me to take an adjournment on his behalf.
Mr. Rautraj stated to be unwell. Interim order to continue. List for the roster bench on 4th May.
Obliged, lordship.
61.
Lord, I pray pardon, Lord. 61 some next week, Lord, any day. It's some checkered history of the case. Did some.
Okay. At the request of counsel for the petitioner. List on 15th May.
Interim order to continue.
All right.
Obliged.
Item 62.
May I please, your lords? My lord, in this case, the petitioner prays for the quashing of the criminal proceeding on the ground that the OP number 2, the present petitioner and OP number 2 have already been married to each other and they have blessed with a child.
Where is that affidavit? You file it before the trial courts permitting the petitioner.
I pray, my lord, one thing. I will file the affidavit. The OP2 will be filed the affidavit, my lord.
Counsel to the petitioner states that affidavit of OP number 2 that she is now married to the petitioner will be filed before the next day. List before the roster bench on 8th May. Interim order to continue.
I pray, my lord, 2 weeks time, my lord.
8th May, sir.
Item 63.
Item 63 on behalf of Mr. Bhuya, I am praying for an adjournment.
What's the reason, sir?
My lord is ill.
All right. Counsel to petitioner state be unwell. List on 8th May. Interim order.
Item 64.
May I please, your lordship? It's a case, my lord, where a passenger train was coming from Bhubaneswar side And due to wrong signal, my lord, dash against a good train, as a result of which there was a loss of 2 lives, my lord, in the good trains. So case was registered under section 304, my lord. It can be under no stretch of imagination, my lord. Death due to rash and negligent act, my lord, can be 304. At best, it would have been 304A. So I have challenged the FIR, my lord, quashing of the FIR. No coercive action was passed against order passed against me. So the state may have instruction, my lord, whether the charge sheet has been filed under section 304A or 304.
Yes.
Mr. Banti takes time.
Just, I have received a letter.
Charge sheet. Under no stretch of imagination, it can be 304, my lord. Because 304 is, my lord, whoever commits culpable homicide not amounting to murder. But here death is due to a rash and negligent act, my lord, attracting the application of section 304A.
In the meantime, substantial investigation has been completed due to non-cooperation of the petitioner. Further investigation could not be progressed. This is the averment made in the petition which we have filed for vacation of the interim order.
That was long ago, sir.
Your lordship may direct that.
The IIC, who's the IIC? Let me file a report.
GRP. We'll file the status report of the case.
The investigating officer of PS case number 131 of 2016 will file a status report on the next by the next date. Interim order to continue list on 3rd May.
65.
65 is file is misplaced, my lord.
Misplaced. Dismissed for non-prosecution with liberty to
I'm for
revive.
informal lordship.
Obliged, my lord.
65, I'm for informal lordship.
All right.
Obliged.
Item 66.
May I please, your lordships. Your lordships have challenged the criminal proceeding. This is a case under section 420, 465, 467, 471, and 468. The case is that, my lords, the informant earlier had applied before the collector Kalahandi for obtaining of an appointment of transportation agent for supplementary nutrition program and emergency feeding program. And your lordships, by swearing an affidavit, he has got the tender call notice and informant has got the agent's license. Later on, your lordships, the informant has been implicated in a case for misappropriation of wheat, 980 quintal of wheat, to save their own color. These present petitioners are strangers being implicated in this case, your lordships. There is absolutely no basis. The petitioners are getting harassed, your lordships. No charge sheet has also been submitted, your lordships, till date. It's been 10 years.
Even happier, sir. No charge sheet has been filed. What are you to worry? Nothing at all.
Lordships,
that's the best news. How many years now? Almost 10 years.
Yes, your lordship.
So best news is that permitting the petitioners to raise all pleas at the appropriate stage, the petition is disposed of. Interim order is vacated. Correct.
Item 67.
May it please, your lordship. Petitioners are government service holders. Have prayed for you also before lordship for quashing of the complaint case, which is absurd one, madam. I am taking to lordship's page 17 of complaint case. One Pavitra Kumar Sahu is the complainant, who is a habitual offender. And kindly see page 18. What is the complaint petition, my lord? Serial number 5, offense committed at serial number 4, date and time of place of occurrence, my lord. On date is 14/1/2017 at about 11 a.m. My lord, kindly see brief of the case, bracket C, that on dated 13/1/2017 at about 11 p.m. night. My lord, it is varies from column 4 to column 6. Factually incorrect. My lord, this petitioner, on the contrary, my lord, he has assaulted the petitioner number 1, who is a government service holder, and he sustained bleeding injuries. 7 stitches were done in the medical. He was admitted for a month in hospital. Petition number 1. Well, I take to your lordships, my lord, kind attention to page 47.
They're ST people, sir. The complainants belong to ST.
Petitioners are also STs.
Very good, very good.
My lord, kindly 47, page 47. On the contrary, my lord, kindly appreciate. The complainant has assaulted the petition number 1. Page 47, I made a grievance commissioner police and IIC, etc.
Satyanarayan Singh,
my lord,
Satyanarayan Singh
is a petitioner and the
son of Gulai Singh.
Gulab Singh. And petitioner 2 is the wife. They are all government servants.
and they are.
No, Satyanarayan Singh is in the scheduled tribe.
Yes.
No,
Yes.
Charge sheet has already been submitted by the FF number 126
You
dated
can
28.
raise all pleas.
Yes.
No,
Permitting the petitioner to raise all pleas.
Kindly page 47. Only thing what they have done. Page 47 they have applied your lordship's manner. To the Commissioner of Police, I'm reading out subject page 47 annex 8, brutally assaulted by my husband by one Pavitra Kumar Sahu, that this complainant, Lakshmipriya Sahu, Lily Naik and 15 others of Gatakono, PS Manchester District Court. Respected sir, with due respect and humble submission, Srimati Lakshmi Singh, age of 48 years, wife of
all this can be examined, sir. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of, the interim order is vacated.
My lord, interim order to continue, my lord, they will, the government servant, they may be arrested at any moment.
No.
Item 68. 68. May I please, Your Lordship? My lord, this is a peculiar case, Your Lordship. Here the dispute is in interstate dispute between the employee and the employer, my lord. Here the employee filed the complaint case against the management, Ayush Hospital management and the executive director, executive officer, that is the petitioner number 2. He therein alleged that the promised amount, the promised salary was not reimbursed in his favor, and this is a money recovery proceeding in the guise of a complaint case. Your Lordship kindly looks at page number 23, my lord, the prayer portion of the complaint case.
Has he been served?
My lord, I'm there. I'm appearing for OP number 2, my lord.
Yes, sir. You are the complainant.
I am the complainant.
What is the money owed to you, sir?
5 lakhs of lordship. Kindly say page 27. I'm a reputed surgeon, my lord. Earlier I was in the army. There subsequent after.
Are you willing to go in for mediation?
Yes, Your Lordship. Page 34, Your Lordship kindly looks at page 34 for a second, my lord. In the agreement for employment, if Your Lordship kindly looks at page 34, points number 8 and 9. Arbitration clause is there, my lord.
Are you willing to go for mediation? Have you understood the question, sir?
Yes, Your Lordship. Your Lordship.
Parties are willing to explore the possibility of settling their disputes through mediation. He'll appear in the mediation center on 19th April at 3:30 p.m. The mediation report. Yes, yes.
Can it miss other date? Because he was earlier, he was in other hospital, so Raigada.
The 24th?
Yes, at 24th April.
I'm obliged. The mediation report be placed on record by the next date.
Obliged.
Interim order to continue. On 4th May.
Item 69.
May I please, my lord? My lord, in this case, I'm appearing for the petitioner. The issue involved here is, my lord, there are 3 cases, my lord. One case has been filed by me for police excesses by the government servants, including the opposite part number 1, at whose behest I was threatened, and thereafter 2 checks were taken from me. And
we'll have done some other day. We say list before the roster bench on 3rd July. Interim order to continue. Right.
Interim order 70. There are 2 connected cases, my lord. There is also interim order in those.
Correct. Same.
In all the cases, my lord. Item 70.
Please, madam. My lord, in this case, the conducting advocate Priyamada Sir is not available in Cuttack, my lord. Any short adjournment, my lord.
At the request of counsel for the petitioner. Please don't. With the roster bench on 9th May. Interim order to continue.
Obliged.
Item 71.
Lord, 71 state is the petitioner. I pray that this may be listed before the roster bench.
All right. Same order. Roster bench on 16th May. Interim order to continue.
Item 72.
May I please, sir? Consider having a BC matter. In this case, my lord, petitioner has challenged the order dated 14th March 2016, passed by learned STJ Bhubaneswar in city case number 569 of 2015. My lord, taking the cognizance against the petitioner. My lord, in this regards, my lord, kindly have a glance to the FAR, which is page number 10. My lord, said that today in the morning, if lordship may permit, I may read the FAR. Today in the morning around 10 a.m. when my husband left for his office and came out in garage to put my clothes for drying, suddenly my father-in-law, Mr. Nathu Saha, and mother-in-law, Mrs. Urmila Devi, attacked me from left and right from my clothes which I was wearing and and beaten with a strong stick, causing some marks on the body of the several parts. My lord, in this affair, that lordship will go through the story of the affair. Then now, nowhere in the affair has reflected whether any torture has been caused to the complainant prior to this alleged incident.
All
My
right.
lord, yes, ma'am.
No, you can take all these pleas at the appropriate stage. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of the interim order. Yes.
Item 73.
73, my lords, arises out of a matrimonial dispute. There are three cases, 125, divorce, and this is under the DVI. So, my lords, may I suggest that if the parties can explore mediation?
Who's for the other side?
Mr. Sharma, I don't think
My lord, it's a case where a preliminary issue was sought to be raised on the ground of limitation. The domestic violence case is barred by limitation.
He's proposing mediation. Are you agreeable?
Let them explore. Three matters would be closed. Otherwise, I'll come back to your lordships.
To enable the parties to take instructions on whether the respective clients will go in for mediation. List on 11th April.
Interim order may continue.
Interim order.
Item 74.
May it please, Your Honor. My lord, I have filed a detailed dead chart and it's all citations. The case is, my lord, cognizance under section.
We'll have it in some other days. List on 11th May before the roster bench. Interim order to continue.
75.
May read your.
Again, the same thing. We'll have it on some other.
I am for the opposite one.
On list on 27 June. Interim order to continue.
Item 76.
May I please, your lordship? I hear the question, Ajay, under section 15 of the EP Act, a cognizance has been taken against the petitioner on the ground that the petitioner company has not arranged an accused. In meantime, the batch of cases heard by Justice Shashikant Mishra, the entire proceeding has been quashed. The batch of cases on 6th February 2023, the company petitioner is the CMD, the chairman cum managing director of the company. And the company has not be arranged and accused.
So this is all that Anita had.
Yes, yes, my lord. Deep level. Your lordship.
All right.
Your lordship has also passed certain
Yes, in view of the judgment dated 16 February 2023 of the learned single judge in CRLMP 317 of 2014 and batch, take the prayer clause and all proceedings consequent thereto hereby quashed. All right.
Deep level, right.
Item 77.
Liberty may be granted to write the all bonded during.
All right. Permitting the petition.
Item 78.
May I please, my lord? My lord, in this present CRLMC, I am challenging the order dated 16/11/2017, that is under Annexure 5, page 28, your lordship. It is a proceeding under section 138 of the NI Act, initiated by the complainant. There is an outstanding.
Who's for the other side? No one. Someone appearing or not?
Yes, your lordship. Mr. Subodh Mahanti is appearing.
All right. The court will directly inform Mr. Subodh Mahanti appearing for the opposite party number 2, opposite party to remain present on the next date. 28th June, interim order to continue.
Obliged.
Item note 79.
But please, my lord. My lords, I'm appearing on behalf of Mr. Debashish Panda. My lords, he's on his legs at the moment.
All right. At the request of Mr. Panda, list on 22nd June, interim order to continue.
Deeply obliged, my lords.
Item number 80.
In item 80, may I please, your lordship, I pray for deferment of this case because this arises out of a complaint case and a matrimonial dispute. There is already a decree of divorce which is pending in the shape of appeal and judgment is awaited. May I pray this may be deferred?
At the request of Mr. Mishra, list on 5th July, interim order to continue.
Obliged.